Good morning. Good morning.
Good morning.
There you go. All right. I'm the chair of the United States Sentencing Commission, Carlton W. Reeves, and I welcome you all to this hearing. I thank each of you for joining us, whether you're in this room or attending us or attending via live stream. I have the honor of opening this hearing with my fellow commissioners. To my left, we have Vice Chair Claire Murray, and to her left, Vice Chair Laura Mate. And to Vice Chair Laura Mate's left is our ex officio commissioner representing the Department of Justice, Scott Meisler. To my right is Vice Chair Louis Felipe Restrepo and Commissioner Wong. Thank you for being here with us today. I'll take this point for point of personal privilege. I got the news this morning that Reverend Jesse Jackson died. He was one who spoke out about racial injustice, criminal justice reforms. So I don't think I, as chair of this commission, where there's a straight through line from his run and for his land, for others laying the foundation for me. He always referred to my homegirl, Fannie Lou Hamer, my homeboy, Medgar Evers, in his run and all the things that he did. There's also one very personal connection. In 1984, when he was running for president, he came to Jackson State University, where I was attending. That happened to be the first date that I had with my bride. We were out attending his speech, and we left there because we were encouraged to move our registration from Yazoo City, Mississippi to Jackson State, where we could have the most impact, he told us. And we marched from Jackson State University to the Hinds County Circuit Clerk's office and went to register to vote. That was our first date. And from there, because the hours of standing in line, waiting to vote, by the time I got back at Jackson State, the cafeteria had closed. So her sister, with whom she was living with, said, "Why don't you invite him over for dinner?" And I had dinner with her and her family. And for the next nearly 40 years, we were almost 40 years. We were all together. But so he brings all those things full circle. And I think of Jesse Jackson in that way. Of course, we all think about him, keep hope alive, and all of those things. So I just wanted to take that point of personal privilege, and thank you for indulging me. Our agenda today reflects the dedicated work of our commissioners. We have been busy, and I want to thank each of them for their dedication and extensive contributions. I'm always honored to be among this group. Of course, though, no matter how dedicated and busy we are, it pales in comparison to the awesome public servants throughout this agency who always make the impossible seem easy. Some of them are in this room, but of course, most of them are not. They have done the research. They have coded every pre-sentence report, every judgment, and every commitment order, every statement of reason. They have drafted the policies. They have set up this room, and they have done so much else to make this hearing possible. On behalf of the commissioners, ladies and gentlemen, and the public, I thank all of our agency staff for the amazing work you do every single day. The Commission has issued proposed amendments on drug offenses, economic crimes, sophisticated means, and post-offense rehabilitation. We have received many comments on each subject, and we are so grateful to everyone who has taken the time to share with us your perspectives and insights on ways we can improve our system of justice. Today, we will hear from individuals to help us determine whether and how sentencing guidelines should be amended. Each witness has different views on these subjects and specifics of sentencing policy. The commissioners, too, have different views. Today, though, we are here to listen and ask questions. The comments we received are posted on our website, www.ussc.gov. You can also find the videos and transcripts of the hearings we conducted on these amendments, and I encourage the public to read these comments and watch our prior hearings. Today, the comments we have already received will be buttressed by testimony from a distinguished group of individuals whose more complete biographical information is included on our website. To all who are speaking with us today, I promise that your extensive journeys and preparations will be worth it. When you speak to the commission, you will be heard and you will be read too. We have read your written submissions and your testimony will be available for the public to access on our website. If some things come up today that you would like to elaborate or respond to, please do so. Each panelist, except for our very first one, will have 5 minutes to speak. Your time will begin when the light turns green. You have 1 minute left when it turns yellow, and no time left when it turns red. I hope I got that right. Thank you. But if, ladies and gentlemen, please, come on, bear with me. If I cut you off, please understand I'm not being rude, because a guy from Mississippi just can't be rude. So, but if I cut you off, I'm not being rude. We have so much to cover today, and a limited time to hear from everyone. For our audio system to work, you'll need to speak closely into the microphones. When all panelists have finished speaking, commissioners may ask you questions. I am certain we will. Thank you for joining us. I look forward to a very productive hearing. That takes us to our first panel. I'd like to introduce who will offer the perspectives of the Criminal Law Committee of the Judicial Conference of the United States on all 4 subjects. My good friend and the chair of the Criminal Law Committee, Judge Chang, who will present that testimony. In his other job, Judge Chang serves as a district judge of the Northern District of Illinois. Judge Chang, please, sir, we are ready when you are.
All right. Good morning, Chair Reeves, and thank you for sharing those profound remarks on the Reverend Jackson. I had not heard the news, and he, of course, leaves enormous footprints nationally, globally, and particularly in Chicago with his Rainbow Push organization. Thank you for those profound remarks. Greetings to all of the commissioners. Happy Lunar New Year. It is the year of the horse, which represents vigor and action, and that certainly describes this commission. It is as always a true privilege to speak with you all here today, and it's an absolute pleasure to continue working with all of you on sentencing policy, and to work with your expert staff, you have a staff that is, of course, populated with sentencing policy experts, and the nation is much better off for that. And Chair Reeves, for all the commission has done in just a little over 3 years, it is hard to believe that it's just been that amount of time since the commission was reconstituted under your strong leadership. As always, the Criminal Law Committee tries to apply the principles that the Judicial Conference has set forth for our committee, and that is that the guidelines ought to be fair, transparent, workable, predictable, and flexible. And of course, my comments don't reflect the views of the Administrative Office Director or all 1,000 or so federal judges across the nation, but this is our deliberative consensus from our committee's perspective. Today, I'll focus my testimony on really three things. One is the methamphetamine proposed amendments, and then the loss table, including the inflationary adjustments, just a brief note on that, and then the restructuring of the loss table, and then lastly, post-offense rehabilitation. On methamphetamine, the committee does support, generally speaking, treating meth offenses equally across the board. The Commission's data does show that current methamphetamine purity levels are uniformly high, no matter the form of methamphetamine, more than 90%. And as a practical and really deeply tragic matter, that is the reality of methamphetamine trafficking at this point, that it is almost always in a very high purity form. And this is an example of intense capitalism working in an illegal market, and supply and demand have converged in this way so that meth is at this tragically high purity. So the time when purity of methamphetamine was an accurate proxy for role culpability, that is to say, the higher the purity, the higher up you are in the supply chain, I think those days have come and gone. And we see that the high purity at the very, very retail level. The Commission has also focused everyone's attention, I think quite appropriately, on the geographic disparities in the availability of laboratory testing, or even if available, the practices of sending samples to get tested among the various districts. And so sentencings that do not involve a purity calculation with meth actual ends up being a result not of differences in purity in meth trafficking, but in differences of laboratory testing across the nation. Not surprisingly, courts have thus reacted in various ways, and the data shows that fewer than one third of defendants in methamphetamine cases are being sentenced within the range. So the committee does support treating methamphetamine across the board the same. Having said that, the committee does oppose what was labeled as option 2 in the proposed amendments. And that is to say, the option in which there would be different base offense levels based on different factors, and a very long list of different factors to consider. Now, some of those factors are cross-references. So in theory, we would have thought about those cross-references in any event. Having said that, some of them are not. And for example, one of the ways to mitigate the offense level is this kind of new proposed specific offense characteristic that is a blend of aberrant behavior and more than minimal planning. And so these would be new factors that would get litigated, and the courts would have to come up with definitions and so on. And so I think that is an overly complicated way of approaching the need for change here. Having said that, the committee at this time does not have a recommendation on where exactly the quantity threshold should be set for methamphetamine. And instead, we encourage the Commission to conduct a study of the relative risks of addiction and other harms that are posed by this very highly pure methamphetamine that is now being trafficked. As the Sentencing Commission's materials explain, put together by that terrific staff of yours, the meth mixture purity used to be something south of 50%, right? And now we are north of 90%. So on the one hand, the purity no longer reflects role culpability. Right? So it's not the case that you are necessarily high up on the supply chain if there is a high purity of meth that's trafficked. But at the same time, bringing down meth actual sentencing down to where meth mixture is also is not necessarily appropriate given the purity of methamphetamine and the additional effects of the highly pure methamphetamine. And I'll just make a quick note that, because I think this has been interpreted maybe slightly differently by different groups, that the testimony that you all heard on methamphetamine, I believe it was in August of last year. The way I read that testimony, both from the DEA pharmacologist as well, and then the social worker who testified, and also the San Antonio Police Department sergeant, all of them did seem to opine that the higher the purity, right, the greater the stimulant effect, right, which leads to a greater addictive effect. I suppose the testimony is subject to interpretation, but that's how I interpret it. The more active ingredient, the more the stimulant effect. So at this point, the committee's recommendation is to study the relative harms of methamphetamine as compared to other drugs, as you are trying to figure out where do you land on the quantity thresholds. It is worth, I think, comparing it to making a comprehensive examination of the various forms, the most commonly distributed forms of controlled substances, so that you can then pick the right the quantity threshold. I mean, just give you an example, as the fact sheet points out, the commission's fact sheet points out that fentanyl is involved in 80% of overdoses that occur each year, and whereas methamphetamine is it's hard to put the word only in front of overdose, but relatively speaking, 1% of overdoses, and yet it takes 400 grams of fentanyl to reach offense level 30, and it only takes 50 grams of meth actual to get there, and so they're recognizing that fentanyl does have this graver risk to the population. It might not be appropriate to set it at that level. At the same time, again, studying those relative effects is, I think, crucial to making that decision on where to set the threshold. I understand that the commission might want to act before doing something like this, if you even take up this suggestion, because the sentencing is not reflecting the reality of methamphetamine distribution now, and this is something you've been studying for years, and so this has been on the table, for a while, and so it may be appropriate to do some adjustment in the interim, and then come back and examine this again. That's, of course, not necessarily going to satisfy everyone, but we believe it does represent the most deliberative approach to this particular issue. So those are my remarks on methamphetamine. So I should pause here before moving on to the next topic if there are questions, and I'd be happy to answer them.
Thanks so much, Judge Chang. We always enjoy having you with us. Do you have kind of specific thoughts on how we can get to those questions of relative harms? I mean, we were trying to do that. I think in our August, September roundtable on meth, we talked to experts about pharmacological effects and about harms in communities. Are there like specific pieces of that puzzle you think we're missing?
Well, and it may be that you have most of the data. It's just surfacing it and then actually making that comparison. I think the testimony, the oral testimony, I'll confess I had not looked deeply into the written testimony, was much more speaking relative-wise rather than empirical-wise, like getting to that real concrete data like the fact sheet did a few weeks ago on the comparison of overdoses and what is the drug that is causing the greatest harm there. So it may very well be that you have those answers and it's just a matter of surfing them into like concrete empirical data because certainly the witnesses did speak about cocaine and heroin compared to methamphetamine, but I don't think in a way that would let you really pick the quantity threshold, at least not quite yet.
Judge Restrepo.
Judge, it's good to see you.
Good to see you.
You commented that fewer than a third of defendants or cases are sentenced within the guideline range. So I'm assuming you mean a good number, maybe close to 2/3 are underneath the guideline range. What should we make of that? Should we interpret that as judges thinking across the board that the meth guidelines are too punitive, that they overrepresent harm? And should we factor in what's happening on the ground in our calculation?
Well, I do think you ought to factor in what is happening on the ground in making a choice to move forward with an amendment. I would be hesitant to say that it's an across-the-board judgment at this point, because there are still 1/3 that are within the range. But having said that, I do think that reflects a dissatisfaction, generally speaking, with how punitive the guidelines are. At the same time, it's not quite, and I haven't done this specific comparison yet, but we certainly saw with crack cocaine, the variances that were happening in that context when there was not a mandatory minimum involved. And I would wager that the discrepancy is not as significant in meth sentencing at this point. So while the 2/3 are below the range, their position relative to that minimum range number, it's not likely as steep as it was with crack cocaine, so that would be worth studying. So I don't think it tells you the actual, the precise quantity threshold to pick. But I do think it speaks to the fact that many judges are looking at the current guidelines that they are too severe.
So as a policy matter, do you think as a policy matter, do you think we should factor into the equation what judges are actually doing when we're trying to come to terms with this very difficult issue?
I do. I think you all have a general philosophy on when is it appropriate to both issue a guideline and to amend a guideline, and I think different judges have different thoughts on that too. And sometimes it is to adjust the guidelines to match what judges are doing and doing in the field, so long as what the judges are doing in the field reflects sound sentencing policy. It might be that the commission disagrees with what judges are doing. So that is a common rationale for amending a guideline, is to reflect what our judges actually doing. And it may be the import of your question is if the idea is that you want to take some interim step, before conducting a wider inquiry and a wider examination of the drug guidelines generally, that where judges are sentencing, might be an interim step.
Vice Chair May.
Good morning. Thank you so much for joining us. As always, it's very helpful to hear from you. Following up on this, kind of looking to what courts are doing to, as evidence of maybe what we should be doing. You talked about sort of policy disagreements and the sentences that are within the range and the percentage that are below. With those policy disagreements, or are you aware of any upward movement from mixed, like if a court's dealing with a mixture case, have you seen any where folks have said this, like I'm going up or is it all kind of been from that actual down, or?
I'm not personally aware that judges have varied upwards from meth mixture to meth actual, and I believe the data showed that it's across the board. Even in meth mixture cases, that the sentences are the majority are below the range, so while there might be like sporadic one-offs, here and there, I think generally speaking, the data shows it's under the range.
Any additional questions on that particular topic?
Yeah, if not, then I'll move on. Thank you, Chair Reeves. On the inflationary adjustment, just a brief comment on this. It has been a decade, I guess now over a decade, since the last time the Commission has adjusted the tables for inflation. And the committee does support that given how much time has passed, there were years of significant inflation, that it is time to adjust the tables again for inflation. I mean, 2015, we were on iPhone 5 is one way to think about it, and the Patriots actually beat the Seahawks in the Super Bowl. So we have moved on at this point, and so we do think that it is time for the inflationary increases to happen again. One of the issues for comment was whether the Commission ought to just have some kind of automatic period of time where there is an increase in the tables to account for inflation. And the committee would urge the Commission to not constrain itself on this and to simply decide when the time is right to make those inflationary adjustments. There could be, heaven hoping that years of very low inflation, and so that you would not have really a benefit of adjusting the tables, but then you add the complication of the tables having changed and figuring out when offense conduct ended and so on to pick the right table. And it is also, I think, possible that there may be instances where there is an increase in inflation over the years, but there might also be an increase in economic crimes, and it might not be appropriate to water down those tables in that time period. And so rather than constrain yourself, we would urge you to just retain that discretion to bring this up when it is appropriate, as it is now. On restructuring the loss table, unless there are any questions on that inflationary adjustment comment, on restructuring the loss tables, the Criminal Law Committee is typically all for simplification and alleviating fact-finding burdens on courts and by extension on our probation officers. And it's true that there are some guidelines loss calculations that are extraordinarily complex, and that a reasonable estimate of loss that falls within a wider band might actually make things easier. And I'm certainly thinking of several securities fraud cases I've had where that was a complex, certainly a complex task, and I wish the table had been from $0 to $50 million. But that is a relatively rare, at least in the committee's experience, it's a relatively rare issue. And so our concern is that if the purpose of this proposed change in the loss table is to alleviate fact finding and to simplify, that advantage actually won't be realized. And in part because we do make more specific loss findings for restitution purposes. Right? Like it may not be every case where the guidelines loss definition matches restitution, obviously, and intended loss being one of them, but we do often have to make that restitution calculation because it's mandatory restitution. So it's not quite good enough to just say, well, it falls within this very, very broad range, and now we're done with that. We need to figure it out for restitution. Also, although it's true that minor differences in loss amounts might not make a material 3553A difference, the loss amount still does represent, I believe, to most judges, a very important consideration of the nature and circumstances of the offense and the seriousness of the offense. And so the restructured loss tables would really minimize those nuances, including, as an example, a $260,000 loss would be treated the same as a $1.4 million loss. It would be within the same band. And so we think it's unsound policy to widen the bands by that kind of extent. And relatedly, the concern is that, especially at the lower tiers of the table as well, we would see a dampening of the importance of loss amount. The Commission's data show that had this amendment been in effect in FY24, 46% of the cases sentenced under 2B1.1 would have received a 2-level reduction, which is a substantial change in the offense level. So bringing the 16 bands down to 8 would eliminate these, we think, important distinctions in loss. And of course, loss doesn't control the sentencing, but it is an important factor and would be watered down by this change in the loss table. So I'll pause here if there are any questions on the restructuring question.
Thank you. Thank you.
Thanks for being here. I'm just curious if the committee considered the interaction between the inflationary adjustment and the loss table. So obviously you support inflationary adjustment. I've opposed the adjustment of the loss bands. But in your deliberations, did you consider how the two interact? Like okay.
Right. Yeah. No, we decided to just keep that separate. In part because we're not sure which, if either, the commission would go forward with, and so we did not blend the two.
Hi, Judge.
Hi.
You hit on one of the aspects of balancing and weighing that we frequently encounter in different contexts, which is balancing sort of the need or the value add of providing some additional structure and guidance versus simplification. And sometimes there is some tension between where to strike the right balance. And I'm just curious if you have some more general thoughts on how to weigh those two different things, and when the marginal loss of guidance is more detrimental than in other situations.
Yeah, I mean, these are the philosophical questions. If there were a guideline, it would be like whatever the letter before A there would be 1.1, which is so. I think of the guidelines as being most helpful with concrete facts. Right? When there's a concrete fact that ought to differentiate a crime from its base, the way it's committed in its basic form. But concrete facts in particular, like possession of a weapon or a drug quantity, a loss amount, and so on. So the more concrete the fact is, the more simple it is for judges to apply, and that gives it the structure that judges would seek from expert sentencing policy bodies like the commission. So concrete facts. And so, as an example, post-offense rehabilitation, that is not so much a concrete fact. Right? Like that is a more kind of general standard. And so I conceive of 3553A as typically taking care of like the issues that are less concrete. Right? It's not as concrete about either the person, the defendant, or the offense. And so I think at its ideal form, the guidelines are giving us the guidance and structure on concrete facts. So that's the general philosophy.
Judge, has the committee given any thought to other ways to measure culpability besides loss? Are there other considerations we should be looking at in terms of measuring culpability other than just loss?
I think what the commission has done appropriately, and arguably given the potential reduction in specific offense characteristics, but that's what specific offense characteristics do in terms of both aggravation and mitigation, and that's what minor role does, right? And that's what vulnerable victim does, and so But when it comes to the crimes covered by 2B1.1, I think loss does make intuitive and concrete sense that is reflective of the seriousness of the offense. Not dispositive, most certainly not dispositive, given all the aggravation and mitigation. But it is our starting point. All right, then with your leave, Chair Reeves, I'll move on to the last topic, which is post-offense rehabilitation. And so here, I think it's probably a universal truth that judges support the idea that when a person engages in post-offense rehabilitation, that we ought to take that into account as substantial mitigation under 3553. And indeed, our pretrial services office, which the Criminal Law Committee works with, all of the offices across the country are dedicated to assisting those who are accused in starting that rehabilitation process, respecting the presumption of innocence, to be sure, but at the same time assisting in mental health counseling, employment efforts, right? and so on, reconnecting with family, all of those things that are a first step to rehabilitation. So we recognize the importance of post-offense rehabilitation. At the same time, in the committee's overall experience, Section 3553A is where this should be located. That judges do vary from the guidelines and take into account that kind of rehabilitation without the need for a formal guideline on this. The committee instead would prefer that the commission instead create an application note, right, that would encourage judges to vary based on atypical post-offense rehabilitation. And that would serve the purpose of incentivizing defendants to begin the rehabilitative process. It would allow defense lawyers to tell their clients, like, here, look, this is going to be relevant at sentencing. You've got to attend these programs. You've got to try to find a job and go to job training and so on. And so it would provide that kind of concrete information to allow there to be that incentive. Adding an actual formal guideline on this I would increase the fact-finding burden, would complicate the guidelines, because then the rehabilitation mitigation would be anchored to some kind of guideline text, right? And because there's guideline text, it's got to be interpreted, it's got to be defined, and then and litigated over, rather than the discretion under 3553. And that's especially a vice of option one, where there are these 11 factors, and then the factors, those factors, the text will be defined and will be through case law and litigation and so on. And so this would, I think, complicate sentencing on this particular issue. If you are going to pass an amendment on this, then at least option two is a bit more straightforward and workable, but again, it would be formal guideline text, and all the litigation would ensue from that. So we believe that an application note would be the middle ground, and in that way, we encourage post-offense rehabilitation as mitigation, but not create these extra burdens. And I will say that I think as a judge who takes into account post-offense rehabilitation, quite significantly, I would have some concern that if there were a formal guideline on this, then judges would be kind of locked into the 1, 2, 3, or 4, however many levels, and not exercise really the fuller discretion that we have under 3553. So that's our suggestion as an application.
I have a question about that central point. Do you believe that anchoring if we were to do a guideline amendment or something, anchoring to one of those would cause judges themselves to anchor the discretion that they have? Or is there a way that we could explain to judges that, this may be the floor of what you can do, and considering all of your options, you obviously should look to the 3553A factors and everything about take in your full discretion to do what's needed. Is there a balance in there somewhere? Because you did mention an application note.
Yeah, and there's, I think there's just a risk. I mean, it is hard to predict, and certainly whether it's an amendment or an application note that then says, and we're not trying to constrain your 3553, authority that would be helpful as well. But there, in those districts, in my district, the majority of the sentences are no longer within the guidelines, and even without 5Ks, it's just we're at 50% downward variances, setting aside 5Ks, and so. But in those districts, where there is still more of this anchoring effect of the guidelines, I would have the concern that no matter what you say, that if there's an actual guideline on this, that judges would not go further with under 3553.
Can I follow up on what you just said? You said 50% of your sentencing is in that, I assume, across the board, drugs, fraud, or whatever. Could you explain how that might be? Is it that what we have here, at least for the Northern District of Illinois, is too high across the board? Is that?
Yeah, I don't know. I mean, and it's not a topic, we discuss as a court as a whole. I mean, I just tell you from my perspective that I take seriously the Supreme Court's admonition that even at the district court level, the guidelines they're like a chronological starting point. They are very important. It's important advice. It's not even necessarily the correct starting point of the sentence, though, right? And so even the word variance is it's a little bit of a misnomer, right? Because the guidelines, they represent advice, and that's what they are. So it's not necessarily the case that the guidelines are from a punitive standpoint, too high across the board, as I think you were asking. It might also be, and I put might in there because I am speculating now. It might be also that the 3553 has all the other factors and discretion in there, and that we are exercising our discretion on less of these concrete facts like guns, drug quantity, number of guns, and so on. And more on this person's personal history and characteristics, their post-offense rehabilitation. So that's my speculation.
Yes, Commissioner Wong.
Judge Chang, you, as a judge who takes into account at sentencing post-offense rehabilitation, do you find that information is available to you either generally through counsel's argument or the PSR, or is that something you find you have to affirmatively inquire into?
Oh, it's there. Yeah. I mean, actually the starting point really is the pre-sentence report, which our probation officers do a terrific job with, even the resource constraints they have in laying out what has the defendant been doing on pretrial release. And we have considered whether we ought to just make that even more informative. But at least the PSRs that I see are very informative on, here are the classes the defendant is taking, the counseling, how he's been doing on release, and then of course the defense lawyers add to that. They rely on that argument, and then they add to that. And I do demand evidence of it if they say that that they have been working, that we need to verify the employment, and they go into counseling sessions. Like, have we called the provider? But I think we do have that information. That does remind me. I should note that whether it's a formal guideline or an application note or some other variation, that the idea of requiring 100% compliance of all release conditions or all the custodial institution rules, in the committee's view, that is too constraining. I think many judges, I certainly have had many cases where a person on release misses curfew by 15 minutes, right? And maybe doesn't have a really good reason. It wasn't, a commuting issue or something, but they just missed it by 15 minutes. But then they do all this other extraordinary rehabilitation. It would not make sense to disqualify that person from receiving that kind of mitigation effect.
Judge Restrepo.
Your comments have been focused on folks that are on release. What about individuals that are in custody? Would this create a disparity in terms of how somebody in custody could demonstrate rehabilitation as opposed to somebody that's on pretrial release?
Yeah, and so a couple points on that. First, it does point out the importance of pretrial release, successful pretrial release, and so the committee is and focus on its efforts in trying to promote successful release across the districts as a whole. There may very well be disparity because, of course, there are different opportunities. I would say on this disparity point that that really does is point out the importance of pretrial release. It shouldn't be a reason to not encourage, hopefully by an application note, not by amendment, but to not encourage some additional mitigation for post-offense rehabilitation because there's a difference in access. That does mean that we ought to promote as we do. We asked the Bureau of Prisons and the Marshal Service about what's available in the detention centers. And it's always made more difficult because so many defendants are housed in county jails, and they're not, their county defendants are there for short term. They're not there for the long term. So there is that gap, but it's not a reason to not give mitigation to someone who's on pretrial release and has been successful. And it does make sense to take into account the relative access. And so I certainly have defendants whom I've sentenced who have done all they can in custody, and then I take that into account as very serious mitigation.
Yes.
Thinking through this idea of an application note, I wonder if it sticks our nose into your business, by which I mean, we've kind of historically seen our lane as we set the guidelines and then your lane as 3553. I remember when we were thinking through getting rid of departures, there was this question of should we make all the departures just kind of hortatory as a, something that we should tell judges they should think about for 3553. And then the decision was like, no, that's not really our business. Like we shouldn't be sticking our noses into 3553. Do you have any concern? That seems like an equity of the CLCs. Do you have concerns about that? It almost sounds like what you want and maybe would be good policy is a departure. Now, obviously, we aren't in a departure world anymore, but anyway.
Yeah, that's a great question because I think we typically do look askance at blending the guidelines with just 3553 in general. Having said that, in this particular instance, there were some members of the committee who were of the view that there's insufficient attention to post-offense rehabilitation, and in particular atypical post-offense rehabilitation, and that if the commission were to state, that we believe this is sound sentencing policy, that as the experts, that would weigh heavily in for those judges who are, maybe more hesitant right now. And so while I wouldn't promote open season on this idea, I think this is one of those instances where it would work.
Any other? I'll ask another question then. In talking about post-offense rehabilitation, I think you used the word extraordinary in describing what a person might do. I guess what would be ordinary or what reaches to the level of extraordinary in your view with respect to the things that judges ought to consider vis-a-vis the things that would not rise to the level of extraordinary post-offense rehabilitation?
Yeah, I think my response to this is that this is another reason why it should be 3553 because it's so dependent on the particular person. For some persons who have been, for example, addicted and participated in a drug crime, and that was their motive, and for them to just stay clean is a huge step forward in that person's life. And you can compare that to then, all right, before their addiction, and we see this all too often. Someone has no criminal history. They've been a productive member of society. They're connected with family. They have employment, and then they get addicted and turn to the drug trade. And so you have a sense in those cases where if that person just stays clean, that they're more likely to return to that life. And so it is just the circumstances are just so varied. But I'm sure you've seen defendants like this too. On the first day when they come in for their initial appearance, just how they look and how they're acting, because they're still coming down from a high. And then a year and a half later at sentencing, they've just turned it around, on that. And so I think it is. This is just another reason why it ought to be under 3553. It's very hard to define.
Okay. Mm-hmm.
This is bringing you to one of the areas in your letter that you didn't make in your oral remarks, so I apologize. That there's this note in your discussion of the fentanyl, the proposed fentanyl SOCs, which it seems like the CLC supports, that you think in future cycles we should look at whether some of them should be applied to other drug types as well, like not just fentanyl. And are you thinking of distribution to a minor and use of the dark web? Are those the two that were
right? Because the other ones wouldn't.
The other ones are more fentanyl.
Yeah, they don't apply. But those two, I recently had a heroin case, which tragically there was fentanyl laced into it. But it was a heroin case on the dark web, and I thought it was particularly egregious that they were using that mode of distribution. Those were the two.
Judge Chang, boy, you got us started off on the right foot. We're getting through with you a little bit early.
Yeah, well, I appreciate you taking the time. Thank you.
Thank you so much, man. We're prepared for our second panel. Our second panel provides us with the perspective of our stakeholders and the proposed amendment on drug offenses. First, we have Vincent T. Lombardi, Supervisory Assistant United States Attorney and Lead Task Force Attorney for the Western District of Washington. Mr. Lombardi has been an AUSA in that office for at least 22 years. Second, we have Caitlin Sani, who is an acting chief of the Narcotic and Dangerous Drug Unit, NDDU, of the DOJ Criminal Division's Money Laundering, Narcotics and Forfeiture Section, where she oversees a portfolio of international narcotics, trafficking cases, and related firearm and financial crimes. Third is Natasha Perdue-Salas, the Executive Director of the Federal Defender Program for the Northern District of Georgia, where she has represented indigent persons accused of federal crimes for more than 30 years. Rounding out this panel is Patricia Richmond, an assistant federal defender in the District of Maryland. Prior to assuming this role, Ms. Richmond was National Sentencing Resource Counsel for the Federal Public and Community Defenders. Mr. Lombardi, we're ready when you are, sir.
All right. Chair Reeves, honorable members of the commission, thank you for the chance to present the department's views on the proposed amendments addressing methamphetamine sentencing. As Judge Reeves noted, I've been in AUSA for more than 20 years, and during my career, I've seen the methamphetamine threat change and unfortunately grow. When I was a new AUSA, I prosecuted individuals making small amounts of not very pure meth in makeshift labs in my district. Now I supervise investigations and prosecutions of transnational criminal organizations making and moving hundreds of pounds of very, very pure methamphetamine into the United States from abroad. The department recognizes that the methamphetamine threat has changed, and we understand that the commission wants to ensure the guidelines reflect those changes. We nonetheless believe that the commission's current proposals are likely unworkable because they fail to reflect congressional policy decisions and directives, and in particular the statutory mandatory minimums. That will in some cases divorce the guidelines from those mandatory minimum penalties, which could give rise to unwarranted and unjustified sentencing disparities. You know, it's easy to forget, given our current and justified concern with fentanyl, just how dangerous methamphetamine is. As noted in commission materials, overdose deaths from methamphetamine and other stimulants did increase dramatically over the last 10 years. But equally important, methamphetamine abuse has powerful adverse effects on the physical and psychological well-being of the folks who use it. That danger is what caused Congress to, over time, regularly increase the statutory penalties for methamphetamine trafficking and often to direct the commission to do the same. That danger is still present, and Congress has not rolled back any of those penalties. Until it does, we believe that the current amendment proposals are problematic. I want to touch briefly on the issues we see with the three parts of the proposed amendments. First, the proposal to equalize methamphetamine at a single base offense level with different options as to what that would be. Second, option 2, which proposes to set the base offense level based on the absence or presence of certain factors. And last, the proposal to add a specific offense characteristic to address the ICE issue. As to option 1, Congress set the current mandatory minimums for mixture and actual. Now, since almost all methamphetamine is highly pure, equalizing at the actual level, which is one of the proposals, would not, in most cases, significantly divorce the guidelines from the mandatory minimums, at least where the methamphetamine has been tested for purity. But that's obviously going to result, as noted in your data briefing, in some guideline sentences going up, which the commission may wish to avoid. However, equalizing methamphetamine base offense levels to correspond with crack cocaine, fentanyl, meth mixture, or even powder cocaine, as has been proposed, would divorce the guidelines from the mandatory minimums and basically untether the two. There are specific reasons not to pick these other levels as well. As to fentanyl, I think many believe the current fentanyl base offense levels are too low for fentanyl, and that's been noted by some other comments. Crack cocaine is also a poor substitute. While the two were originally set at the same, if you look at how crack cocaine is made and trafficked, it's pretty much the same as it always has been. Methamphetamine is dramatically different than what it used to be, and we can talk about that further. But more important, Congress changed the mandatory minimums for crack cocaine. They have not changed the mandatory minimums for methamphetamine, at least not yet. So at any level other than actual, you're going to get these cliffs as set forth in our written materials, and that's going to present problems for folks caught with drugs around the methamphetamine mandatory minimums. And you'll get defendants who are otherwise dissimilar just end up getting the same mandatory minimum sentence. Talk briefly about option 2. It's a creative attempt to attack the problem, but we agree with every other stakeholder that it is simply too complicated and will be impractical to administer. I last want to talk about the ICE special offense characteristic. Again, Congress directed the commission to punish crystalline smokable methamphetamine more harshly. And we understand the Commission's concerns with administering that directive. But there's not a straightforward way to reduce it unless Congress takes it back. What is, non-crystalline, non-smokable methamphetamine isn't always going to be obvious, and it's going to result in some odd results if it's implemented. And the one I think of the most is liquid meth. As you've heard in other hearings, methamphetamine is often smuggled into the United States in liquid form. That liquid can be highly pure. And the goal is to convert it into crystalline smokable meth. That's what the users want. That's the end product. If you catch someone with highly pure liquid meth and the plan is to convert it into crystal, it's not obvious why they should get a break under the guidelines because of the fortuity of when they're caught. You're also seeing methamphetamine converted into tablets. That can be very dangerous because it looks like a prescription drug like Adderall. And again, that can be snorted, it can be inhaled. So just implementing it is going to be problematic as a factual matter. Thanks for the chance to address you. I look forward to talking to you about these issues further.
Thank you, Mr. Lombardi. Ms. Sadi?
Chair Reeves, honorable members of the Commission, thank you for the opportunity to discuss the Department's views on the Commission's proposed amendments related to fentanyl. The Department appreciates your continued attention to fentanyl trafficking and your efforts to ensure that the enhancements in the guidelines address those harms with which I am personally familiar through my work as a Department of Justice prosecutor for 8 years in both the Criminal Division, where I am the acting chief of the Narcotic and Dangerous Drug Unit, and in the Civil Division, where I was part of the Consumer Protection Branch's Opioid Initiative. As a preliminary matter, the Department holds the consensus view that the quantity threshold for fentanyl-related substances, as defined by the HALT Fentanyl Act, should be set to the same level as fentanyl analogs. Also consistent with the Act, the fentanyl enhancements proposed by the Commission should, at minimum, apply to fentanyl, fentanyl analogs, and fentanyl-related substances. The Department agrees with the CLC that the Commission should examine if the proposed enhancements should apply to all drugs and not just fentanyl, but because the current proposals are focused on fentanyl, that will be my focus here too. Regarding the proposed fentanyl enhancements, last cycle, the Commission amended the fake pills enhancement in response to stakeholder concerns and solicited comments on additional actions the Commission could take to address the serious and often deadly threat posed by the proliferation of fentanyl. This cycle, you've proposed several enhancements to address certain aggravated conduct associated with fentanyl offenses. We applaud your efforts and think that these enhancements are necessary and complement your changes last cycle. They also address the full range of fentanyl trafficking from illicit manufacture, which often involves pill presses and dangerous adulterants, to distribution to the end user, which often involves the dark web and sales to young people. First, we think it is important to provide an enhancement for distributing fentanyl to a minor or a young adult, or for using a minor or a young adult to commit the offense. Drug traffickers leverage social media to market, buy, sell, and deliver deadly fake prescription pills and other fentanyl-laced drugs on social media, gaming, and other similar platforms. Such an enhancement should apply to individuals under the age of 21 and not just 18. If the Commission chooses to adopt a defendant-based enhancement, the mens rea should only apply to the defendant's knowledge of the individual's age and not require the prosecutor to show the defendant's specific knowledge that the substance involved is fentanyl. Based on our experience with the marketing and misrepresentation enhancement, the Department believes that requiring specific knowledge of fentanyl will greatly limit the enhancement's application. We also think requiring an age gap would be inappropriate. The danger of selling fentanyl to a young adult is present regardless of the defendant's age, and excluding defendants from this enhancement may create an incentive for drug traffickers or dealers to recruit younger co-conspirators who would have lower sentencing exposure. Moreover, a sentencing judge can already take the defendant's age into account when determining the appropriate sentence. Next, I want to discuss the enhancement for adulterated fentanyl. Adding xylazine or other similar substances to fentanyl introduces complications to treating overdoses. and xylazine is showing up in a growing number of samples of seized fentanyl. The adulterant enhancement should be offense-based because adding a mens rea, again, would undermine application. Additionally, the enhancement should apply to the specific class of adulterants into which xylazine falls, not just xylazine, to deter drug traffickers from switching to a different substance with similar effects. Further, the department supports an enhancement for the use of the dark web or dark nets in drug trafficking cases. The intentional use of the dark web or anonymizing technology to conceal drug trafficking activities makes investigation and prosecutions more difficult and resource intensive. The department supports a 2 or 4 level enhancement, but urges the Commission to consider applying this enhancement to all controlled substances. Finally, we believe the proposed pill press enhancement addresses a fundamental part of the illicit supply chain for fentanyl-laced pills, the creation of the pills themselves. An offense-based enhancement is the best approach to ensure that the enhancement applies to all culpable defendants, including those who direct others to use pill presses to create dangerous fentanyl-laced pills. Again, I want to thank the Commission for its continued attention to the harms of fentanyl trafficking and the opportunity to testify here today. I welcome your questions.
Thank you, Ms. Salas. Just punch.
Okay, great. Good morning. My name is Natasha Purdue Silas, and as Chair Reeves mentioned, I am the Executive Director of the Federal Defender Program in the Northern District of Georgia. Although my post as leader began on July 1st of 2024, I have proudly served my community for the past 30 plus years, since November of 1994, and exclusively representing indigent people facing federal criminal charges. Thank you for the opportunity. I'm honored to testify on behalf of federal defenders. So over my career, I have represented more than 1,500 people, and that means I have defended drug offense clients through every wave of federal drug enforcement. Crack was king when I began my career, and I can remember sitting across from clients, most of the time in a jail attorney visitation room with this 1994 book, somewhat of a relic, trying to help my clients make sense of why crack carried such a different penalty than powder cocaine. And I was very unsuccessful. Not one of my clients ever said, okay, I get it. And it was unfair, and my clients knew it. And so it was irrational, it was unwarranted, and this commission had the wisdom to tackle the crack powder disparity. So now we turn to meth. I applaud the commission for taking on this really important issue. Today, everyone in this room knows that meth is uniformly highly pure. In my own district, 2 clients with identical drug packages can face very different outcomes depending on whether the drugs were sent to the DEA lab or to the GBI, which is far less likely to conduct purity testing. That is not a principled distinction, it is an arbitrary one. I am thinking now of a client that I will refer to as Carlos. Finding himself in dire financial straits, Carlos turned to what some call shady delivery work for extra money. For just $200, he carried a 3-pound package across town and delivered it to a man who turned out to be a confidential informant. So Carlos soon found himself sitting across from me. I explained that because the meth in his case had been sent to the DEA lab and therefore tested at over 99% pure, his guideline calculation started at a level 34, yielding a range of 87 to 108 months after acceptance and safety valve, rather than the 57 to 71 month range he would have faced if the substance had been sent to the GBI lab. Carlos protested that he had no knowledge of and nothing whatsoever to do with the purity of the drug. He was the delivery guy. Just like my crack clients, Carlos could not understand why the purity distinction should make such a difference to his guidelines. As we fashion rules, let us remember they must make sense to the people who will be subject to them. When guidelines produce results based on distinctions that defy rationality and do not resonate with real people, the messages those sentences are meant to convey does not land. Defenders strongly support option 1. We greatly admire the Commission's commitment to follow science and data. Dr. Jonathan Calkins testified here 6 months ago that both scientific and drug market evidence show meth is most comparable to powder cocaine, while crack has been associated with higher observable harm. This is consistent with experts that I have consulted with in my own district. For this reason, defenders urge the Commission to set unified meth thresholds at powder cocaine levels. The Commission's own data show that setting them at crack levels would increase sentences for up to a third of individuals, even as judges are already varying downward because they believe current meth penalties are too high. And most defendants are lower level participants. This statutorily independent body should ground its decisions in science and reason. Setting thresholds at powder cocaine levels follows the science, follows the data, advances simplification, and moves us closer to a system that produces sentences we can explain and that people can understand. Thank you, and I look forward to questions.
Thank you, Ms. Salas. Ms. Richmond.
Well, I've gone through the first challenge. Chairman Reeves, commissioners, thank you for the opportunity to speak today about the proposed fentanyl and fentanyl analog amendments. The devastating impact of fentanyl and its analogs cannot be overstated, but we fear that the Commission's approach will not help us to address this crisis. It will not make our communities safer. I spent many years defending people charged with federal drug crimes in Maryland. I often meet my client just a few moments before their initial appearance. And it sounds like Judge Chang. I've come to recognize the signs of drug withdrawal, to know when it's necessary to pull a trash can next to my client during their initial appearance in case they need to vomit, to push for emergency room treatment when they cannot competently proceed, to ask the marshals for a blanket when my client's teeth are chattering and their hands are shaking uncontrollably, and when those clients are detained, to beg that they be placed at the single facility in Maryland that offers medically assisted treatment to pretrial federal detainees, and to know that it will rarely happen. Most of my clients will get at best Tylenol and a blanket. For decades, Baltimore has tried to solve its drug problem with arrests and aggressive policing. My clients are already casualties of war on drugs enforcement and centuries of racial discrimination and redlining. They grew up where excessive punishment for drug crimes created an unbroken cycle of trauma and socioeconomic marginalization, which are the root causes of many substance use disorders. Today, much of Baltimore and many urban areas in Maryland remain treatment deserts. And in 2024, the New York Times called Baltimore the U.S. overdose capital. The city's overdose rate soared higher than the rest of the country from 2018 to 2022. Why? Because campaigns to reduce deaths and increased treatment withered on the vine, discarded in favor of prosecution and jail. The resulting overdose crisis is what happens when we choose punishment over public health. Chairperson Reeves, commissioners, we are grateful for your commitment to empiricism, innovation, and evidence. Today, we ask the Commission to ground itself in those principles. Please scrutinize each proposed change and ask yourself 3 questions. What data shows this change is needed? How will it address the harms of drug misuse? Is it rooted in evidence and science? I anticipate it will be hard to answer that question today. When I look around this room, and even when I look at the comments that have been submitted to the Commission, who's missing? Public health researchers, emergency room doctors, addiction specialists, epidemiologists, community health workers, chemists, pharmacologists. The lawyers in this room do not have the expertise to diagnose the antecedents of harmful drug trends or to propose effective responses. We all see only the aftermath, the drugs that are seized, the overdose victim, the client sitting next to you in the courtroom, and withdrawal. Last August, the Commission held a hearing with public health experts on methamphetamine. They gathered many of those experts, people on the ground. That was a very good idea, a step towards bringing in voices that have too long been absent from these deliberations. And I urge the Commission to take a similar approach when it comes to fentanyl, fentanyl analogs, and fentanyl-related substances. Consult the experts before acting. Knee-jerk increases in punishments are not the way. Finally, the specific proposal. First, fentanyl-related substances. There are many different fentanyl-related substances and many fentanyl analogs. Not all of them are harmful. Some of them are inert, and some, the FDA has testified, even have the potential to treat opioid overdoses. The blanket addition of FRS to the guideline without potential for a downward adjustment captures none of this nuance. It doesn't make sense for someone to face an offense level 4 times higher than fentanyl levels when their offense involved far less harmful substances or ones that are not harmful at all. And I direct the Commission to Dr. Gregory Dudley's comment. He is a scientist and a chemist for important information about the necessary fix. The enhancements. The Commission asks whether adding these would address fentanyl's harms. They will not. They will punish for the sake of punishment. Where is the data showing that enhancements will reduce harm, decrease drug sales, stave off overdose deaths? There is none. These proposals lack empirical support. They all add unnecessary complexity and directly contravene the Commission's laudable efforts to simplify guidelines and recenter for courts the 3553A factors. Moreover, they are largely redundant. Each proposed enhancement already overlaps substantially with existing enhancements in 2D 1.1 and Chapter 3. And these enhancements will likely trigger more and larger downward variances. When judges sentence our clients, they look at far more than to whether they distributed to a 17 or 20-year-old friend or co-conspirator, or whether they used the dark web. They see the whole person, their backgrounds, their addictions, their ages, their roles, and countless other factors that the guidelines cannot capture one by one. We urge the Commission not to repeat past mistakes. Allow judges to address these factors through 3553A rather than enshrining them in 2D 1.1. Thank you for considering defenders' views. I'm happy to answer any questions you may have.
Thank you. Any questions? Who wants to start us off? This is an excellent panel. Not that others are. VC Mate.
Thank you all for being here today. I appreciate all of the efforts to be here and the work in preparation. To no one there. Is that better? I have a question. I have a bunch of questions, but starting with meth. So, and I was thinking about the testing issue, and if the commission were to proceed and set meth all at one level, am I correct in thinking that the only role then for purity testing, which I understand is what's kind of happening in some places and not others, but that would just exist for purposes of mandatory minimums, and there wouldn't be purity testing for purposes of the guidelines? Do I understand that correctly from the testing perspective?
I think that's probably correct. In my district, I think we would still continue to ask that it all be tested for purity for those purposes, but obviously it would be less important than under the current distinctions.
I think I'm going to agree with my brother there. There would be less need for the purity testing. And a few months ago, I went out and visited the lab, the GBI lab in our district, and they were complaining that they kept getting calls to go back and test things. They already tested for purity, and they have a big backlog. So I think they would be happy about that.
Thank you, that's helpful.
And then, sorry, this is a follow-up, and then I have my real question. But there'd be no need for isomer testing at all. Is that right? So purity you would still need for mandatory minimums, but no need for isomer testing because the only reason we have that is because of ice?
I'm not quite sure the answer to that. In my district, regardless of whether it was tested by a local lab, we have them send it to the DEA lab so we get a purity test. And then in my district, it's all 95% plus pure. And so that tends to be what drives the guidelines. We have almost 100%, testing on drugs that are seized in my district. So
maybe I'm being dense, but am I right that the only reason we do isomer testing, though, is because of this definition of ice that the commission kind of invented?
I'm not 100% sure the answer to that question.
And then I have more questions about ice, if you don't mind.
Sure.
It seems like the department has two concerns about the elimination of ice. One is this concern about tablets and liquid, and one is a kind of a concern about the directive. And it seems to me like at least the policy one can be dispensed with by a change to the amendment. And I'm wondering if this would resolve your policy-based concern. If we were, we have this, the amendment has this sort of two-step downward for things that are non-smokable, non-crystalline. If we were to explicitly exclude from that liquid and tablets, to say, or they can readily be converted into crystalline smokable, and then divide it in an application note to make clear that what we mean is, liquid and tablets are at the higher level. Would that alleviate the department's policy concern? I realize there's also still a directive-based concern.
I think it would partially alleviate it. I still think there'd be some issues. One, are you creating a null set? I mean, what meth is going to fall, once you exclude those? Is there anything, in which case, why are we making the amendment?
That's a little bit of a question for Congress rather than us.
Well,
right?
that
we
is
didn't
fair.
create the null set.
Sure.
And so I guess that goes into my second question, which is, I saw that you guys kind of gestured at maybe that wouldn't meaningfully comply with the directive. And I'm wondering then if you think that the current regime meaningfully complies with the directive, because the current regime does not distinguish between smokable crystalline meth and other kinds, right? The commission that drafted the current regime didn't know what that directive meant, and so grafted this 80% rule on, which did not come from Congress. And so I'm wondering if you think the new null set would be more problematic than the current regime in terms of the directive.
I don't think the current regime does set quite a null set. I mean, there are districts that have applied it successfully. I'm not aware of anybody contending that the current regime doesn't comply with the directive. So I think the answer is no, but
you think the current regime distinguishes between smokable crystalline meth and other kinds of meth?
I think on the ground it does, yes. I think people understand what it means.
So in practice, people are not using the 80% definition, they're using smokable crystalline versus not?
I think it's both. I mean, I think it's all part of the analysis.
Is it Restrepo?
This is a question for Ms. Silas and Mr. Lombardi. So if the original thinking was purity was kind of reflection of relative culpability, the guys at the top of the food chain, so to speak, had access to the most pure, and now everything's pure. How do you suggest we evaluate relative culpability in the meth context?
Well, I think it's already set forth in the guidelines, and the commission has recently expanded, people that can qualify for downward roll adjustments. So there are certainly still tools under the guidelines for a judge to, weigh relative culpability, who's a leader, who's just a courier and maybe is appropriate for a downward roll adjustment. And then, of course, the 3553A factors will come into play. So I think the current regime, will let judges do that. And it's one thing we mention in our written materials. I do think the change to roll adjustment that the commission just made, that are just coming into effect, might have a significant impact in at least some methamphetamine cases. Again, meth is largely being produced abroad. Many of the people that are being caught up in meth offenses here in the United States now are going to be couriers, they're going to be stash house operators, and may qualify for those roll adjustments. And it may make sense to let that play out a little bit, see how that affects methamphetamine sentences before you start revisiting the other parts of the guideline. But I do think it's still going to be possible without the amendment, any of these amendments to still reflect that.
I guess I think that the commission's recent amendments on roll are very welcome. And in Carlos's case in particular, I made a very impassioned plea for a minor roll, and that was before the recent amendments, and that was denied for Carlos, even though everyone agreed that he was the delivery guy. But still, our district court judge hung her hat on the fact that he was the only one prosecuted in that particular instance. So that's why the new amendments, I think, are very helpful. We do talk about relative culpability in every one of the sentencings that I appear in. It's just that we have been having trouble with a stuck faucet when it came to minor roll and minimal roll. So that's very helpful.
Yes, VC May.
I have a follow-up question on that, Ms. Silas, and just kind of listening to Mr. Lombardi. And when it comes to us setting the appropriate level for meth, we've heard from a lot of stakeholders that a lot of meth cases involve sort of low-level actors. We heard from one commenter that about 20% of those prosecuted for methamphetamine are women. And I'm curious whether you think our mitigating role adjustment kind of takes care of that, or whether that should also inform what level we might set the meth at if we were choosing a single point.
Well, I think the current meth level is too high. And even though we've gotten the faucet unstuck on mitigating role, that really doesn't answer the question fully. I still think I would be trying to explain to Carlos why his offense level is higher on account of a purity that he had nothing to do with. So I think that it's not enough to just say we're going to adjust for role, because there's more than that involved. And the science and the data that the commission has pursued tells us that methamphetamine is much more comparable to powder cocaine. And so I think you need to still set the levels appropriately, independently of what you've already done on the roll.
Thank you.
Mr. Wong.
Mr. Lombardi and Ms. Silas, one of the arguments we have heard for considering the meth amendments are that this could alleviate some of the testing burdens that there are. And if I heard correctly earlier, both of you indicated that, in fact, even if it is less significant for the guidelines, but the testing would go to mandatory minimums, you would still envision testing in 100% of cases, or close to the same amount of cases regardless. I'm just curious if you could unpack that a little bit for us, because I think there has been sort of an underlying assumption that the need for testing may be minimized dramatically or significantly with some of these proposals.
Yeah, I do think we would still see a considerable amount of it tested just to get the purity for figuring out whether the mandatory minimum applies. Obviously, if he sees like 1,000 pounds of something that tests positive for methamphetamine and the level is at something below actual, maybe it just kind of doesn't. It's a base 38, no matter how you kind of slice it. Maybe then you don't need a purity testing. But for smaller quantities, you're still very often going to need purity testing. So I don't know that it would result in a significant cost saving. If I could I respond to one other thing that was said earlier? I disagree that methamphetamine is the same as powder cocaine. You know, I think we've all seen, you know, thinking back a few years, that poster, Faces of Meth. I've never seen a poster like that, Faces of Cocaine. Methamphetamine is a more significant, more addictive stimulant. That's not to say that cocaine's great. Cocaine is also bad. But I don't think that they're, you know, really comparable. Congress certainly didn't think it was comparable. The other difference is, they're, again, very different trafficking patterns. You know, cocaine is a plant-based drug. There was a reference in the written materials. Cocaine costs more money, it must be worse. No, it's a function of how it's produced. It's grown from a plant and it has to be refined. It's much more complicated and expensive to produce than methamphetamine. So I don't think the comparison between methamphetamine and powder cocaine is well taken.
You can follow up.
Could I just follow up on sort of the first point? On the testing and whether there would be cost savings, would there still need to be, and this is just a granular question on the ground, would there still need to be lab testing to confirm through a lab test the presence of methamphetamine? Or would a field test suffice for sort of that, and then you know it's a mixture, you know? Or do you think there would still need to be the lab test?
You would still need a lab test.
Does that actually provide any cost savings? Or at that point, if you're testing, a lab is testing for the presence of meth, is there additional cost associated with testing the quantity, or is it going to be one test regardless? If it's a test that's happening regardless, just to confirm the presence of meth.
So as I recall the testimony that you had in August, someone from the lab did testify and said that there is additional testing for purity. So there's a test just to confirm meth at the lab, which in my judgment, that's beyond a reasonable doubt that it's meth. And then they do additional testing for purity that they wouldn't necessarily have to do if you're not looking for purity, but I don't know that it's a huge cost savings. You know, there is additional testing. It does tack on a little bit of time to finish it, but I don't know that the difference is that significant. But again, I'm not the lab expert.
My recollection is that there is a different process for determining purity than the identity of the substance, at least at the GBI lab. And so there would be a cost savings if you're just looking for the identity of the substance. I don't think any of us would be willing to rely on field testing for methamphetamine. So you're going to have a test, yes, but the extra step of the purity, and now I'm relying more on the testimony y'all heard in August that I listened to. So I think there's a cost savings for sure.
Murray.
I have a xylazine question. There's a little bit of a debate in the comments that we heard about whether xylazine makes, or mixing with xylazine makes fentanyl more dangerous, and whether it makes it less susceptible to naloxone. I think the government said yes, and it seemed like both the defenders and our practitioners advisory group cite a study that seems to call that into question. I'd be interested in hearing from both of you about xylazine.
Thank you. We agree that there's a considerable question about the role of xylazine in overdoses, with mixed information coming in, some of it showing that the presence of xylazine could be reducing overdose death. And that comes in the form of data and studies that are being published on government websites like NIDA. There's NIDA-funded research showing that emergency outcomes are better. And there's also research beginning to show that it might be responsive to Narcan. I think that this is an area of considerable study and research, and it's evolving rapidly, which really speaks to the need to stop and hear from the experts about the particular harms posed by xylazine in the fentanyl drug supply, or in the drug supply generally.
The department's understanding is that xylazine creates complications related to overdose because naloxone does not treat xylazine. There are additional emergency procedures that need to be done in order to ensure that someone is not having an overdose. And so because of these complications, we think xylazine is particularly problematic and leading to negative health outcomes. Yes, but I think I agree, this is an area where more study needs to be done.
I'm sorry, may I just add, because I think it's important, it's rare to have an unadulterated xylazine overdose. It's usually mixed with fentanyl. It's really important that first responders keep using Narcan because it binds to the same receptor that the fentanyl does, even though we need to keep studying the role of xylazine. Narcan still really works and is essential in those types of overdoses.
I have one last question. I'm sorry. It's just really for the department. We've been talking about the cost of testing for meth. The defender says that the defenders say that maybe you ought to be sentencing meth like powder cocaine, which I presume is a much lower level than crack or anything else. Does the department take a view on, the cost of incarceration? Because I think in every PSR that we receive, every year of incarceration costs over $55,000. I think it is $55,711 as of today. The exponential cost, in months, in years, the difference between how persons are sentenced. And I know the Bureau of Prisons is within the DOJ, and there's some question of whether the Bureau of Prisons is providing everything that it can under the current constraints of budgets and things. I understand you have to enforce the law, but is that something that the department looks at as well, the cost of incarceration?
I don't think in this context, again, Congress has set these mandatory minimum penalties. It's Congress's indication of how serious they see this drug. And so, people who are committing these violations, need to be sentenced accordingly. And that just kind of is what it is. If, Congress decides to change the statute, well, that might be a reason to do that. But it's a serious offense and it should be dealt with accordingly. And I don't think cost is necessarily a huge factor in that regard.
What determination does the Department of Justice take in pursuing charges of mandatory minimum versus anything else? I don't think Congress dictates to the department exactly who is to be charged with a mandatory minimum. So tell me, how does the department determine which defendant or which case you will pursue the mandatory minimum of and not the other?
So certainly we do have limited resources, both prosecutors and law enforcement. We have to pick our places. In almost every jurisdiction, there's concurrent jurisdiction with state authorities who can do drug cases. So we are trying to pick the cases where we're prosecuting the higher level traffickers or prosecutions that are going to have a more significant impact. And there's a lot of factors that going into making that determination how we charge the case. Again, I've been doing this for a while. For most of my career, not all of it, there have been some variation between administrations. The directive has been to prosecute the most serious, readily provable offense. So regardless of what drug it is, if it's triggering a mandatory minimum, we're typically going to charge that because that's what the policy directive is, and that's what's consistent with what Congress has enacted. But obviously, there's going to be all sorts of cases where we pass on the case for one reason or another.
Thank you for the engagement. Commissioner Meisler, you may have had a question, and I see you were jumping in there too.
I'll defer to Commissioner Meisler.
Mine was more of a theoretical question, the opposite of the granular question that Commissioner Wong asked earlier. But I'm just curious, and this is primarily for maybe Ms. Richmond, but others should feel free to weigh in. I'm just curious about, at a high level, what we should be thinking about purity, given all of the information we've heard, purity, potency, these concepts. Because I was thinking, Ms. Richmond, in particular, with respect to fentanyl-related substances, it seems like on meth, maybe the defender's view is this purity thing doesn't matter, forget about it. When we get over to fentanyl-related substances, it's we should look at it. And yes, you can set the levels equivalent to analog, but when purity and potency come in, those considerations weigh in favor of kind of a downward exclusion at some point. So just conceptually, do you acknowledge that purity and potency can play a role in the commission's policymaking?
Thank you for your question. I think your question illustrates some of the problems with approaching changes to 2D 1.1 piecemeal. And there's widespread agreement that drug type and quantity are particularly poor metrics for gauging culpability and figuring out the right amount of punishment for somebody. And we think that's true. Fentanyl and its analogs are within a framework right now that looks at potency and looks at type to determine how they're punished. And so if we're taking that into consideration, we think it's really important to note the huge swings in potency and harmfulness between fentanyl and its analogs. You know, I couldn't help but notice in the 2024 quick facts, one of the substances involved was benzylfentanyl. That's a substance that the DEA has acknowledged has no pharmacological effect whatsoever. So we have this mix, this vast quantity of substances that are being brought into federal sentencing. And I think it's important for the commission to understand the complexity of the pharmacology and chemical determinations while it continues to value potency and harmfulness as a factor in its sentencing decisions.
Briefly for Mr. Lombardi, in response to the chair's question, you referenced this department policy of proving the most serious offense. Does the department take a similar view with respect to 851 notices? Is there any sort of uniform policy on meth cases and 851 notices?
I believe there is, but I'm not sure that we've changed that or this administration has changed it. You know, in my district, it is very, very rare that we file 851 enhancements. So I think we'd have to get back to you on that. I'm not that familiar with that part of the statute.
If I can offer this as well, it's very rare that we see 851 enhancements. And also with respect to mandatory minimums, I don't think that the commission needs to be concerned about the cliffs because it's very few cases that end up getting governed by the mandatory minimums for most cases. And I think your data shows only 24% of cases are sentenced according to a mandatory minimum. Most cases anchor on the guidelines. So we hope that you will make the guidelines follow the data and the science.
Thank you all so much. We appreciate your comments. Our third group of panelists will provide us with the perspective of our advisory groups on the proposed amendment on drug offenses. First, we will hear from David Patton, chair of our Practitioners Advisory Group. Mr. Patton is a partner at Hecker Fink LLP in New York City, where he represents clients both retained and appointed in federal court. Prior to joining Hecker Fink, Mr. Patton was the executive director of the Federal Defenders of New York, serving Southern and Eastern districts of New York for about 12 years or so. Second, from our Probation Officers Advisory Group, we have Sammy Gertz, who is Supervisory Probation Officer in the Eastern District of Virginia. She has been with the U.S. Probation Services since 2003. Adam Clausen will be the third. He is a member of our newest advisory group, the Sentence Impact Advisory Group. Mr. Clausen was sentenced to approximately 213 years in prison and served over 20 years before a court granted his motion for compassionate release. Since his release, Mr. Clausen has founded and worked with many organizations that aid those who have been impacted by the correctional system. Fourth, we have Jamie Johnson of our Tribal Issues Advisory Group. Ms. Johnson is an enrolled member of the Choctaw Nation of Oklahoma. She is an assistant federal public defender for the District of Arizona, where she represents indigent defendants primarily in federal criminal appeals. Rounding out this panel will be Colleen Clace of the Victims' Rights Advisory Group. Ms. Clace is the Chief Counsel for Arizona Voice for Crime Victims, a nonprofit organization that provides pro bono social services and legal representation for the purpose of asserting and enforcing victims' rights in criminal prosecutions. Mr. Patton, sir, we're ready when you are.
Thank you, Chair Reeves, and thank you, Commissioners, for inviting me here to share the views of the Practitioners Advisory Group. In short, our positions are that we support option 1 of Part A, the proposed amendment to the methamphetamine guideline, and we encourage the Commission to set the quantity thresholds at the current level for mixture. Secondly, we oppose the proposed specific offense characteristics for offenses involving fentanyl and fentanyl analogs. So I'll start with methamphetamine. Along with many commentators that you've heard from, the PAG has been critical of the meth guidelines for many years, and we're very pleased to see the Commission proposing to eliminate. Sorry, am I back on? The Commission itself, in discussing the feedback it's received from stakeholders, and probably most significantly from judges, has noted the many problems with the current purity-based regime. Purity is no longer a proxy for role or culpability to the extent that it ever was, but it surely is not now. Testing procedures vary widely from district to district, and sometimes even within districts, as you've heard. There is no empirical support for the current distinctions, and most judges find the guidelines to be too severe, and by a substantial amount, not just by a minor amount. One example we provided in our comments to really highlight how irrational this can be, in one case in the Eastern District of Kentucky, 2 co-defendants in the exact same case involving the exact same drugs were sentenced at different points in time, one before purity testing had been done and one after. And the one after got a substantially higher sentence based purely on the happenstance of the timing of the testing, and that far greater sentence was upheld on appeal. Due in no small part to a lot of the issues that you've been hearing about when it comes to purity testing, There are quite a number of districts where the majority of judges, just as a policy matter, do not apply the 10-to-1 ratio, and a number of circuits have authorized that. And so I think we are at a point where it's important for respect for the guidelines, to address what are some really irrational disparities, to make this change that you've proposed. Secondly, when it comes to fentanyl and the specific offense characteristics, we really feel strongly that these would run counter to a lot of the efforts that the Commission has made to simplify the guidelines, to take a step back from the really thinly slicing of human behavior and trying to quantify individual things that are just better left to judges and 3553A factors. The Commission itself in recent years has really, I think, been taking seriously and trying to fix this issue with factor creep, and this would just move in the wrong direction. I was struck in particular on the age-based proposal in the data briefing by how high the sentences already are for the very small number of cases that would apply if that SOC were enacted. They're already far higher than typical fentanyl sentences, even though, according to the data briefing, 77% play a very low-level role. And what that suggests to me is judges are paying attention to these things, and they're accounting for them, and there really isn't a need to continue digging when it comes to the factor creep. And I look forward to answering your questions.
Thank you, Mr. Patton. Ms. Gertz.
Chairman Reeves and the commissioners, thank you so much for the opportunity to share POAG's perspective on the proposed drug offense amendments. POAG unanimously supports reducing the disparity between the treatment of methamphetamine mixture, methamphetamine actual, and ice, and is unanimously in favor of option 1 of Part A, which sets the same quantity thresholds for all methamphetamine offenses. The availability of lab reports varies greatly between districts and even within districts, depending on the agencies involved, and not all lab reports reflect purity. The varied testing practices have led to unwarranted disparities and growing policy disagreement as to whether purity is an appropriate indicator of culpability. As a result, some courts are treating all cases involving methamphetamine as methamphetamine mixture, even when the purity level is known. A single substance measurement for methamphetamine would eliminate the current 10-to-1 ratio difference between meth actual and meth mixture, while simplifying the process and eliminating these disparities. While POAG agrees that all meth cases should have the same quantity threshold, we have opted not to weigh in as to which measurement is most appropriate, and instead we defer to the subject matter experts for that determination. POAG is unanimously opposed to option 2 of Part A, which provides different offense levels for meth offenses depending on a wide variety of factors. POAG believes that option 2 is complicated, provides too many variables, and moves away from the goal of simplification. Providing alternate meth quantity ranges based on certain aggravating or mitigating factors would require additional fact-finding and result in significant legal challenges. Further, many of the proposed factors are already considered elsewhere under the guidelines. Turning now to fentanyl offenses, POAG unanimously supports adding fentanyl-related substances to the drug quantity table and believes it would be most appropriate to set the quantity thresholds and base offense levels at the same level as fentanyl analogs. POAG is in favor of creating an enhancement based on the use or possession of a tableting machine in fentanyl offenses, as this conduct is not always captured under the guidelines. In cases involving pill press operations, the operator may not qualify for an enhancement under 2D 1.1b13 because they did not misrepresent the substance. This could result in a lower offense level for pill press operators compared to distributors. POAG believes that this enhancement should be offense-based because in most cases involving tableting machines, many individuals, not just the operators, are aware of and benefit from the pill press operation. POAG is also in favor of an enhancement for offenses involving fentanyl that is adulterated with xylazine, but in a broadened state. Specifically, the enhancement should apply to any adulterated substance that, quote, negatively impacts life-saving measures, end quote, or that, quote, increases the risk of serious bodily injury or death, end quote. The broadening of this enhancement may require additional fact-finding, but we believe this change best meets the goals of this enhancement while not limiting it to xylazine, given the introduction of new drugs that could have the same effect. POAG is not in support of creating an enhancement for distribution of fentanyl to minors or for the use or attempted use of minors in fentanyl offenses. While we agree with the intent behind this proposed amendment, it does not appear the enhancement for this conduct would be applied often because in most cases, unless there's a death or an overdose, the age of the person who the drugs were sold to is unknown. Similarly, unless there's an arrest, the age of the participants is unknown. Further, in cases where such information is available, those usually result in higher base offense levels and Chapter 3 adjustments. POAG is also opposed to an enhancement for the use of the dark web or similar technologies in fentanyl offenses. Currently, this conduct is generally captured at 2D 1.1b7 for distribution of a controlled substance through mass marketing. Additionally, based on ever-changing technology, the enhancement may become obsolete, or alternatively, as use of the dark web becomes more commonplace, it could be applied more ordinarily. Rather than an enhancement under 2D 1.1, we believe use of the dark web may be better served as a qualifier under the proposed Chapter 3 amendment for sophisticated means. Thank you for your time.
Thank you. Mr. Clausen. At the bottom. There you go.
Thank you. Chairman Reeves, Commissioners, thank you for the opportunity to testify today. My name is Adam Clausen, and I'm here on behalf of the Sentencing Impact Advisory Group, or SIAG. Prior to today, we submitted extensive written comments to the Commission, laying out our positions on all of the proposed amendments, and I would encourage, if you have not, to please read those in their entirety. It's well worth the read. SIAG brings our firsthand lived experience into this process, and I am honored to carry that perspective into the room today. We can speak with real authority about how the federal criminal code and the Commission's amendments actually function in practice, and about the consequences those decisions create for both the people and the families who actually have to live with those. I also want to acknowledge something directly. The Commission has made great efforts and made meaningful progress towards strengthening both the efficacy and the fairness of the system, and we want to acknowledge that. I'm genuinely grateful for us having a seat at the table, so thank you. What I want to do now is give you SIAG's position on the drug amendments plainly from that lived experience vantage point. On methamphetamine, SIAG supports option 1. We support eliminating the purity-based distinctions and moving to a simpler, single set of thresholds. I've heard plenty of support for that position, but from our perspective, it's the people who are on the ground they're not in a position to take into account any of the more complex procedures that are used to determine what the ultimate sentence would be. Second, if the Commission adopts option 1, we would suggest that it implement it using the current mixture thresholds and not the actual thresholds applied across the board. And SIAG supports removing references to ICE and supports a 2-level decrease for non-smokable, non-crystalline methamphetamine. On the fentanyl-related substances, SIAG supports treating fentanyl-related substances and analogs similarly for guideline purposes. We recognize the extraordinary danger posed by this substance here, and we're not minimizing the harm that fentanyl has caused to our communities and to our families. Where SIAG is more cautious is around the additional enhancements. In our submission, there were differing views amongst our members, but the majority of participating members opposed several of the proposed enhancements as they were written. And our concern is based on our lived experience, and that a more broad and duplicative enhancements can ultimately expand punishment in ways that don't reliably track a person's knowledge, a person's intent, or their actual role. And that can produce outcomes that feel arbitrary for the people who are living through them. Prisons are filled with drug users. And yes, there are some higher level dealers, but they're in the minority. Currently, the vast majority of people that we have sentenced under our drug laws are there because they've been swept into a large net. We want to make sure that there is no further disparity created by any of the enhancements. I would encourage everyone, especially those following these proposals closely, to read our formal submission where members of our group discussed our differing views on some of those enhancements. It lays out our positions in detail, and in the areas where members held differing views, it captures the nuance of our lived experience and the context behind those differences, which is important in considering what SIAG brings to this conversation. So the clearest way for me to summarize SIAG's position is this. We want to simplify methamphetamine in a way that improves clarity and proportionality. Option 1 is what we are suggesting with the mixture thresholds, and we want to remove ICE, reference, and adopt the 2-level decrease for non-smokable, non-crystalline methamphetamine. Second, treat fentanyl-related substances like fentanyl, acknowledging the seriousness of that threat. And finally, please use restraint with the enhancements and make sure that any increase in punishment is tied closely to culpability, personal knowledge, intent, and the role. And I'll close with this. SIAG's comments are not theoretical. They come from people who know personally how the guidelines and the choices that we make here ripple outward into families and across communities and throughout both the rehabilitation and reentry process. Our goal is to support the Commission in creating a guideline system that is easy to understand, proportionate, and credible, because credibility and fairness are what makes public safety a reality. Thank you.
Thank you, Mr. Clausen. Ms. Johnson.
Thank you. Thank you, Chair Reeves and Commissioners, for the opportunity to address you today on behalf of the Tribal Issues Advisory Group. As you have seen from our written submissions, TIAG, like many commentators, supports eliminating the artificial distinctions between meth mixture and meth actual. TIAG supports option 1 and supports setting the levels at the current levels for meth mixture. And rather than repeat some of the other arguments you've heard today that are present in our letter, I want to talk to you a little bit about some issues that are specific to tribal jurisdictions that may not apply in other locations. Mr. Lombardi, the gentleman from the Department of Justice, talked about how in his jurisdiction, when meth cases are prosecuted, the federal government goes after the kingpins and the large quantity dealers and the large conspiracies. This isn't true for Indians in Indian country. For jurisdictional reasons, the state has no jurisdiction over most crimes on most reservations, and exclusive jurisdiction is with the federal government or the tribes themselves. So what we do see in Indian country is prosecutions of individuals selling small quantities who are not part of a larger conspiracy. Take an individual, for example, who might sell something slightly south of 5 grams of methamphetamine. Generally, this is somebody who is themselves addicted, and they are sharing or trading or selling small quantities to support their own habit. And I practice in a jurisdiction where the drugs are almost never tested unless someone proceeds to trial. So currently, this person with this, slightly less than 5 grams of meth has guideline levels of, would face a base offense level of about 12. That is a base offense level that makes this person eligible for probation, pretrial release. They can get into rehabilitation, they can get therapy, they can get services they need. And what we see is that these people, when provided with services, they often do quite well and succeed and go on to receive non-custodial sentences or very short custodial sentences and are able to be rehabilitated into the community and continue to do well on supervision. Setting the offense level for meth actual would mean that that same person with this small quantity of drugs faces a base offense level of 22. This is an offense level where a non-custodial sentence is not recommended or even close to being recommended by the guidelines. It would require a very substantial variance. And incorporated within the guidelines appear to be this assumption that if anyone has very pure meth, as we've heard from other people, that this person must be a kingpin or a leader, and that assumption is just outdated. And so what TIAG does not want to see happen is to see Indians in Indian country with very small quantities who are not professional dealers, who are people who are substance addicted themselves, who are selling, exchanging, trading small quantities of drugs with very high offense levels that and result in very long periods of incarceration, that do nothing to protect the community, that do not provide the people with the services they need, and do not give people the incentive to do well on pretrial release in the hopes that perhaps they can avoid a custodial sentence. With respect to the fentanyl amendments, TIAG does support, with limitations, the age amendment, with the important limitation being that the age threshold be set at 18, and that there be an 8-year age gap, at least an 8-year age gap, between the defendant and the minor in question. And that age gap is important to TIAG because in a lot of these reservation communities, people's peer groups encompass a larger diversity of age individuals. We're talking about rural communities where people don't have very many neighbors. And TIAG does not want to see this age amendment, which it does support, turned into an enhancement that generally applies to young people who are selling drugs to each other or using each other to facilitate drug transactions. So that it becomes a sort of de facto sentencing amendment or a sentencing enhancement for young people. With respect to the other amendments, TIAG does not support the other amendments because we believe that there hasn't been enough study and enough empirical evidence to support their enactment at this point. For example, the use of the dark web. We appreciate that the dark web may make it more difficult for law enforcement to investigate and prosecute crimes. It is unclear that that necessarily merits a harsher sentence. For example, one can imagine that the use of the dark web, if it's a substitute for street transactions, could potentially have salutary ancillary effects upon the surrounding community if it reduces street crime, if it produces fewer negative externalities for people who live in the community where the behavior is happening. I don't know if that's true, but we don't believe that there's been enough study to determine that. And TIAG generally opposes adding amendments without sufficient study, and so we would appreciate more information on those, but do not support them at this time.
Thank you. Ms. Claes.
Good morning. Good morning, Commissioner. Good morning, Commissioner Reeves, members of the Commission. My comments today reflect the position of the Victims' Rights Advisory Group, and our position is informed by our collective experience providing direct legal and social services to victims of crime. Drug-related crimes do not stay contained within users, or traffickers. It devastates families, communities, and too often costs innocent people their lives. Drug trafficking frequently results in death, whether through overdose, tainted supply, or drug-induced violence. Certain drugs, like meth, are scientifically proven to increase aggression and antisocial behavior. And victims, including third parties, often suffer long after the offense itself. Sentencing should reflect the real world harm. Victims deserve a framework that prioritizes accountability, deterrence, and public safety, not one that rewards technical distinctions. Amendments to the guidelines should prioritize victim harm, public safety, and accountability. The Victims' Rights Advisory Group urges the Commission to adopt Option 2 for methamphetamine offenses without reducing existing penalties. Option 1 oversimplifies the guidelines and risks the minimization of real-world harm to victims. Simplicity should not come at the expense of justice. The impact on a victim cannot be simplified. Whether a methamphetamine user commits a property crime to fuel their addiction, or a violent assault or a homicide, the harm to victims is profound and long-lasting. The CVRA provides victims a right to fairness, and fairness demands accountability, and that the guidelines reflect the purposes of sentencing. A potential reduction in penalties for methamphetamine offenses would conflict with the intent of Congress. With respect to the fentanyl-related substances, the Victims' Rights Advisory Group does support the Commission's proposal to treat fentanyl-related substances the same as fentanyl analogs. The harm caused by fentanyl-related substances is indistinguishable from fentanyl itself, and the harm is extraordinarily potent. We also support adding fentanyl-related substances enhancement for misrepresentation and false marketing. The Victims' Rights Advisory Group also supports special offense characteristics, addressing distribution to minors. And finally, we support all 4 proposed fentanyl enhancements. The Victims' Rights Advisory Group recommends a 4-level enhancement for distribution to distribution to minors, using a bright line under 18 standard with no age differential requirement. We also support a 4-level enhancement for dark web trafficking, enhancement for xylazine and similar, and a 4-level enhancement for possession of tableting machines. With that, I would welcome any questions that the Commission has as it relates to the victim perspective, the harm that victims endure, and the victim impact. Thank you.
Thank you all for your openings. Any questions? Yes.
Mr. Clausen, thanks for being here. So as you know, the guidelines include a lot of specific offender characteristics. Do you think that individuals factor these SOCs into their calculation before they engage in prohibited conduct?
Thank you for the question, sir. I would say unequivocally no. There's no consideration from the vast majority of people who ultimately end up in court about what the mixture is, what the weight is. Those are not considerations that are taken on a day-to-day basis. And in my experience, the majority of people caught up in our criminal justice system are there out of drug addiction, substance misuse. They're there for a multitude of reasons, but it's not carefully planned or executed or weighed out what their actions are ultimately going to result.
Commissioner Wong and then VC May.
Thank you all for being here. POAG's position that you support option one, but you don't take a position on where the level should be drawn, I think underscores part of what we're wrestling with in this option, which is there's kind of two components of it. One is whether there should be one uniform level, which I think there's some broad agreement on, but differing views and differing commentator views on where that level should be drawn. And so my question is really for PAG and TIAG and SIAG, who did take the position that you support option one and came out at a particular threshold level. To what extent are the advisory group's support of option one contingent on that being the threshold level? In other words, do you still see a value that may be worthwhile in the uniform single threshold, even if the commission were to come out differently on the threshold? If you can answer that.
I'll take a first crack. We would certainly not support a unified threshold that raised sentences as it would occur if they were all set to actual. And that's in part because I think what the data demonstrates and what the commission is seeing from a lot of the stakeholders, and in particular the judges, is that it's not just a matter of uniformity. It is also a matter of severity. There is, as Judge Chang was pointing out this morning, a real minority of cases that are being sentenced within the guidelines range. And so I do think it is both an issue of uniformity and severity.
On behalf of TIAG, we did not discuss this as a group, so, and we also I did not conduct a survey as to the various Indian country jurisdictions and where drugs were being tested and where drugs were not being tested. I would largely agree with Mr. Patton. I think that TIAG would be unlikely to support option one if everything were set at meth actual, because there is not just a uniformity interest, but also an equity interest. And, as I mentioned, as somebody who practices in a jurisdiction where drugs are pretty uniformly not tested, this would be a very dramatic increase in sentencing for the Indians in Indian country, at least in the jurisdiction in which I practice. It would be a negative transformation for a population group that generally does receive downward variances in the instances in which they are able to engage in post-offense rehabilitation, drug treatment, and show a measured commitment to change.
And simply stated from SIAG's position, I would agree that although this was not specifically discussed, I could say from our discussions, it could be easily inferred that the consensus was that meth sentences are already very high. And as we heard from the judge earlier, many of the districts are recognizing that in the same way that we have, that these sentences are high. And we would strongly suggest that they need to come down. So we would want, if option one is the preferred option there, that those sentences remain at the actual level.
Easy, mate.
Thank you. And thank you all for being here today. I appreciate all of your efforts. This is actually a follow-up question to Judge Restrepo's question to Mr. Clausen, and maybe this goes to everyone, but I've been looking recently actually at deterrence research in general, and I'm wondering if anyone can point me to any research that shows that the type of marginal increases we're talking about in connection with the proposed fentanyl enhancements has a deterrent effect. If anyone has any research, and I guess And if not today, later, I would appreciate seeing anything. Thank you.
Oh, yeah, I thought you had a follow. Okay, go. Did you have another? Okay. Commissioner Murray, I'm sorry.
I had a question for Mr. Patton about pill presses. There was an interesting kind of aside kind of argument in your letter about legitimate uses of pill presses and how there might be proof issues because there are legitimate proof uses of pill presses. This is just like a place of ignorance for me. Are there like plausible when we're in a preponderance world? Are there like plausible reasons that people, like non-drug related reasons that people may use pill presses?
So I will admit I'm personally not familiar with them, but yes, we had members who discussed it, and I'm gonna have to get back to you on the details of that because that didn't come from my own personal experience.
Thanks.
I have a couple of questions. I know, Mr. Patton, you represent people who have been accused of these drug-related offenses, meth including, and I know that the offenders were talking about if you peg it to an amount, peg it toward the powder cocaine, which I believe would be less than the mixture, and I think a lot of people have said mixture. What about the sentence that might be pegged to mixture versus okay? Does that sort of reflect more seriousness or what?
I think that falls into the category of we didn't dare to dream. We were really responding to the specific proposals that the commission had set out. I do think, going back to the severity point, it would be good of the commission to set it at an even lower level, and based on the experts that you heard from and the harms, the equivalence of the harms for the various substances, that an equivalence to powder cocaine makes a lot of sense. I think at the time we were generating our comments, we were looking at the specific proposals, and the lowest proposal that was specifically mentioned was the mixture.
And follow and a different question from Mr. Clausen, because you're the only one on this panel, at least, who could talk about this. But you know, we've been talking about either incrementally months, the difference between a month in prison, a year. You served 20 years with the expectation that you would serve 213. I sentenced a 51-year-old. He was facing a matter. His guideline range was 360 months. So if I chose the guideline range from 51 to 81, he would be in prison. Tell us, I mean, you know, the difference between your first day going there, your 10th year being there. What is it like?
Excellent question. So people often ask me what it's like to live with a 213-year sentence, which seems pretty incomprehensible. And whenever someone would come into prison, because I ran A&O and I tried to get people off on the right foot, make sure that they were utilizing their time in a positive manner, they almost felt guilty telling me how much time they had, whether that was 6 months, whether that was 6 years, because my sentence was so extreme. What I learned from that experience was, to every single person who receives a sentence, no matter how long it is, it's significant. It's significant to that person. It's significant to their family, to those who have children, to those especially who leave those people behind on the outside, because they are directly impacted as well. And that's a part of this that is not often considered. We're here talking about a sentence as if it's this thing when there are people on the other side of it. And if I can express one thing, it's the human impact. And I believe that's my role here, right, to represent those people who are receiving these sentences, how they will have to manage however much time they receive, and how their families will cope and adjust without them. Those are the ripple effects, right? So when we talk about increasing sentences, personally, I'm always going to urge caution because this is the punishment. The base level time that we impose based on Congress's laws, like that's the minimum threshold that we have said is required for justice. When we start increasing that time for whatever additional factors, I would say we all need to be extremely cautious because of those far-reaching effects. So if I could speak to the time in any particular way, for me, that was my greatest experience over 20 years. I had the opportunity to deal personally with a lot of people, literally thousands of people, who are directly impacted by the decisions that we make right here.
Any additional questions from this group? Thank you so much and appreciate your testimony.
Thank you.
At this time, I believe we're slated for a 15-minute break, and we're right on time, actually. Well, I'm looking at that clock. I think it's different from our clock. But we'll take a 15-minute break. our fourth panel, which will present perspectives from our stakeholders on proposed amendment on economic crimes. First, we have Jeremy Sanders, Assistant Deputy Chief of the Fraud Section of the Criminal Division of the Department of Justice. Second, we have Michael Caruso, currently an Assistant Federal Public Defender for the Southern District of Florida, and whose many years of service with the defenders include chairing the Federal and Community Defenders Sentencing Guideline Committee. Mr. Sanders, you may proceed when you're ready.
Judge Reeves, Commissioners, good morning. First, let me thank you for the opportunity to share the Department's views on the Commission's proposed amendments to Section 2B1.1. As set forth in greater detail in our written submission, although we appreciate the Commission's goals with respect to this guideline, the Department has some concerns with some of the proposed economic crimes amendments. Although we support the creation of a specific offense characteristic to address non-economic harm, the Department opposes the proposed revisions to the loss table in Section 2B1.1, as well as the suggested reductions for claims of duress or coercion and post-offense remedial conduct. Our opposition to many of the Commission's proposed economic crimes amendments stems from the concern that the proposed revisions would result in an unwarranted reduction in sentences for white-collar offenders, in diametric opposition to the Department's mission to combat fraud and related economic crimes by appropriately punishing those who were responsible for such offenses. Indeed, white-collar criminals disproportionately stand to benefit when these proposals are taken together, particularly in conjunction with the recently enacted zero-point offender reduction. That risks returning us to a world that prompted the Sentencing Reform Act and the guidelines themselves when Congress expressed concern that economic crimes were not being appropriately punished. While I'm prepared to answer questions about any of the Department's comments on the proposed economic crimes amendment, I'd like to focus my comments this morning on the proposed revisions to the 2B1.1 loss table and two of the three proposed specific offense characteristics. Given the time limitations, I plan to directly address the proposals related, I do not plan to directly address the proposals related to sophisticated means and post-offense rehabilitative conduct, but rather defer to my colleagues from the Department, Amanda Rydell and William Voigt, who will be addressing those topics later during those specific panels. First, like the Criminal Law Committee, the Department opposes the Commission's proposal to restructure the loss table by reducing the number of categories into which economic loss is divided. When combined with the Commission's proposed inflationary adjustment, which the Department also opposes, the widening of the bands in the loss table would result in an offense level reduction for 2/3 of offenders, with 20% of those receiving a 4-level reduction. Reducing the advisory guidelines range for a substantial number of defendants convicted of economic crimes is the wrong message to send. The Department also has concerns that the Commission's proposed amendment to the loss table would not adequately distinguish among those convicted of economic crimes. For example, the widened bands would treat an offender who causes just over $250,000 worth of loss the same as an offender who causes up to $1.5 million worth of loss. Nor does the proposed restructuring meaningfully advance the goals of reducing the court's fact-finding burden or simplifying the application of the guidelines. Judge Chang noted this morning on behalf of the CLC that district courts are already required to calculate actual loss when calculating restitution, which is usually mandatory for economic offenses under the MVRA. Thus, widening the bands will not substantially reduce litigation or the need for judicial fact-finding. Turning to the proposed specific offense characteristics, the Department is pleased to support the Commission's proposed amendment to increase the offense level for economic crimes that also result in substantial non-economic harm. The proposed amendment will appropriately account for non-economic harm in identity theft and healthcare fraud cases in which the damage inflicted goes far beyond financial loss. For example, this proposed amendment would appropriately account for non-economic harm suffered by individuals in many healthcare fraud prosecutions brought by the Department. In those cases, the victim for purposes of the guidelines is usually the federal healthcare offense, which suffered the financial loss from either claims that were not provided or claims that were not medically necessary, excuse me. However, the individual patients may experience psychological harm or emotional trauma in the course of the fraud. They may, for example, receive unnecessary medical treatments or may be suggested to living in unsafe environments, as is in the case of the sober homes cases that have been prosecuted recently by the department. The department does not share the concerns of the federal public and community defenders that the proposed specific offense characteristic is vague and difficult to define. To the contrary, we think the non-economic harms this proposed amendment is aimed at covering are identifiable harms. And in response to those concerns expressed about over-application, the department believes the word substantial does significant work to avoid overreach and cabins application of the enhancements to appropriate cases. I welcome the Commission's questions.
Thank you, Mr. Sanders. Mr. Caruso.
Good morning, Chair Reeves and Commissioners. Thank you for inviting me to speak today on a guideline that has long concerned the defenders.
Make sure your microphone is on. I'm sorry. There you go.
Thank you for the
No, it's off again.
What's happening? We're going to talk about sophisticated means later, but this is not a. This is a very sophisticated sound system
on how to do it.
So thank you for the opportunity to speak to you today on a guideline that has long concerned defenders. I recently saw a clip of a congresswoman from Los Angeles who said at a House hearing that Los Angeles was the fraud capital of the country. I'm more than happy to let her claim that title for her district, but I think the data show that the Southern District of Florida may have the edge. In the course of my career at the Federal Public Defender's Office, I've handled nearly every type of economic crimes case. When I was a younger AFPD, I had clients who were accused of stealing mail out of mailboxes. In the later stages of my career, I represented a CEO of a hedge fund. The Southern District of Florida annually leads the country in trials, so many of these were not resolved by plea, although most of them were, but we've had many, many trials involving these issues. While not every defender may have had my specific experience, I think we've all had the same general experience that 2B 1.1 is fundamentally broken. And that's a conversation, that I think we want to start having today in light of the Commission's, sustained attention to these issues. We think these proposals are a step in the right direction for the most part, but they're a significant step backwards as well as we'll talk about. The first matter I want to talk about is regarding, the inflationary adjustment, which I think there's, with one notable exception, there's widespread consensus that should apply. With regard to the loss table, we believe that reducing the number of loss categories is long overdue. The current 16-tier structure forces courts into burdensome, time-consuming fact-finding over, small differences in dollar amounts that carry no real relationship to culpability. We think wider bands would likely reduce litigation, better reflect the inherent imprecision of loss calculations, and really focus the sentencing court on what the person actually did, not an arbitrary dollar threshold. But where we part ways with the Commission is that your proposal pairs this simplification with 4-level increases between categories. We think that the cliffs that would occur with regard to 4-level adjustments are inconsistent with proportional punishment and will simply shift the litigation to those new thresholds. We recommend 3-level increases instead, and we think the data support this. For the last 4 years, 56% of 2B 1.1 cases resulted in below guideline sentences. And in the highest loss cases, the average imposed sentence was roughly 35% the guideline minimum. And you'll see from our submission, the chart we have on page 2, that the divergence between the guideline minimum and the actual sentence imposed doesn't really start at the very high levels. I think you can see a significant difference even starting at $250,000, which is important because now the median loss is $210,000. So like right from the start, the guideline doesn't seem to be to working to that extent. We also urge the commission to restructure the loss bands around 25% quartiles. Essentially we took Judge Newman's suggestion that judges, and I can say on behalf of practitioners, when we get a case, we generally try to gauge, is this a small, medium, large, or extra large case? And that's how we think about these cases. So as we have a conversation about how to reconstruct 2B 1.1, I think that's an idea that's worth considering. We strongly oppose the non-economic harm specific offense characteristics for a number of reasons. Unlike the Department of Justice, we do find these terms very vague, and we do believe that they'll act as automatic enhancements in nearly every case. These harms are captured not only by the loss table, but other specific offense characteristics as well as Chapter 3. And of course, it goes against the Commission's the simplification efforts from last year. With some hesitancy, we also oppose the mitigating specific offense characteristics that you've proposed. And again, we believe that the language that the Commission has proposed is unnecessarily cabined and will not reach very many cases. Especially if you compare the language that the Commission used with regard to the mitigating SOCs as compared to the non-economic harm SOC, you can see how that difference in that language actually might result in a net loss to defendants who are sentenced under this guideline, throwing an already broken guideline further out of whack. I'm happy to answer any questions that you have. Thank you again.
Thank you, Mr. Caruso. Open it up. Yes, V.C. Restrepo and then V.C. Murray.
Mr. Sanders, is it Sanders or Saunders?
Sanders.
Sanders. Could you elaborate a little bit on the department's opposition to the inflation adjustment? I mean, you folks seem to be an outlier on that one issue. I'm curious as to why.
Certainly. I think our response is twofold, as we said in our written submission. The first being Congress makes a determination as to whether with certain criminal offenses, whether those amounts are going to be indexed to inflation, and has decided by and large not to do so. And so we think similarly not indexing or adjusting for inflation, the guidelines 2B 1.1 table is appropriate, because otherwise it would put it in sort of an inconsistency with it. And the second thing that I'd like to point out is just simply, as I said in my opening comments, the result will result in a substantial reduction for criminal sentences, particularly for white-collar offenders, but across all offenses, if the adoption is adopted along with some of the similar and recent amendments, including the 0-point offender reduction.
Yes, V.C. Murray.
Thanks to both of you for being here. I have a question for both of you, which is, I wonder if you can do a kind of thought experiment and divorce in your mind any severity change from the widening of the bands in the loss table. Does that change for either of you the position? Say we were able to calibrate it in such a way that the mine run of cases stay the same, or an average cases stay the same in terms of severity. Does that change your position on the widening of the loss bands?
I don't know if I totally understand the question, how it wouldn't change the severity.
Well, so obviously, there's two parts to the amendment. One
Right.
is deleting half of them, and one is what number you have bracketed here. Right. And you say you could change the number in these brackets such that, on average, people were, obviously some people would change in each bracket, but you were centering the first two levels around whatever the average of these folks would be, in such a way that the average guidelines range, or at least offense level, was going to be the same, or on average the same for defendants.
Well, I think if you divorce the proposal from any severity concerns, I know Judge Chang and Mr. Sanders had raised this regarding the fact-finding And so I'd like to give you a definitive answer on whether fact-finding would stay the same or be reduced. And if this is a thought experiment, I would say that it's likely to be reduced. So for example, obviously, if you reduce the number of loss bands, you're reducing the number of instances where people would argue around the margins, obviously. You know, that being said, if the commission stays with 4-level increases, because that is such a steep increase or decrease depending on what side of the aisle you sit, I think the litigation will tend to be more intense because there's a larger swing. So when you look at 2B 1.1, there are a lot of moving parts, obviously, right? You have the loss amount, you have the 20 SOCs, you have Chapter 3. When a person goes into court to advocate for a sentence, again, on either side, you're mindful of the amount of time the judge wants to be in court, litigating these issues. So if you don't have a very strong argument around the loss band, you might focus on other matters. Sophisticated means we'll talk about later, is one of those. But if you have a 4-level swing, you're not going to sort of give that argument up.
It's hard to see what the severity neutral way to smooth the cliffs is.
Right. Well, you can obviously keep the +2 with the reduced bands, and I think that would smooth that out.
Right, but that wouldn't be severity neutral if you're
Right.
developing. Right, exactly.
I also am not entirely sure I understand the concept of lessening the severity of the bands, but if I do understand your question appropriately, I think I agree with Mr. Caruso that you're shifting the litigation to those cases that are going to be at the margins. And so there will still be a significant amount of litigation for those people who are, going from one level to the next, particularly if there's a 4-level adjustment. I also think there's still a conceptual problem the department has with treating a $250,000 loss as equating it with 1.5 million, and similarly to other levels like that. So I don't think that any effort to adjust the severity, as you say, will address the problems that the proposed amendment has.
Thank you both for being here. I really appreciate it. A follow-up on that sort of question. One of the other things I was wondering about, and I don't know whether anyone's had a chance to discuss it, is there's all of our proposal and the comments we received suggested that if we were to make adjustments there, that the increases in each of those things would stay the same. It would be 2 or 3 or 4. Did you think or talk at all about whether that should change for those different buckets? Like if you got to the extra large bucket, should that one, maybe be a bigger increase than you might be looking at for the lower loss amounts? Or
in other words, if I understand you, for something that causes a $65 million loss, that might be +8. For something that causes a $16,000 loss, a +2.
Correct. That's my thought experiment.
We certainly, the department certainly hadn't considered that because it was obviously part of the proposal. So I don't know that I have any particular comments on that.
Having seeded the field, I'll take a crack at the question. I think, although defenders have not spoken about that specifically, I think conceptually, giving larger increases at the high end again would break even more a fundamentally broken guideline, because again, if you look at the chart that we put on page 2, that when you get to the higher loss amounts, judges are varying down significantly, in terms of years and years. So if you're pushing those higher end sentences up by even more levels, I think that is, either judges are going to be departing at the same variance rates or even more.
Just to follow up on the line of questioning or your comments about the fact-finding burden, I think from my experience, when I've seen some of these fraud cases, at least if they're measuring actual loss under the guidelines, are also going to trigger restitution obligations, some of which are mandatory by statute. The judge has to do those. How much, if we're trying to if reducing the fact-finding burden of courts is something the commission is interested in, how much should the commission be considering that the judge is going to be calculating guidelines alongside other loss amounts for restitution purposes?
I think very little is my answer, for two reasons. As commenters have already pointed out today, the actual loss amount is not always the same as the restitution amount. And it's been my experience in practice that restitution is very rarely litigated. Like, as you know, most cases resolved by plea. I think the circumstances where a person agrees to plead guilty and then contests restitution are very rare. Under the guideline system, the person may be putting acceptance of responsibility and other, issues before the court. But even when cases go to trial, what ordinarily happens is that a person is sentenced, any restitution hearing is deferred for 90 days. And then, again, almost invariably, the parties stipulate to a restitution amount before the district court judge. I'll tell you an example. I'm handling an appeal currently. There was a restitution matter outstanding when I was appointed, so I had to handle that in the district court. We disputed restitution. We appeared in front of a senior district court judge appointed by President Clinton, who said it was his first contested restitution he's ever had. So I think that concern should not give you pause at all.
Oh, go ahead.
Unsurprisingly, we have a different view. I mean, perhaps from where I'm seated in the appellate world, I see a wide number of cases where restitution is contested. Obviously, some of those cases are ones that have went to trial, but I do have other cases where they are contested as part of a plea, where we leave open the restitution amount for sentencing. So I do think there's going to be those occasions for district judges that are going to have to determine restitution under the MVRA, and it is going to require a painstaking fact-finding mission that would just as easily have to happen if there was an intended loss calculation.
I have a brief follow-up.
Yes.
Yeah. So with regard to the restitution piece, and to the extent that you want to consider this, it does seem that the Supreme Court is poised to hold that restitution is subject to apprendi. And so then again, if a jury makes the determination with regarding restitution, there'll obviously be less fact-finding for the district court judges.
I have a couple of rapid-fire questions, I think, for the Department of Justice. I know it appears that you seem to agree that 2B1.1 should be simplified. I guess my question is, how?
We have agreed or to support the Commission's recommendation to reduce some of the lesser used enhancements, but in particular with respect to offense from the person, and one of the ones that applies an offense level for particular statutes. We do oppose the exclusion of those in the business of selling property offenses for the reasons put in our submission. But so we do see there's an effort to simplify by removing those uncommonly applied characteristics. I think another way, it may add more words to the commentary and may increase that a little bit, but we also support the instances of, as we said in our submission, if defining loss is so difficult, there can be further examples like there are with Ponzi schemes, like there are with federal healthcare offenses and things like that, to give greater detail to district judges. So again, it may increase the book, but it does simplify, have the effect of simplifying, I believe.
And Mr. Caruso, for you, thank you, I'm sorry. And for you, I think the FPD recommends that the floor be 15,000, change the floor from 15,000.
26, I think, with an inflationary adjustment.
How did they come about that particular number?
So I think we were trying to follow what the commission did with determining sort of the heartland of sort of small, medium, large, and very large cases, trying to get them grouped. But at the end of the day, and when we point this out in our submissions, I think when those levels were first established, the median fraud loss was very, very low. I think around $17,000. Now it's $210,000. So that's another reason to raise the threshold.
And I guess finally, when we talk about you mentioned that the wider bands and most fraud seem to get the variances or whatever at far more frequency and much more levels downward. Might that be because those who have access to committing that type of fraud be like a person like your CEO of a hedge fund, and that person who's standing before the judge is not the drug dealer or the one person who's...
Yeah, well, because we're on camera, I'll take the opportunity to say the CEO of the hedge fund was acquitted by the jury. But I do. I
was wondering why you were representing the CEO of the
right, because he was innocent. But no, but obviously in the high dollar cases, I think you do see greater variances again by the piling on effect. The loss amount, the specific offense characteristics, the Chapter 3 adjustments. I was talking to Mr. Sanders before the hearing. He had participated in a case in Miami at the same time I was participating in another economic crimes case. This person was the CEO of a pharmaceutical company. He was convicted by the jury and had to appear before the judge in sentencing. And so he wound up receiving a 30-year sentence by the district court judge. This was a function, of the loss amounts, a few specific offense characteristics, a Chapter 3 role adjustment, and he received a 30-year sentence in prison. At the same time, the Department of Justice was prosecuting a person who was accused of submitting fraudulent billing of over $1 billion in a healthcare fraud scheme. He was convicted by the jury, and the judge gave him a significant variance to 20 years. So I think, and then President Trump later commuted his sentence. So I think district court judges who either take a plea or preside over trial do see how these very high value cases bear no relationship to a person's actual culpability. That's not saying they're not deserving in the district court judge's mind of a significant sentence. It's just that the guidelines don't reflect what they believe is the appropriate sentence.
I'm sorry, I have one more. Because nobody's mentioned the ABA task force thing, I don't think. And they've studied this for a while. What is right or wrong about that particular approach, as it should inform us how we are to proceed?
So I think, I'm not here to say what's wrong with it, because my memory of that proposal, is vague on that point. But I think what's right about it, and I think this gets to what Judge Restrepo's question to an earlier panel is how do we focus on culpability? Like various judges over the years have submitted, comparisons, what's worse, a person who steals $1 from 1 million people or someone who steals $1 million from one person. And so I think that's where the defenders want to work with the commission on a comprehensive overhaul of 2B 1.1 to focus more on how to advise judges how to sentence, focusing on culpability, factors like motive and intent, how long the person was involved in the offense. Were they the initiator of the offense? Were they recruited into the offense? All these role issues. Well, we'll talk about this afternoon with regard to the sophistication of the offense. Whether the defendant was the person who created the sophistication or was just taking orders to fulfill the scheme on behalf of the higher ups. So that's what is monumental about the ABA approach. that they're focusing on individual culpability rather than sort of artificial loss thresholds.
I think I would just briefly note that one of the ways where I think I would diverge from my friend on the other side here is the department doesn't view the 2B 1.1 loss table as a broken system. Although there are difficult decisions that have to be made by judges in terms of fact findings in particular cases, the overall approach and layout of 2B 1.1 is rather easy. You determine the loss amount. There's a specific offense characteristic for that. You determine whether it's sophisticated means, whether that's now going to be in 2B 1.1 or in a Chapter 3 adjustment. You adjust it for that. A number of victims, all those other specific offense characteristics. I don't have specifics about the ABA's proposal, so I'm not prepared to go into that, but if there's a specific proposal that you'd like me to comment on, I'm happy to.
Thank you all so much for bearing with me. I appreciate it.
Thank you. That's it.
All right, you're excused, Mr. Caruso.
I don't get up until the judge tells me to get up.
Before lunch, we'll present the practitioners' perspectives on the proposed economic crimes amendment. First, we will hear from Abraham Ryan, our Third Circuit representative to the Practitioners Advisory Group. He is the chair of the White Collar Defense and Investigations Practice Group and the Data Privacy and Cybersecurity Practice at Post and Shell PC. Second, we have Barry Boss, who is a co-chair of the Commercial Litigation Department at Cozen O'Connor and a former member of the ABA Criminal Justice Section's Task Force on the Reform of Federal Sentencing for Economic Crimes. Mr. Ryan, please start us off.
Thank you, Chair Reeves, and thank you, members of the Commission, for having us here. It's a privilege. First of all, add us to the group of folks, the Practitioners Advisory Group, to the group of folks who support the inflationary amendment and see no reason why it shouldn't happen on a regular basis. Putting that aside, I have basically 3 high-level points I want to make about the economic crimes guideline. Point number 1, at a high level, is simply that the PAG continues to be of the view that that it has maintained, going back at least a decade and a half, and I think probably further, that allowing the economic crime guidelines to be driven as heavily as they are by the bare loss number, this difficult concept that can mean a variety of things. It can mean actual loss, it can mean intended loss, it can mean gain, which everyone agrees is hard to calculate and which many of us agree isn't really appreciably tied to culpability. Allowing the economic crime guideline to be driven the way it is, to the extent that it is, by loss is a mistake, and the whole guideline should be revised. That's point number 1. I won't dwell on that further unless, of course, the Commission wants to hear more from me on it. The other 2 high-level points I want to make are fairly straightforward. We have a proposal on the table that has 2 parts. The first part would simplify the loss table by removing half of the tiers, and we're in favor of that idea. We generally favor simplifying, and we're in favor of it in this instance with some additional nuance, which I'll get to momentarily. That's point number 2. And then the third high-level point is part 2 of the proposal that's on the table would add various culpability factors, some enhancements, some reductions. We're opposed to all of that. We think it's contrary to the mission of simplifying things, and so we oppose it. And for clarity, that goes for both the enhancements and the reductions. Now, let me rewind to point number 2, which had to do with simplifying the loss table by removing half of the bands, and give a little bit more detail on our view on that. I'm here on behalf of the Practitioners Advisory Group. We represent practitioners. The perspective that we offer, among other things, and this is shared by many of the other advisory groups, but we offer the perspective of folks who deal intimately with clients whose lives and the lives of their families and the lives of their loved ones are going to be defined by a decision that's made in a courtroom that's going to be driven profoundly by the guidelines. So speaking from that perspective, we're generally in favor of simplifying. Making them simpler means making them easier for everyone to apply. Courts, obviously, lawyers on both sides, obviously, probation, victims, and the defendants themselves. And we think that's important. Defendants need to be able to follow the sometimes perhaps seemingly arcane calculations that professionals will be applying that's going to impact their lives so profoundly. Simplifying also means fewer opportunities for error. And as we've talked about a fair amount already today, it means easing the fact-finding burden associated with sentencing. And when I say the fact-finding burden, I mean that goes for courts, but it also goes for parties and lawyers, the people who are the individual defendants and victims, and also their lawyers and the courts. And I think everyone has slightly different considerations in terms of the fact-finding burden. So with that perspective, it seems to us that removing half of the tiers is a no-brainer. If the goal is to simplify and to ease some of the fact-finding burden, taking away half of the tiers means removing half of the hard cases where we really have to fight. The litigants really have to fight over what's the loss amount. The obvious drawback to this, as has been alluded to already today, is that the proposal as written introduces these incredibly high sentencing cliffs for levels at each tier. And to put a little meat on the bones of what that can mean for a specific defendant, take defendant 1 and defendant 2, who are exactly the same in every way, except that defendant 1 has a $95,000 loss, defendant 2 has a $96,000 loss. That 4-level difference can mean the difference between a Zone B guideline range and a Zone D guideline range. That's meaningful and it matters. So there's an obvious easy fix to this, which we support, which is rather than bumping up the levels by 4 at every tier, bump up by just 2. I will stop there. I see my time's out, but I'm happy to answer any questions.
Thank you, Mr. Ryan.
Thank you, Chairman Reeves, and thank you, Commissioners. I appreciate the opportunity to be here today. I should say also I'm here on behalf of Jim Fellman and David DeBold. We submitted our statement together. We're all former co-chairs of the Practitioners Advisory Group, and we've been focused on 2B 1.1 for an extremely long period of time. And so we welcome the opportunity to present our perspective to the current commission, and we are so happy to see the commission focused on 2B 1.1. We agree with what many have said, that there's a widespread recognition among the practitioners and the judges that 2B 1.1 is flawed. And the reason that it's flawed is the overemphasis on the loss amount. And we appreciate what the commission is doing by trying to account for inflation. That's certainly a positive step. But the overemphasis on loss in the guideline calculation results in the guideline itself being unworkable in terms of providing for a fair and just sentence. We support an approach that incorporates loss, but also factors beyond loss into that guideline calculation. Chairman Reeves mentioned that ABA task force report, which we believe provides the right structure for the guideline. It has only 3 specific offense characteristics: the loss amount, culpability, and the victim impact. And the culpability, which is what is missing from the present guideline, is something that accounts for the motive of the person, the degree of sophistication, the duration, the efforts to mitigate, which I know the commission has looking at in its current proposed amendment, and the extenuating circumstances also, which the commission's considering in its current amendment, things like family, coercion, and things of that nature. The idea is to distinguish between the predatory defendant, somebody who goes in with the intent to steal money from vulnerable victims, versus somebody who maybe just gets into something over their head. They had a positive mindset in going into it. They did it with good faith, but circumstances resulted in them doing something like underestimating the value of the collateral that they were using as security for a loan. Also somebody who, one of the examples that we provided is somebody who provides oxygen to people who need it. Turns out the oxygen was fine, but the person didn't get certified by Medicare. There was no harm to anybody, but the loss was substantial. That person should be judged differently than the Madoff type who goes into a Ponzi scheme with the idea of stealing from people. The current guideline, but just relying on loss, doesn't allow for those kinds of distinctions. And so we believe that the way the task force approached it was the right way and something that the commission should consider. We're not talking about necessarily about a reduction in sentences. We're talking about a different way of determining the sentence. In fact, in the ABA proposal, the predatory defendant winds up with a more severe sentence than they would under the current guidelines. It's about how we get to that result. And I know, I believe it was Commissioner Mate asked about deterrence. The one thing that we've seen in the studies, and this is something that we rely on consistently in our sentencing memos, is what matters for deterrence is the certainty of punishment and going to prison at all. The length of the prison, according to all the studies I've seen, doesn't have any impact on a deterrent effect. So we believe that we should move away from the scattershot specific offense characteristics into a more simplified guideline that more fully accounts for somebody's culpability. Thank you.
Any questions of this panel?
Mr. Boss, I understood you to suggest that we capture culpability looking at the individual defendant as opposed to just the loss, correct? Then how do you reconcile that with moving away from specific offender characteristics? How would we capture culpability?
Well, that would be what we proposed was a three types of specific offense characteristics: loss, culpability, victim impact. So culpability is just the specific impact with a variety of factors, the ones that I mentioned.
Which are specific SOCs, right?
Right, exactly. Well, no, the specific factors wouldn't be SOCs. They would be commentary describing how you would put somebody into a culpability level. And they would start with the lowest culpability, which was, in our view, I think, -6 points, low culpability -3 points, moderate culpability, which would be the presumptive place everybody would be, and then high culpability +3, highest culpability +6.
And we do that by way of commentary?
Well, no, that would be the specific offense characteristic under culpability. You would have lowest, low, moderate, high, highest. The commentary would give the judges some guidance as to where you would put somebody within that category. So, for example, the predatory defendant would be somebody who would presumptively be in the highest culpability category, whereas somebody who didn't intend any loss would be in the low or the lowest. In our view, the defendant would have the burden of proving a decrease, low or lowest. The government would have the burden of proving the higher, so high or highest.
Thank you.
Any of this, VC Mate?
Thank you both for being here and for your written testimony and your remarks today. I have a question for you, Mr. Boss. I think because in your testimony you kind of walked through those examples and whether they would change under our proposal versus the changes that would happen with the ABA proposal and comparing to the current guidelines. And I was curious whether, in light of that analysis, there's anything on the table in our amendments this year, or on the table in our amendments this year that like variations on it, like PAG's proposal to do the 2-level increments rather than the 4, the defenders to look at 3. Whether any of those are worth considering this year, or whether your view is just wait, like really do a complete overhaul. So I was just interested in your thoughts on that.
Well, I appreciate the question, and I don't want the perfect to be the enemy of the good. And I do think that changing the table to account for inflation, especially if you do it at the 2 levels as suggested by the Practitioners Advisor Group and by the defenders, I think that's a very positive change. And I wouldn't want to stand in the way of moving forward and making progress, but I would hope that that could be a first step into looking at a broader overhaul of the guideline.
One follow-up on that, that's very helpful. Do you think the widening of the bands, in addition, that even wider than what we've proposed, which I think was suggested by some commenters, would be a helpful step in that effort, or is that less important than the kind of?
I think the widening, I think the fewer categories, the better, but the critical question is how much of an increase are you going to have between categories? Because you do have the cliff problem once you start decreasing the categories.
Thank you.
Anything additional from this esteemed panel right before lunch? I'm so sorry. Somebody had to get there.
We just appreciate the opportunity to be here.
No, thank you all so much for your testimony. We really appreciate it.
Thank you.
Thank you.
We're now going to take a break from the lunch for 55 minutes, since I've gone, instead of 1 hour. So let's be back in about 55 minutes. Thank you. Welcome back. Our 6th group of panelists will provide us with our advisory group's perspectives on our economic crimes proposed amendment. First, we will hear from Joshua Luria, Chair of the Probation Officers Advisory Group. Mr. Luria is an Assistant Deputy Chief Probation Officer in the Middle District of Florida. Next, we will hear from Dr. Carl M. Reddix, the chair of our newly formed Sentence Impact Advisory Group. Dr. Reddix was sentenced to 72 months in prison after pleading guilty to bribery. He is a retired obstetrician with over 30 years of practice and is currently a physician providing public health interventions to vulnerable populations. Third, we will welcome back Jamie Johnson, who will provide us with the perspectives of our Tribal Issues Advisory Group. And finally, we will hear from the chair of our Victims' Rights Advisory Group, Mr. Christopher Quaisbarth. Mr. Quaisbarth is a senior staff attorney for the Maryland Crime Victims Resource Center. Mr. Luria, you can kick us off.
Thank you for the opportunity to share POAG's perspective on the proposed economics crimes amendments. POAG is split on the proposed changes to the loss table. This amendment could cause circumstances wherein there are less challenges to the process when the loss clearly falls within the range. However, the courts must still make a finding of fact about loss, which is often challenging given the need to extrapolate from complex or incomplete records. While the broader ranges may create circumstances that reduce the intensity of disputes, there is concerns that those cases which fall close to the cusp between tiers may end up being strongly challenged with a more significant outcome. We are also concerned that the expanded ranges will remove meaningful distinctions between the loss amounts, reducing opportunities for more gradual incremental punishments. On the other hand, this may also reduce some arguments about the difference between actual and intended loss, creating fewer instances where intended loss would push the loss amount into a higher range. Further, we are concerned that the lowest tier may leave individual victims who have experienced less than $15,000 in loss with a perception that their losses are unimportant. We are in favor of an enhancement related to substantial non-economic harm. However, we believe that definition and examples of psychological harm, emotional trauma, harm to reputation, and invasion of privacy interests are necessary to provide guidance on how to apply this enhancement with consistency and reduce disparity in application. For example, there may be instances when a victim reports having suffered emotional distress but did not seek professional counseling, maybe even because the victim was indigent. In such a case, there may be disparities if a victim's statement alone is insufficient to apply this enhancement. If the intent is to focus on harm to individual victims, not just government, business, and corporations, then we suggest an increase on this basis. Quote, if the victim of the offense was an individual, increased by 2 levels, end quote. We also suggest considering whether these victim considerations should not be relocated to Chapter 3 with other victim-related adjustments. We are not in favor of the proposed Section 2B1.1b22 related to motivation considerations. The concerns about this approach revolve around fact-finding and whether the probation office must rely on the defendant's uncorroborated statements as to subsections A or B. It is really hard to make a determination as to whether the defendant did or did not experience fear. Additionally, subsections B and C appear to capture similar considerations taken into account for mitigating role. We also do not support the proposed Section 2B1.1b23 reduction related to withdrawal, restitution, and voluntary secession. POAG noted that it is rare to encounter this type of defendant. If they have all 3, they probably have been diverted from prosecution. If they have 1 or 2 of the 3, courts consider it as a mitigating factor through a variance. With regard to subsection B, making a good faith effort to return money would be a better approach as well. It allows individuals of different levels of means to be considered rather than just those who have the means to return the money and property to victims. Regarding returning property, the property may not be returned in the same condition. A car stolen and returned with substantial damage is still returned. There are other problems with this approach. It is likely that a defendant will request a longer time frame before sentencing to demonstrate their good faith effort, causing delays in the court's docket and delays in providing closure for victims. We also believe voluntarily ceased will likely create application problems. When a fraud is perpetrated against a temporary government program or perpetrated during a temporary window of opportunity, did the defendant cease the fraud voluntarily, or did the opportunity cease to be available? Lastly, the proposed amendment may end up being somewhat detrimental to those defendants who do meet one or several of the criteria. If they have made a good faith effort towards returning the money or goods, but did not voluntarily cease, they would not get a reduction. Additionally, it is our experience that individuals who do engage in even some of these types of efforts often get substantial variances in excess of the levels this reduction would establish. In articulating the levels that the Commission believes this mitigation should be awarded, the Commission may be anchoring these considerations to a level that courts would previously have surpassed, absent the articulation. We believe this is an area of consideration best left to the court through the statutory sentencing factors. Again, thank you for the opportunity to share POAG's thoughts on this.
Thank you, Judge Reeves. Thank you, commissioners. First and foremost, I want to thank you for the establishment of the Sentence Impact Advisory Group. We are a divergent group of individuals from different demographics, both geography, income, and educational attainment. I thought that I was going to be the only nerd in the bunch, and as it turned out, as you heard from Mr. Clausen, we've got a lot of nerds, very opinionated, very passionate, and very communicable about what it is that we're trying to, our mission in helping the Commission. The Commission is considering consolidating the monetary thresholds in 2B 1.1. SIAG supports simplifying the sentencing guidelines so that the average American can understand the potential consequences of antisocial conduct. Clear and predictable standards promote fairness and enhance deterrence. The current sentencing guidelines for economic offenses overemphasizes intended loss. The Commission's proposed inflation and restructured 2B 1.1 loss table would simplify and consolidate loss categories, and SIAG strongly encourages its adoption. In addition, SIAG recommends that loss be calculated using a consistent and objective accounting methodology. Our preference is generally accepted accounting principles or GAAP accounting. Reliance on intended loss is inherently subjective and serves as an imperfect proxy for culpability. Evidence-based sentencing should rely on clearly defined and transparent methods rather than arbitrarily assigned accounting assumptions. Justice is best served when sentencing aligns with actual culpability and the harm caused. The guidelines should promote consistent adjudication of similarly situated defendants across circuits. The current framework fails to account for meaningful differences among categories of the different economic crimes. Data from the 2024 Interactive Data Analyzer demonstrates the resulting inconsistencies. The median loss in bribery cases is $43,700 and an average sentence of 20 months. The median loss in theft and property destruction cases is $210,000 with an average sentence of 22 months. And the median loss in healthcare fraud cases is $2.5 million with an average sentence of 27 months. There's no linear consistency amongst these different economic crime cases. These outcomes indicate that downward departures play a significant role, especially in healthcare fraud sentencing. SIAC's concern is the clear inconsistency in the application of downward departures across the spectrum of economic offenses. While monetary loss is a relevant consideration, it is only one component of accountability. Over-reliance on loss amounts can result in sentences greater than necessary to achieve the goals of federal justice sentencing. SIAG urges the Commission to place a cap on the enhancements of 2B 1.1 at offense level 16. This adjustment would help mitigate the imposition of excessively punitive sentences in certain cases. Finally, SIAG strongly recommends permitting reductions in offense levels where there is little or no actual loss or intended monetary gain. Over the longer term, SIAG encourages the Commission to transition toward a culpability-based framework that accounts for the defendant's role, intent, nature of the harm, and degree of greed when determining sentences for economic crimes. I stand ready to answer questions. Thank you.
Thank you, Dr. Radix. Ms. Johnson.
Yes, good afternoon. Thank you for allowing me to weigh in on behalf of TIAG on this important issue. So this is obviously the loss calculations and the loss tables. It's a very complicated issue. And TIAG does not pretend to have the full access to the full universe such that we can make a concrete recommendation about how this should be amended. We do encounter fraud. It is not one of the more common guidelines that we see. So my goal here today is to just give you a little bit of insight into the kinds of offenses that we are seeing that are covered by the fraud guidelines in Indian country and some of the issues that we are having with them. We, up until 2020, I would say most of the fraud issues that we were seeing in Indian country were government contracting fraud, occasionally Medicare fraud, large dollar amounts, very often arrived at through intended loss, as opposed to actual loss. And very often there would be some degree of services delivered, but perhaps not the full extent that was contracted for, or there might have been fraud in the procurement of government-sized guidelines calculations that were perhaps excessive to the actual damage or harm caused, especially when calculated or when seen in with respect to the gain of the particular person who ends up being convicted of that. And so that's one of our concerns, is that the over-reliance on loss amounts was resulting in excessively long sentences in cases like this. Since 2020 and when McGirt happened, and we now have jurisdiction in eastern Oklahoma, what we are seeing more and more in Tulsa and around there is relatively small dollar frauds that are prosecuted by the federal government for jurisdictional reasons because the state can't prosecute them. So smaller dollar amounts, which are very resource intensive to figure out where they exist on these very small bands that are provided for in the loss tables. Particularly when you consider that sometimes the records that are under consideration may be tribal records that may be old or not particularly reliable. My friend here to the left was talking about generally accepted accounting principles. Tribes are, of course, not obligated to use generally accepted accounting principles or to keep records according to generally accepted accounting principles. And so trying to calculate loss in these very small bands is very difficult and excessively resource intensive, and it's very difficult to figure out where someone lands on this table. And it's unclear that making such fine-grained calculations is really providing a lot of information about how culpable someone is or what the appropriate sentence is. So TIAG we support the inflation adjustments that I believe most people support, and also support larger bands that will hopefully ease some of the burden in doing these very fine-grained calculations on fairly low loss amount cases. I would say TIAG also, and I think this didn't make it into our letter, we do oppose the enhancement for substantial non-economic harm, principally on grounds of administrability. No one seemed excited about litigating this, about who was psychologically harmed, whether somebody was more psychologically harmed than somebody else. And I think particularly in the tribal context, people were very concerned that the judges would have to make cross-cultural assessments of relative harm that were uncomfortable, that they were not well-equipped to make. And it was also unclear how this would be administered, whether a victim would have to come forward and self-report, whether you would have case agents probing psychological harm, and whether they would be equipped to do so in cross-cultural contexts. So that is our position in the on the economic amendments in a nutshell, and I would welcome any questions you have.
Mr. Quaysbaum.
Thank you. Good afternoon, and thank you for the opportunity to speak on behalf of victims. Just in summary, the Victim Rights Advisory Group.
Could you turn on your microphones?
I'm sorry. The Victims Advisory Group does not recommend the Part A restructuring of the loss table. The Victim Rights Advisory Group supports the non-economic harms inclusion in Part B. And as to the Part B mitigating factors, we would oppose subsection 22, but we could support subsection 23 with modifications that we proposed in our public comment, which would have the offenders held more fully accountable. As to Part A, economic crimes are directed towards victims, whether those victims are people, businesses, or government agencies. In every instance, actual people are harmed, whether an individual, the owners or employees of a business, or the taxpayers. We respectfully ask the Commission not to adopt Part A of the proposed amendments. The minimum loss thresholds for each described quintile in the loss table increased tremendously if you were to adopt Part A, and even higher if you also adopt the inflationary adjustments. Increasing the minimum thresholds lowers the deterrent value of the guidelines. The lowest minimum threshold would rise from $6,500 to $15,000 and would cause a two-level reduction for offenders previously in that same range. Combining Part A with the inflationary adjustments would raise the level to $20,000, according to your data briefing. And that would result in a reduction of 2 to 4 levels for 36% of the 848 offenders sentenced in fiscal year 2024. And of course, each of the quintiles increased dramatically as well. In fiscal year 2024, with these proposed amendments, 66% of all offenders sentenced would receive a reduction of 2 to 4 levels. And this is a huge increase that affects victims. Your August 2025 Crime Victims Fact Sheet on economic offenses for fiscal year 2023 identified over 2.5 million persons as victims of economic crimes under Chapter 2, Part B. And your projection is that 66% of those offenders, if we mix fiscal years together, would receive reduced sentences of 2 to 4 levels. And that's just a huge jump in magnitude. The Department of Justice and the Probation Officers Advisory Group also seem to support, for similar and other better articulated reasons perhaps, that the loss table should not be restructured. We do support in Part B the substantial non-economic victim harms. You've listed examples in your proposed guidelines, including physical harm, psychological harm, emotional trauma, harm to reputation or credit rating, and invasion of privacy. We think they are all apt. Your data briefing also indicates, your fiscal year 2023 crime victims data shows that of 1,455 cases, non-economic harms included death, bodily injury, psychological and emotional harms, reputational and social harms, and child pornography. So all of those things could be encompassed if you would include that with the culpability factors. We do agree with the Department of Justice, as they spoke earlier today, that perhaps the substantial non-economic harm should be to one or more persons rather than to one or more victims, as having a broader scope for the reasons they set forth in their public comment. As far as the Part B mitigating factors, we do not support subsection 22. Subsection 23, with the modified language that we proposed, we could support, which would make it more restrictive, making it more of an accountability for the offender, including the payment of monies that were taken or the return of property. I think that Mr. Luria identified a good problem with the return of property. How can we determine that that property is in the same condition it was when it was stolen? But for those reasons, we think that you should go ahead and adopt that, because it requires an accountability from the defendant, which can be healing for the victim. Thank you very much.
Thank you, Mr. Quaysbar. Any questions of this panel? It's teasing a little. Okay, go ahead.
Mr. Quaysbar, how would you suggest we take into the impact on the victim without overburdening victims to kind of prove substantial harm this financial crime may have caused them? Is there a middle ground here?
Well, that's a very good question, and I don't know. I don't know if the data from the economic crimes, the crime victim fact sheet, how things like bodily injury, death, child pornography, how those were identified. Did they just show up in the file from the information that you have? Was that something that was specifically addressed as part of sentencing? I don't know that information. Certainly, if there are 2.5 million victims in fiscal year 2023, there's no way to talk to all of those people. But I think you also identified a smaller percentage of people in the data that you went through, the number of cases that had 10 or less victims. So it may be more accessible for the probation office to be able to contact those people. Certainly, they would have to be willing to want to come forward and to speak and to provide information about the harms that they've suffered. Some victims are willing to do that, others are not. But I think that that is something that perhaps, and I'll defer to my esteemed colleague here from POAG as to whether that is something that they could include. Certainly they work with victims, they talk with victims about these sorts of things, and there could be an accessible way for that to happen.
Mr. Lloyd, I think he just called on you.
Certainly, we have a longstanding effort to connect with victims about the impacts these offenses have on them. Victim impact statements oftentimes touch upon a lot of the issues that are listed there. Where we get concerned about it is in terms of what level of proof and to what degree are you going to create a circumstance where every victim has one or several of those, as long as they're willing to respond. That's kind of why we recommended that, making that victim enhancement based solely on them as an individual, because that's where you see all of those attributes most frequently. If somebody's had a theft of their property, there's some shame in it. There's some frustration. There's some concern about, some apprehension about what might happen next time they open their bank account, or if they've had something stolen from their house or their person. What happens when I open that door or turn that key? What am I going to see? And so every single victim seems to have at least one of those things on there, as long as they're willing to respond. And so that's, from our perspective, to simplify it, simply say if they're an individual, they've almost certainly had some one or two of those attributes in their life as a result of being victimized. And so, by having it as that individual, there's less of a need to get statements from them, to get a circumstance. We understand that this is going to be something that's going to happen because we see it all the time. So by simplifying it and not having it so that they're required to respond, you kind of meet the same end without as much of the trauma, the relived trauma of it.
VC mate.
Thank you all for all of your work preparing to be here and the effort to be here. We appreciate it. Dr. Reddix, I had a question for you. You'd mentioned capping the enhancements at 16. Can you explain a little bit about how you arrived at that decision, that 16 mark, or what the thought was behind that?
Right. In looking at the other loss tables, I don't know them all by number, but I think there are 3 in the economic crimes categories. And while they may start at a higher base level, they only increase by 1 from category to category. And the cap is at 9.5 million or thereabouts on both, on 2B 1.1, and there are only either 7 or 8 different categories in the other 2 tables. But in the 2B 1.1, there are 30 enhancements, but the base offense starts at 7. So, the question is, if an economic crime, whether it's a robbery or fraud, there still should be some level of linear increase for one crime over the other. That's essentially our position.
Thank you.
And how did we get to 16? By decreasing the number of levels from 30 down to toward 8. It just seems a natural, decrease to a number. It wasn't a tremendous amount of debate as to what that number should be. We just picked one.
Yeah, another one?
Did you have a question?
Go ahead.
I just had a similar type of question for you, Ms. Johnson. You talked about that 15,000 threshold as being outdated and suggested it was time to move it. Did TIAG have something in mind about where it should go instead of that, or just that we should be looking at that?
We do not have a particular number. I think that we viewed the proposals kind of holistically. And so starting with an inflation adjustment as the sort of baseline to that number. But we do support the wholesale reconsideration of broader bands and fewer of them. And so if that is going to happen, then the simply inflation adjusting may not be a sufficient adjustment. I know that there was a tentative suggestion of perhaps having bands where, a quarter of defendants fell in one, and then another quarter, and then another quarter. And we would be interested in seeing what those numbers were. So I think the answer is that we didn't arrive at a particular number. We think it should be substantially higher than 15,000, but we didn't land on a final figure.
Thank you.
Yes.
Turns out I'm not very creative, so I was just going to ask Mr. Luria the same question I'd asked earlier for the previous panel, just to get your perspective on the kind of fact-finding burden issue and the relationship, if any, between fact-finding for restitution and fact-finding for loss. I'm just curious, from your experience in POAG, what do you see in that regard? Do you see that courts are often required to make restitution findings that are going to overlap with the findings they're required to make for loss under 2B1.1?
Our experience with this is that courts are always looking to find a specific number. I think a lot of the retroactivity we've experienced in the last 20 years has taught us that ranges don't really work for retroactivity. We've had, you look back 20 or 25 years, somebody might have come up with a quantity that was 15 to 50 in terms of the quantity. And then on retroactivity, you have to go back and try and figure out, well, what did they mean? Where was that? A similar circumstance, I think, with losses is that lesson was learned throughout the guidelines in terms of you come to a specific number on quantity, you come to a specific number on loss. I think with restitution, it certainly is a tie to it. And we certainly see circumstances where there's plea agreements, where there's agreed upon amounts of restitution. It's not a perfect circumstance that happens, and sometimes you'll get additional information that drives that number up. But I think that the fact that they have to find restitution doesn't necessarily mean that they're not going to feel compelled to find a specific number. It's very rare that you find courts, in my experience, that you find courts that are willing to accept a range and say, it's around this or it's around that. There's a lot of specificity to it.
And with respect, Mr. Luria, I think you've identified that 4 levels has calls for some, I guess, greater advocacy, I guess, of more contention. Is the answer to that reducing those levels to 1 to 2, 2 to 3, or something less than 4? Or
I'm really not certain. What I can say is that courts are going to be compelled to find that number, and if that actual loss falls on one side of that number, and the that cusp, and the intended loss falls on the other, that's going to be quite a contentious hearing. Or if there's some fact pattern or component that causes it so that if you take one set of facts, you end up on one side of the cusp, or one set of facts, you end up on the other side of the cusp. There's going to be a lot of argument about that. And I think in all likelihood, you might even see a lot of variances based on that too, simply because for such a large jump in terms of the overall outcome. We do think that there's a benefit to having graduated increases. I realize this is still graduated, but it is with such a much larger range that it's really hard to see, hard to gauge how this might impact that those arguments and that outcome with variances.
And Dr. Reddix, I think I heard you say in your opening, sort of do away with this issue. Maybe not do away with this issue of intended loss, as far as not weighing so much on the calculation of a final sentence.
Correct. I think the issue is how you calculate intended loss and consistency with that calculation. The only thing that as a defendant, the intended loss was millions more than the actual loss, and in my case, the state never even injected that a loss had occurred. So, the intended loss seems to me to be simply an area to enhance punitive punishment rather than to mitigate the harm that was caused by the antisocial act. So, and I think, whatever the methodology is for accounting should be the same across all circuits. And I don't believe that it is. Obviously, it's not. Third Circuit certainly does not even look at intended loss, only the actual loss.
Okay, well, thank you, lady and gentlemen. Panel, it's my time to introduce them. Will present the stakeholders' perspectives on our proposed sophisticated means amendment. First, we have Amanda Rydell. Is that right?
Perfect.
Okay. All right. Thank you. Well, perfect. I don't get that off. The acting assistant director in the legal program section of the Executive Office for United States Attorneys, EOUSA. She also serves as EOUSA's white collar crime coordinator. And returning to the dais is Michael Caruso, who will provide the federal defender's perspective. Ms. Rydell, please start us off.
Thank you so much for inviting me here to discuss sophisticated means. The incorporation of sophisticated means into Chapter 3 supports the Commission's efforts to promote clarity and fairness in the federal sentencing process. It holds responsible those who commit the most serious and harmful crimes. It deters criminal activity and creates a level playing field for defendants. The proposed language should, however, be tweaked to remove a reliance on technology. Should the Commission decide to leave sophisticated means in Chapter 2, the Department believes the current wording should be maintained and the examples remain as is. So why do we need a sophisticated means adjustment in Chapter 3? Applying a base level of 12 plus 2 for the most serious, complex, and concealing conduct is consistent with the aims of the guidelines. It recognizes that the most injurious criminals do not function in silos, either committing drug crimes or violent crimes or economic crimes. Instead, the most nefarious criminals layer their finances, hide behind stolen identities and shell corporations, and conduct crimes across borders. The adjustment captures this conduct and provides simplification in line with this Commission's aims. Let us now turn to what sophisticated means is not. It is not an invitation for a broad application to any crime that includes a bank account or use of the internet. First, the adjustment is self-limiting at 2 levels and a base offense level of 12. It will provide context to the guideline calculation and acknowledge the magnitude of harm. Next, the Commission's own sentencing statistics show the current enhancement is applied in 14.1% of economic crimes that tend to be more complex, and only 1% of cases overall. There's no reason to think relocation to Chapter 3 will significantly change that. Third, courts are comfortable analyzing what is and what is not sophisticated. It goes back to the origins of the sentencing guidelines. Settled law directs judges to evaluate complexity and concealment efforts, notably in relation to similar crimes. They know to compare a defendant who committed a complicated overseas child exploitation operation to a similar defendant, not to a defendant that conducted hand-to-hand drug transactions. Fourth, a Chapter 3 sophisticated means adjustment addresses sentencing disparities. People, regardless of what kind of crimes they commit, who commit more sophisticated crimes and conceal their identities cause more harm. They require more law enforcement resources, and their guidelines should reflect that. Finally, the Department believes that putting sophisticated means in Chapter 3 would allow for additional streamlining and get rid of the need for specific enhancements for mass marketing or dark web in the drug guidelines. Now let's discuss the proposed language. We agree with the federal defenders and with POAG that the proposal's focus on new and emergent technologies creates ambiguity and could limit the usefulness of this enhancement. Ask yourself, what is new and emergent technology? My 79-year-old father, who still works full-time, thinks YouTube TV is a new and emergent technology. Is it new or emergent to the victim, to the perpetrator, or to the judge? It creates a confusing and ever-changing landscape for judges to navigate. Next, the focus on technology belies the purpose of the guideline enhancement, which is to punish conduct that is more damaging due to concealment and sophistication. This analysis isn't reliant exclusively on technology. And in fact, the department believes it would be a mistake to create the impression that everyone who uses WhatsApp or pays in cryptocurrency is automatically entitled to this enhancement. Rather, sophisticated means is and should be reserved for those defendants whose conduct is especially intricate. Looking at, as the settled law suggests, the duration of the scheme, the number of participants, the use of multiple accounts, and the efforts to avoid detection. None of those factors necessarily include technology. And finally, if sophisticated means remains in Chapter 2, we believe the language should just remain the same, if anything, relocating the examples from the commentary into the text. Introducing amended language to Chapter 2 would invite confusion and litigation. At a minimum, the department supports retaining the examples, which set an important baseline against which courts can measure the sophistication of a given defendant. Thank you.
Thank you. Mr. Caruso.
Thank you, Chair Reeves, and members of the Commission. If the sophisticated means adjustment were a financial event, I think your accountant would tell you to take a write-off. And certainly your accountant would not tell you to export it to all your different business lines. And so that is essentially the position of the defenders. We think unlike the Department of Justice, that this adjustment hasn't brought clarity and hasn't brought fairness to the sentencing process. So we urge you to eliminate it for 3 reasons. As the data show, this adjustment generates unwarranted disparities. We see that in the inter-district applications of this adjustment. We cited the circumstances in the northern and southern districts of Mississippi and the western and middle districts of Tennessee, of course, bordering districts that have wildly disparate application rates. We also think the data show that this double counts conduct already captured in the loss table, especially at the higher levels. And we also don't think this is sound sentencing policy because the way the guideline is the specific offense characteristic is currently constructed, it not only punishes the people who are involved in the offense that created the sophisticated scheme, but also punishes those who were involved in carrying out the scheme, and we don't believe that that's sound process. If the Commission's not prepared to eliminate the adjustment, we do urge you to narrow the specific offense characteristic, and we've submitted proposed language, and of course, under no circumstances should this adjustment be exported to Chapter 3. Since the Commission severed sophisticated means from the more than minimal planning standard in 2003, it seems that courts have largely ignored that severance. You know, we cited cases from 3 circuits, the 7th and 8th and DC, who I think counter the position of the Department of Justice that there's this settled law across the country that this adjustment is applied in a certain way. And certainly the Commission's 2015 amendment has not minimized the application of this adjustment. Today, nearly the same percentage of individuals sentenced under 2B.1 receive this enhancement. And the disparity is staggering, you know, as I've talked about in the 2 districts we mentioned in our submission. Also nationally, 10 districts exceeded 20% application rate, while 15 districts were below 5%, including 5 districts where no one received the enhancement at all. This is the same guideline, vastly different outcomes, and I think establishes our point that there is no clarity or fairness to this adjustment. While we appreciate the Commission's concern and attention to this guideline, we don't think your proposed definition, if it remains in 2B1.1, sort of goes as far as it needs to go. For example, a judge could reasonably read the phrase to cover conduct in the upper half of all fraud cases, and that's not a narrowing, in our view, just a relabeling. I think we're in agreement about the emergency technology language, so I'll adopt my friend's remarks. And our written comment proposes an alternative definition to address what we see as the flaws. That sophisticated means should require conduct that is highly complicated or entails great skill, resulting in unusual difficulty in detecting, investigating, or prosecuting the offense. We believe that this adjustment should be narrowly construed and reserved for exceptional cases, and the Commission should make this clear. We also urge the Commission to address double counting directly. The Commission's data shows that sophisticated means adjustment is applied in nearly 20% of cases at the plus 14 loss level and nearly 49 of cases at the plus 24 loss level. At those levels, sophisticated means is not an independent aggravating factor, it's a near automatic add-on. Finally, exporting the sophisticated means adjustment to the entire guidelines manual will generate more litigation and more disparity, not less. The only voices calling for expansion are Department of Justice and, in passing, the Probation Office. Neither has offered empirical support for this expansion, and we know of none. I'm happy to answer any questions you may have.
Thank you. VC Mate.
Good afternoon.
Hello.
Thank you both for being here. I have a question for both of you, I think, that, and maybe for you first, Ms. Rydell, because I think this kind of came up in a little bit in your comments today and definitely in your written submission, and encouraging us to adopt a Chapter 3 sophisticated means adjustment. Your letter mentions a couple of similar SOCs, specific offense characteristics, and shares our thoughts on whether we should kind of change those, whether we should or could, because I think there's some discussion of directives to us around those and whether we could even change those if we were to consider a Chapter 3 adjustment. So I guess my question is, before we can even evaluate the wisdom of adopting a Chapter 3 adjustment for something like sophisticated means that would apply to every single Chapter 2 guideline, wouldn't we need to review every base offense level and every specific offense characteristic in the manual to assess whether it would need to be lowered to accommodate this addition in Chapter 3? And, as an example, the manual currently treats the offenses of insider trading and bribery as, I quote, sophisticated frauds. And those start at a higher base offense level. They already have some provisions in them. So wouldn't we need to ensure that the sophistication of the offense isn't already baked into those guidelines?
That's a big and meaty question.
I know, it's a long one, sorry.
No, it's okay. I mean, right, what the department was trying to do was respond to this in context. There are lots of contextual discussions going on here. One is we want to make this simpler for judges, more clarity to understand for victims and the public. But we also want to maintain the context of what's happening in the white-collar space. In the white-collar space, we've already seen a reduction for zero-point offenders that you're more than twice as likely to get if you're sentenced under 2B1.1 than the rest. And what we were trying to do is say, if there is an effort to streamline, but while also maintaining this important principle that's been since the beginning of the guidelines, to capture more sophisticated conduct because it's more harmful, how can we do it? And in the most fair way to do that is to apply it to everyone. And that's because I do not think that we started out with the guidelines looking at each individual crime. And these individual crimes, like you just point out, were written specifically. But now we're asked, well, what if we apply something to everything? So you're absolutely right. It would require going back and looking. But the language that the department proposes sort of takes that into account, because it looks at things that take a particular level of complexity, a particular level of sophistication, more than minimal planning for those specific offenses. So if you have something like bribery that starts out with, it is a sophisticated offense, in order to get this Chapter 3 enhancement, you would need something that even in the context of a particularly sophisticated offense would be more so. And I think that's how judges have applied this. Relative to that type of crime, how do you make it appropriate? Well, it's appropriate if on the scale of how you commit insider trading, how you commit securities fraud, it is particularly complex, particularly concealing, and particularly harmful.
Thank you. Mr. Caruso?
So, no, I agree with your point. So I know in the Department of Justice's submission, I think I'm representing this position correctly. They said for the assault and the burglary guidelines that contain more than minimal planning adjustments, do away with those. I think for an obstruction offense, they said we need to look at it further. But then I think their position is for every other guideline that touches either more than minimal planning or sophistication, keep it. And, that's our ultimate concern, that the problems with the sophisticated means adjustment in 2B1.1, the lack of clarity, the lack of fairness, are now going to be exported to every offense in the manual. And I think you're absolutely right. Before the commission goes there has to be a comprehensive review, not just looking at whether, in this one particular guideline, there's an SOC for more than minimal planning, but seeing how the base offense level is calculated, seeing how other specific offense characteristics in the guideline may impact on sophistication, to make sure that it's a clean process. But before we do that, and again, I think it'll be a hard sell for me to convince you all to eliminate the adjustment in 2B1.1. But where we also fundamentally agree with the Department of Justice, based on the data, is that and the commission's prior work in 2015, that more work needs to be done reconfiguring the definition. So if you want to keep the sophisticated means adjustment in 2B 1.1, we urge you to reconfigure the definition, then see how that definition plays out in the context of 2B 1.1 before you come to a decision whether to put that in Chapter 3. And then, of course, in the meantime, you can conduct the comprehensive review of every guideline in the manual to see where there could be significant or partial overlap.
Mr. Caruso, I was struck by about your finding, if you will, of the difference between what is occurring in the Southern District of Mississippi versus the Northern District. And I think I heard you say the Western and maybe the Middle District
of Tennessee.
Did you all look and see if there's a difference between the Western District of Tennessee and the Northern District of Mississippi? Because that's Memphis.
Right. I don't believe we looked at that. If we did, we certainly can submit follow-up questions. I think while the reason we focused on intra-district disparities, of course, is that both U.S. attorneys in the same state are appointed by the same president, recommended by the same senators, generally have similar demographics. So that's why we focused on these two districts in these two states, because there doesn't seem to be any explanation based on the cases or prosecutorial objectives why there would be such disparate rates of application.
Right, and that's under the existing rules.
That's right.
So, I mean, do you have any way to think, how can we address that now? Because that does seem totally with 30 and 1.
I agree. So if you pull back and sort of look at the national statistics where it says, applied in 14% of cases, like on the face of it, that sounds reasonable, right? As far as these things go. But like as the pollsters say, if you look at the crosstabs and you see exactly what's going on, you see the other data show that in some districts all across the country, there are very high application rates. In other districts, very low. And to be honest, we don't know why that's occurring. In my mind, the way I think about it, it's like the flip side of minor role, right? I know the commission has struggled over the years, like why don't more district court judges give minor role, right? In drug cases, certainly, and you've given advice a few times about that, and your data will show like whether that's worked or not. But the minor role adjustment in 2B 1.1, I think is even worse. There's even a lower rate. So like what I come back to, is this actually just a cultural issue? Does this have anything to do with case law? Does this have anything to do with sort of prosecutorial objectives? Or is this just the culture in various districts, whether driven by the U.S. Attorney's Office, the probation office, or the judges, that we either apply, we seek out and apply sophisticated means or we don't. Like I see that in my district. I come from a very large district, and to draw on the minor role sort of counterpart to this, there's very much a cultural issue. When I started in the office, half of my cases were drug importation cases, and like the only things at issue, some cases went to trial, but most pled, and so at issue would be acceptance of responsibility, safety valve, and minor role. Half the judges always gave minor role to couriers. About a third never did. And then the remaining judges, it would be a case by case basis. I think the same holds true, although not based on data, based on sort of my experience in courtrooms, that certain prosecutors, certain probation officers, and certain judges have just embedded views of what sophistication means. The other problem that we see is, and again, I touched on this in my opening remark, that we don't think it's sound or fair sentencing policy to hold someone accountable for just participating in a sophisticated fraud if they had nothing to do with creating that sophistication. Like many of these fraud cases are very hierarchical, right? Like I have a healthcare fraud case where there's essentially a CEO, COO, and CFO. And I have a client at the very bottom, and he's just taking orders. He's writing checks, whereas the CEO created 100 shell companies, created 100 bank accounts. But at the very lower level, my client is just performing a very, very limited function. And under the guideline, because he's involved in that sophisticated scheme, he would be eligible for this adjustment. So I think I answered more than you wanted me to.
I'm trying to find out what's going on between
Mississippi,
Jackson, Biloxi, and Oxford and Greenville.
I don't know if you were here when Judge Chang started off the day, but it's hearkening back a little bit to one comment he made, which was that where the guidelines are dealing with more of a standard as opposed to what he called a concrete fact, that there is discretion. And you're giving the example of minor role. Of course, we still have minor role. And I think anytime it's sort of a standard, we recognize that baked into that system, there's going to be some discretion. The example he gave was post-offense rehabilitation. Of course, we are proposing, there's an amendment on post-offense rehabilitation. And so I guess I wonder if, does that necessarily mean that, like, what in this particular context makes us feel that that discretion is just so beyond the bounds when we have many examples of situations where there's going to necessarily be discretion, where there's some kind of relative judgment made, which might inhere in many parts of the guidelines. And so that's just an observation. I guess, Mr. Idala, do you also have, maybe related to this, any reaction to what might lie behind some of these interdistrict
Yes. Questions? As a federal prosecutor for more than 20 years and someone who's prosecuted cases across the country, and now my role at EOUSA, who is intimately involved with the types of cases across the country, the answer lies in the fact that we have 94 different U.S. attorneys' offices that have different communities and respond to different needs, different types of crimes, and different emphasis. The districts that are very small, like small districts like the ones in the southern Mississippi, all of their AUSAs are generalists. They have less or fewer law enforcement resources. They're doing more violent crime, they're doing more drugs, more reactionary crimes, and their white-collar crimes, frankly, that they have the capacity to do, are often less sophisticated. That's just the reality of the resources that they have. Comparing that to some place that has like Nashville, just because something is a neighboring state doesn't mean the districts are the same. I'll compare our districts because I'm from the Middle District of Florida that always feels like the redheaded stepchild compared to the Southern District of Florida. They have twice as many prosecutors as we have in the Middle District of Florida, even though we are also an extra large district. They have more than twice as many law enforcement officers. They bring more white-collar cases. They bring more sophisticated and difficult white-collar cases. We would not look to the Southern District of New York, which is home to Wall Street and does the most complicated financial crimes, and compare them to what goes on in Arkansas, which may do a white-collar crime that simply involves lying to your neighbor to get them to invest in your, you want to sell soap and it's a pyramid scheme. That is why there are discrepancies. And this could be an education issue, it could be a victim issue, but simply saying geographically that shows that the guideline enhancement doesn't work, I don't think truly captures all of the context. And to your point, this is guidance that we ask judges to keep in mind when sentencing and to use their discretion. That's why we give them examples. That's why we have helpful language. And we rely on judges, practitioners, and the probation officers to guide that process. I saw Mr. Loria here. He did a bunch of my PSRs. He told me no to sophisticated means on multiple occasions. So I, as the prosecutor, thought it was sophisticated. He thought something else. The defense attorney thought something else. The judge was able to look at the guideline and the case law and make a judgment call.
If I may, and again, just to be clear, our starkest examples are interstate, where I agree, comparing the Southern District of New York or the Southern District of Florida with smaller districts is not the most apt comparison. So that's why we looked for, the 2 districts in Mississippi and 2 out of the 3 in Tennessee, because if you look at the Western District of Tennessee with Memphis, and in the middle with Nashville. Again, I don't know if there are differences in resources or priorities, and that is something that the commission can figure out. But to your point about Judge Chang's comment, I would say we're in agreement with him with regard to this guideline when we're talking about like what we consider very broad and vague guideline language about especially complex or especially intricate. Of course, you're going to have divergent views of what those terms mean, especially when you're trying to find facts. And that's why the defenders proposed more criteria. Now, again, is this anti-simplification? Maybe. But we think with more criteria and stronger language, that is a way to smooth out all these disparities in application that we see.
Oh, yes,
Mr. Crusoe, I think earlier you were talking about the different reasons that could explain some of these disparities. You mentioned case law as being one of them. And I'm just curious because, let's see this time up. It seems like some of the case law that I think was cited in the defender submissions and others is quite a bit older. I think predates the 2015 amendment that you talked about, which I understood to have narrowed sophisticated means to make it more defendant specific in certain ways. So I'm just wondering if you think that part of the problem could be that circuits have carried forward older pre-2015 standards in a way that's not commensurate with the changes the commission meant to effectuate, and if that was one way to get at some of the breadth concerns that you mentioned.
That could be. I haven't looked at that specifically, and again, that we can follow up and submit comments after the hearing. Aside from that, because that does happen in many contexts, there is this carryover depending on sort of the level of litigation and sort of the attention of the courts. The other issue that that I have to raise that I don't think can be ignored in terms of guideline specific offense characteristics is the concept of harmless error at sentencing now. So for example, in my district, and again, this is not every judge, but so for example, if the litigants are arguing over a sophisticated means adjustment, and they both have cases to make, a judge can say, you know what, either way, it's not going to impact my ultimate sentence under 3553A. So that's another issue that our criminal legal system has to confront, that perhaps now because of these harmless error rules, there's not going to be this full-throated litigation that's going to develop case law like it did in the past. And there's no sort of common law of sentencing because district judges, by and large, don't publish their sentencing orders.
Thank you.
Yes. No. Go ahead, Commissioner Meyer.
So I fully appreciate, first of all, thank you both for being here, but I completely appreciate what you all have been saying about administrability and about drafting. My guess is that part of what is driving maybe your different views on this is that probably Mr. Crusoe is a little bit less excited about Chapter 3 enhancements than
a lot.
just throwing it out there, than Ms. Rydell. But I'm wondering if it's possible to kind of like bracket those issues to just talk about whether sophisticated means makes sense if we were able to abstract those things as a kind of retail or wholesale thing. So do we think that some crimes are more aggravated by being sophisticated than others? Or do we think that if we were able to, not increase severity and not have drafting errors and not have disparities, it would make sense for it to be kind of a thing that applied across the board?
So across the board, I don't know. But with regard to 2B 1.1, I think the answer is yes. And I think this is where we are in agreement. As part of our definition, I think we call it an impact. The Department of Justice calls it effects, or I have that opposite. So I think there is a rational sentencing policy to look at a person who devises, based on the language of a highly skilled or difficult to detect, a sophisticated crime, to hold them more responsible than a person who does not.
Agree. We have extremely limited resources to protect the public to detect crimes. And if you're hiding, concealing the mechanisms of those crimes, your identity, and the proceeds of those crimes, regardless of what it is, if it's drug trafficking, those people's guidelines should reflect that. Their crimes go on longer, they commit more harm, they hurt more people, they require more resources that are very in demand, and their guidelines should reflect that.
Okay, one more.
I think this is a quick one, but it's just a clarification question, just because I wanted to make sure that I was hearing this correctly. In the discussion about technology, you were, Ms. Rydell, you were talking about, kind of, we don't want this to apply, to, all the, to, YouTube and things that aren't, that some people might view as emerging and other people wouldn't. But in your proposed definition, you go about that by just striking the limitation of advanced or emerging and keep technology. And then I'm looking at the defender's suggestion for the definition, which doesn't have the term technology. And so I'm wondering whether so is the department's position that technology is a factor courts should be considering in the sophistication, and is the defender's position that it's not necessarily, or?
I don't think we're that far apart on this, and maybe the
That's
verbiage
kind of my question.
suggests that it is. I think the department's position is new and emergent technology creates more problems than it solves. I saw in one of the submissions they said new and emergent using like AI. Every single time you hit in a Google search, you're using AI. If we use terms like that, it becomes so inherently subjective, it's not anchored on anything. The words sophisticated, complex, those things can refer back to the nature of the crime and the tools that they use to commit that crime, which of course may include technology. But we don't talk about other things. We don't talk about using false identities, when that's certainly a level of sophistication. And I think the department's position is it should be more like that, a factor, but to put it front and center creates confusion and could potentially really narrow it or ridiculously expand it, right? You could have some judges that say, oh, use WhatsApp. This tells me technology, and it becomes de facto. We don't want that. And then you could have somebody else that says, well, this isn't new and emergent because it's been out for 2 years and they're an early adopter, and then it becomes impossible to meet.
So mostly agree with Ms. Rydell's comments. So we do agree that there should not be a focus on advanced or emerging technology, but we also believe that the word technology should not appear in the specific offense characteristics, because I think that will naturally drive judges to look at technology, and we don't think that should be the focus, although it should be a circumstance, of course, they could look at.
Thank you, that was really helpful, and thanks for your indulgence.
All right. Thank you all so very much.
Thank you.
needs no introduction, but I have to do it because they represent the perspectives of our advisory groups. And I thank you all for being with us again. Abraham Ron, who will provide the perspective of the PAG, the Practitioner Advisory Group. Joshua Lurie again from POAG, our Probation Advisory Group. Dr. Carl Reddix with our Sentence Impact Advisory Group. And Jamie Johnson, again, boy, you're doing triple or quadruple duty. Perspective of our TIAG, and of course, Mr. Quaysbar for our VRAG, our Victims' Rights Advisory Group. Mr. Rain, could you get us started, please?
Sir, thank you again, Chair Reeves and members of the Commission. It's a pleasure to be back. I have two primary points I want to make about the sophisticated means proposal. Number one, I'll say briefly, it seems to us at the PAG that option one under the proposal, adding an adjustment to Chapter 3 that would have to be analyzed in every single case. Does this robbery, this drug offense involve sophisticated means, is problematic for a variety of reasons, not least because sophisticated means has proven to be a problematic concept in practice. And that's true for a variety of reasons as well, which I'll get to next. So that's point number one. We think adding an adjustment to Chapter 3 that would be analyzed in every case is a mistake. My second point is more fundamental, and it has been covered, I think, to a great degree already today, so I'm going to cut short a fair amount of what I have written on the piece of paper here. But to state it simply, our view is that sophisticated means has proven in practice to be unworkable and is not really tied to culpability, or at least independently of other factors that are captured in other ways in the guidelines. So why do I say this? Again, I'll cut this relatively short, but number one, it's applied inconsistently for reasons that my friends at the Federal Defender have already discussed. And number two, it's a highly abstract concept, and think of the distinction that Judge Chang made between concrete facts and standards, which, highly abstract is not necessarily in of itself always a problem, but in this particular case, it's problematic because it's a constantly moving target. What's sophisticated today is likely to be commonplace tomorrow for reasons, again, that we've already talked about. The technology examples that I think generally seem to be reaching an agreement on. Emerging technology is probably not a workable basis to ascribe culpability to a particular defendant, just because it's relative to what is emerging, and what's emerging changes at any given historical moment. And that's a difficult thing to ask judges and litigants to keep track of without some sort of expert-driven litigation in every case. And I would add that the language in the proposed amendment doesn't really fix this problem, and that's not to fault the drafters, but it's a feature of the problem itself. It can't really be fixed. The language, the proposed language, as it has to be, is phrased in terms of relative terms, more complex than typical or everyday or ordinary. But what's typical, everyday, or ordinary changes constantly. And again, difficult to ask litigants and courts to stay on top of that. Sophisticated means has also been subject to what I think of as conceptual inflation over time. And I'm not sure that this has been covered to a great degree yet today. But it's a pretty straightforward concept in itself. Courts, we have in our written submission examples of courts finding forging documents, using a P.O. box. I've, looking at case law last night, found examples of courts finding using an alias to be sophisticated means, disguising the origin of funds. It seems to us that it's just not proven to be a workable concept because it's so abstract and it's gotten to the point where it's essentially meaningless. The thing that I think distinguishes the PAG's view from what's already been discussed today is, or somewhat distinguishes our view, is here's what we think should be done to address this issue. We think the abstract concept of sophisticated means should just be taken out of the guidelines, and it should be replaced with the concrete facts, to use Judge Chang's concept, that are listed as examples in the commentary. So we have concrete examples of sophisticated means appearing in the commentary. The commentary says sophisticated means, and this is true everywhere sophisticated means is used in the existing guidelines. Sophisticated means includes hiding assets and transactions, using fictitious entities, corporate shells, and/or offshore financial accounts. You know, if that's what we're talking about when we're talking about sophisticated means, let's specify that and leave it at that. Take away this difficult to apply abstract concept that everyone seems to agree is problematic in one way or another, and leave it at that. And with that, I will stop. I welcome any questions. Thank you.
All right, thank you. Mr. Luria.
Thank you again for the opportunity to give POAC's position. POAC is in support of finding ways to improve the way sophisticated means is captured within the guidelines. We believe that if either option 1 or 2 are adopted, both would benefit from more definitions and examples. While we are in favor of this change being made through amending into Chapter 3, there are areas that could be better clarified. For instance, there are certain terms which could be interpreted narrowly or broadly. The word typical can have alternate interpretations depending on the circumstances. This can readily be seen in 2B1.1 cases. What is typical in a wire fraud case is not always typical in a bank fraud case, though both are captured by 2B1.1. When we compare a case to all 2B1.1 cases, it may be that certain types of cases are naturally more sophisticated than a typical 2B1.1 offense. For example, in general, bank fraud cases are more complex than false statement offenses. If a bank fraud case is compared to all the cases that fall within 2B1.1, it may be that more bank fraud cases receive the adjustment. However, if we compare a bank fraud case against other similar bank fraud cases, that narrower focus could impact the outcome. It would help to provide guidance on how broadly or narrowly this should be interpreted. While POAG also supports an increase based on advanced or emerging technologies, we suggest not including the additional bracketed language. The terms routinely employed and everyday user can have different baseline interpretations depending on the type of offense and even where the offense is committed. The term everyday user has similar application issues, as it is unclear whether it would be interpreted broadly to be any person or narrowly to be individuals who commit an offense of this type. Similarly, the other bracket that includes more specialized, elaborate, or unusual way and ordinary user also have definition challenges that could lead to disparity. POAG believes that it would be more appropriate to use neither bracket language and simply stop at emerging technologies, which in and of itself has some surmountable challenges. Emerging technologies is hard to define, and we suggest that the Commission clarify if the emerging technology was based on the time of the offense or the time of sentencing. Further, it is difficult to pinpoint when technology has moved from emerging to general adoption. For example, at one point, email was emerging technology, but over time, it became something everyone uses. If we look back at the history of email, we may be able to determine when it was no longer emerging, but that timeline may differ between districts and even within districts. Pinpointing when a technology is no longer emerging while you're living in that moment would probably be extremely difficult. POAG believes that examples in the commentary may provide guidance on how to work with this terminology. POAG supports option 1, creating a new Chapter 3 adjustment that replaces the existing specific offense characteristic related to sophisticated means. This change would allow for consideration of sophisticated conduct in all Chapter 2 offenses. There has been an increase in the use of cryptocurrencies for illicit purposes, in the use of the dark web for a variety of offenses, not just fraud related. 3D printers are becoming more widely available. Artificial intelligence is a cutting-edge technology that could be used for nefarious purposes. Who knows how we might see these technologies used in the future? What technologies may follow them? For these reasons, it seems prudent to allow sophisticated means to be considered in a broader sample of cases. We also support this being an offense-based standard and do not support the bracketed mens rea language. The mens rea standard can create application problems that may be compounded by having an offense-based standard followed by a defendant-based mens rea standard. Lastly, we suggest retaining some of the applicable examples from the current sophisticated means commentary. Thank you for the opportunity to share our thoughts.
Thank you, Mr. Luria. Dr. Radix. Make sure your microphone is on. There you go.
Thank you, Chair Reeves, and thank you, Commissioners, for yet another opportunity to make the Sentence Impact Advisory Group's positions clear. The interpretation of sophisticated means is ambiguous, difficult to apply, and duplicative of other enhancements. Unfortunately, this enhancement has the strong potential to subject people to double punishment. The Commission has proposed redefining and refining the definition to provide of sophisticated means to provide greater clarity and consistency for federal judges when considering this sentencing enhancement. The proposed SIAG specifically supports option 2 of your proposed change, expanding its application by moving it to Chapter 3 as contemplated in option 1 would significantly widen its reach and risk enhancing sentences in a far greater number of cases. Such a shift would extend the enhancement beyond its current scope to create substantial concerns about over-application. In an era of rapidly evolving technology, the Commission cannot and should not attempt to catalog every technological tool or method that could potentially qualify as sophisticated. Rather, trial courts are best positioned to assess whether a defendant's conduct satisfies a proposed definition based on the specific facts of each case. Critically, the enhancement should focus on how the offense was carried out or concealed, not merely its size, duration, or its financial impact. This determination should be guided by, number one, meaningful complexity and its structural, operational, or technological complexity, and that's what should inform the analysis. Secondly, heightened difficulty of detection, conduct that goes beyond ordinary concealment practices such as the use of multi-layered corporate or financial structures, multiple intermediaries, or advanced technological systems designed to frustrate detection should inform the application of this enhancement. To promote uniformity and avoid over-application, the Commission should expressly identify certain practices that standing alone do not qualify as sophisticated means, including routine use of computers, email, widely available communication devices and services such as WhatsApp or Signal, and the use of shell entities where their structure does not materially increase complexity or materially conceal the offense. Judges should focus on the defendant's specific conduct when determining whether the enhancement applies. The inquiry should assess the defendant's intentional involvement and role relative to the complexity of the charged offense. This enhancement should not be imposed solely because co-conspirators employ sophisticated means, absent the proof that the defendant personally used, directed, or knowingly exploited those methods, should it only apply. Finally, SIAG urges the Commission to address the existing inconsistencies across circuits. Federal judges should be provided with a precise, uniform, and objective framework to ensure consistent and fair application of the sophisticated means enhancement nationwide. Thank you.
Thank you. Dr. Reddix. Ms. Johnson.
Thank you, Chair Reeves, again.
Make sure your microphone is
Thank you. After lengthy discussion, TIAG elected not to take a specific position on sophisticated means. This is, again, one of the enhancements that we do see in Indian country, but not with great regularity. But we have nevertheless seen it enough that we have observed, as have many other people who've spoken today, that it is inconsistently applied and that there is a lack of clarity as to when it is appropriate to apply it. And that is, we had a lot of discussion about that. And I would like to respond to actually Mr. Meisler's question from a little bit earlier about the anchoring effect, which I think animates our concerns about giving examples, to provide a very concrete example of what you were talking about old case law being imported even after amendments. I actually was working on a case recently where a financial fraud case where a substantial amount of money had been returned to victims prior to the detection of the fraud. And prior to 2001, when 2B 1.1 or 2B 2.1 and the 2T 1.1, that merger, there was a body of case law among certain courts that said that loss amount in cases like that could be determined by amounts put at risk. So you got no credit for any money that you returned to people. When those guidelines were merged, the commentary very specifically says amounts put at risk no longer has any application to loss amount in these cases. Could not be clearer. In my case, I had a prosecutor cite a case saying, well, amounts put at risk are appropriate for loss calculations in this case. And I looked at the case and it was pre-2001. And so I was like, oops, the prosecutor messed up. I'm going to cite this amendment. But I take the case, I shepherdize the case, and I find out that this amounts put at risk case has been cited by courts in 2004, 2005, 2006 for the same proposition well after the change has been made. And I think that that's what's animating a lot of our concerns about these examples is that things tend to creep into the case law that then make it very hard for when changes actually happen in technology and things like that to get rid of them. So if you have cases saying the use of email is a sophisticated means, it's very hard to approach a judge and say, look, email is not sophisticated. Like, I know that we have 50 cases saying email is a sophisticated means. And so we don't oppose a sophisticated means enhancement, but we all agreed that it needed to be something that made it very clear that sophistication was to be assessed relative to offenses occurring now of a similar kind. With all respect to Mr. Luria here, cryptocurrency, maybe that's a sophisticated means now. Is that going to be a sophisticated means in 5 years? I'm not sure. And so if you write cryptocurrency into the guidelines, are we going to be sitting here in 10 years now talking about how 80% of fraud defendants are getting this enhancement because the word cryptocurrency is in the guideline? And so TIAG really only supports this amendment to the extent that it could be made clear that it really needs to apply to things that are the most sophisticated as compared to similar crimes existing in the United States today. So, thank you.
Thank you. Mr. Quaysbar.
Thank you, Chair. And good afternoon, everyone, again. Let me turn my microphone on. Thank you.
Emerging technology.
I'm not 79 years old like the DOJ attorney's father. But anyway, I got my microphone on. We're not experts in our group on sophisticated means. Let me just admit that right up front. In our work representing crime victims in criminal cases, we're working on their behalf. We don't litigate issues of sophisticated means. But in our discussions, we do have a sense of what may be valuable to crime victims in this area. And in our public comment, we cited to a number of cases from 2022 and 2024 where the federal courts have applied sophisticated means. I won't go through those details because you've got it in the public comment. But the Victim Rights Advisory Group supports the Commission's Option 1 inclusion of sophisticated means in Chapter 3. Technological developments make it far easier for crimes to be committed, which harm victims financially and in non-economic ways. And Option 1 seems to us to be the more comprehensive application of a sophisticated means adjustment than the Option 2 proposal. The technologies that allow criminal offenders to be less identifiable directly affect crime victims. And those changing technologies make it more difficult for law enforcement to investigate and prosecute those cases, making it easier for victims to be harmed. The broad scope of harmful criminal activity using sophisticated means includes fraud and economic harms, but also applies to other violent offenses as well that affect victims. And that may include drug trafficking, child pornography, sexual offenses, and terrorism. It also allows crimes to be committed in the United States, but it might be based from international locations or movable jurisdictions within the United States. So we understand the importance of being able to address sophisticated means and to try to capture the new technologies that come out. In our research, we looked at some cases, we read the responses to your priorities. Since last week when we had public comment available, I have read, and maybe other members of our group were able to read some of the public comment, including from the DOJ and from the POAG, and I heard comments here today. We asked the Commission to strongly consider the DOJ recommendations here as to the appropriate placement and the definition of sophisticated means. Thank you.
Thank you all. Any questions from the commissioners? Yes, Commissioner Wall.
Thank you all for being here again. It seems to me like we're getting a lot of commentary on various different strands, and the way I'm thinking about this, there's like a first order question, a second order question, and a third order question. The first order question is what Commissioner Vice Chair Murray asked the last panel, which is, if we take a step back here, are some crimes more sophisticated than others? And I think there was consensus, at least on the last panel, that yes, there are. Then I think the second question is, so if we agree that there are some crimes that are more sophisticated than others, the sophisticated means enhancement only applies to fraud, tax, and money laundering. Do we think those are the only three crimes that have a differentiation between more sophisticated versions of those crimes or not? And I think from my perspective and from the examples some of we've seen, that certainly we would think once we can see that there are more sophisticated crimes, that can apply to violent crimes as well. That's certainly not limited to white collar crimes, right? There can be more sophisticated kidnapping schemes, burglary schemes, child abuse, sex crimes, and the like. And then it seems like then if we acknowledge it's not like there's something specific and unique to these white collar crimes where there's somehow more diversity there, so there needs to be a sophisticated means differentiation within white collar. It's not like all these other crimes, all the crimes are routine, so there's no need to try and differentiate. Then I think then we're left with one strand of the commentary here, which is, well, is there a way, if we had our druthers of stepping back here, thinking about ways to differentiate, recognizing that sophistication isn't limited to fraud, tax, and money laundering, are there ways to bring clarity to that analysis? And then I think really what we're left with is a very practical question, which is how would we provide clarity? Is it through going through as many examples as we can? And the more examples you can, that eliminates disparity because you've given examples? Or is there a trade-off because technology evolves? There are changing things in society all the time. And we prefer, because of that trade-off, to go with a looser, more standard-like discretionary judgment. Because I look at even what the defenders suggested for their language here. They're suggesting, if you take the concrete examples of technology, like obviously I think we recognize that's not only used in fraud, tax, and money laundering. But even if you take the more, highly complicated, entailing great skill, concealment, difficulty in detecting and investigating, those are clearly not just limited to fraud, tax, and money laundering. Is there a way that, as we wrestle with that third question of is there a way to just provide a more concrete, clear standard or build consensus on where along that spectrum of examples versus discretion is the optimal point? Like, would it be something like just stressing that sophisticated is a discretionary judgment but should be narrowly construed and reserved for more extraordinary cases? Anyway, I feel like in some ways we're getting lost in all three of those. And if there are practical thoughts on that last question on where do we want to be along that spectrum of clear examples versus a discretionary standard, or like a narrowly specified discretionary standard, where could we constructively go? That would be helpful.
So I'll take a shot at it, if that's all right. I think what I've heard a lot today and seen a lot in the writing is a lot of concern about what technology is. I think technology is much more a methodology than it is a sophistication. It's a methodology for doing something sophisticated. And we're much more in awe of the new technology because of its newness, it can kind of bamboozle people more easily. If I'm thinking about a drug case that's sophisticated or a gun case that's sophisticated, a lot of those are going to be traps, things that are built into items to conceal it. That is not new technology. That's like something from the 15th century kind of technology. But it's the use of that technology, that methodology, to engage in something that's concealing, that's intended to conceal something or to hide property, or to, same thing with layering. Layering is hiding property, hiding my identity. So maybe a way to approach this issue is not to focus on the technology component as much as what are some of the things are intended to achieve by sophistication. What am I trying to achieve? And we're not focused on the methodology then, but these are the things that sophistication is attempting to achieve, and these are some methodologies that might facilitate that. These are symptoms of that sophistication, if that helps. Concealment, certainly concealing identity, concealing property, creating layers, creating higher avenues to victims to allow for information to go back and forth with them. That kind of access. So I mean, you're not really focused on the technology so much as what are we trying to accomplish in that sophisticated component, and what are those methodologies that might be brought to bear to make that endeavor successful.
If I may, Commissioner, just to respond to your direct question, where on the spectrum do we want to be between highly abstract and highly specific? I think the PAG's view is more specific is better. Everyone seems to agree, or maybe that's probably an overstating it, but many of us seem to agree that there is one of the issues with sophisticated means is it's not applied consistently, and it's very difficult to apply because the standard is something that's always going to be changing. So the more specific we can be, the better in terms of, because that addresses that issue. And as I said, the PAG's proposal is get rid of the concept of sophisticated means altogether. Just list the specific concrete examples that are in the commentary. We know that the commission thinks those examples merit an enhancement. Let's just limit it to those examples. That's easy to apply. The other the other thought I have about this discussion is we should think, I would recommend, and this is coming from me speaking for myself, I haven't spoken to the other members of the PAG about this, but I'd recommend thinking about what is it about sophisticated means that we think makes it more culpable, makes it merit greater punishment, and to what extent are those things not already captured in other places in the guidelines? So, okay, I've heard sophisticated means, we need to address sophisticated means because it's a way of increasing the harm. Well, I think the level of harm is captured in many places in the guidelines. We need to, okay, that's one. Another is we need to think about it because it's a way of increasing the magnitude, putting aside harm. I think the same thing is true. I think the magnitude of the offense is captured in a variety of ways in the guidelines. And another thing I've heard is we need to pay attention to sophisticated means because it makes the offense harder to detect. And on that one, my question is, number one, the guidelines do capture obstructive conduct. There's already an enhancement for obstructive conduct. And number two, if the goal is to deter, I don't think that, I just do not believe, and this is an empirical question, and I don't actually have the data to know the answer to the empirical question, but I don't believe that we will deter criminals from committing crimes, that we will cause people to commit crimes in ways that are easier to detect by punishing it more when they're harder to detect. It's just another thought to add to the conversation.
Anyone else wish to take a stab at that? I saw.
I debated. I think the issue is that from a previously sentenced individual, that we've got plenty ammunition in the guidelines for the prosecutors to prosecute any and everything. So the goal should be to simplify the process, and we're the most incarcerated population in the world. There's no other country in the world that criminalizes more acts than the United States of America. So the goal should be not just, obviously you want to punish criminals. I'm not arguing against that, but the goal should be to simplify the process such that everybody understands the consequences of an antisocial act, and have some easily, emotionally acceptable manner to accept the punishment for the accountability thereof. And by increasing the number of enhancements that the prosecutors have at their disposal, does not increase deterrence. It just increases frustration amongst the folks who were defendants. So I would just encourage the commission to be cognizant of the real world consequences of adding, tremendous numbers of enhancements. You certainly don't spend as much time on downward departures as we do on enhancements.
Ms. Johnson, because you put on your green light.
I did, and I think it was the word kidnapping, actually, that made my ears perk up. I see Mr. Voigt will be addressing you later. I think he may be one of the few other people in the room who has a lot of experience with a lot of kidnapping cases. I've done probably, 50, 75, which is probably surprising to most people there, most people sitting in front of me who do not do reservation cases and do not practice in jurisdictions where there are reservations. For the first 10 years that I practiced, kidnapping was charged every single time, basically, anyone was detained for any amount of time, even non-physically. Almost every assault was a kidnapping. Certainly every robbery was a kidnapping. Now, there has been recent case law in the 9th and 10th Circuit that says that actually you do have to detain somebody for more than 10 seconds, more than the 1 minute that it took to take the property off of them. But in my experience, if you want to talk about what a more sophisticated kidnapping is, it's anything that's more sophisticated than detaining somebody for a minute or two while you take their wallet off of them, or a minute or two while you punch them in the face. Anything more sophisticated than that would be substantially more sophisticated than what we were used to seeing. Now, somebody sitting in another jurisdiction probably has a different view of what a sophisticated kidnapping looks like, and I think that's, I think back to what Vice Chair Mate, the question that Vice Chair Mate asked, which is that this might be a good reason to take a wholesale review of the guidelines and to sort of go guideline by guideline and say, well, what does a sophisticated kidnapping actually look like? And does it matter? Does it matter whether you're in Arizona or New Jersey? And what are the ancillary implications? I think that, as I said, using a telephone in connection with a kidnapping would be probably sophisticated if you're just trying to compare it relative to the sort of baseline kidnapping offense that I've generally dealt with. And so I think it is good to use some caution because crime does look different nationwide. And it would be, I think it's good to be cautious about unintended ancillary effects.
Yes, Mr. Meisler.
Just one question for Mr. Ryan. I found the PAG's proposal very interesting about trying to be more concrete and going with a kind of conduct or rules-based proposal instead of a standard. But I guess I'm wondering if we end up at the same place. And so the example you gave before, which I thought was an interesting one, was alias. But if we cross out kind of sophisticated means and we're looking at the concrete examples that are given in the existing guideline, we get conduct such as hiding assets or transactions. So if you use an alias as the mechanism for hiding the assets, for opening an account that's not in your name, does the court just end up asking or making the same kind of determination and get us back to the same place?
So I have a very sort of text-based answer to that question, which is the way I read the language is hiding assets or transactions or both through the use of fictitious entities, corporate shells, or offshore financial accounts. So no, using an alias would not qualify. It would you have to be hiding assets or transactions through the use of specific things that are described here.
I appreciate that. And I guess the broader point, though, ends up being, do you think then the commission would be asked from time to time, well, the case law says this doesn't qualify because it's not on the list, but it sure seems like it's very similar to conduct that the commission does deem to warrant an enhancement. You should add this on. We end up with kind of a long laundry list of things.
Do I think that could happen? Yes, I think people would likely ask the commission to add things to the list. I'm not sure that I think it would be a good idea, but I think there's definitely constituencies that would ask for things to be added to the list. Yes.
I have a follow-up question for you, Ms. Johnson. It seems that TAG supports the notion of talking about exceptional cases, I think. And I think the defenders in their thing sort of said exceptional cases, but narrowly construed. I'm trying to grapple with how do you identify those exceptional questions? And I'm going to ask Mr. Lurie to listen carefully because I got to follow up to you as well. I mean, how would you grapple with that?
That's a very good question. I think there are actually ways of addressing it, and I think that they are, unfortunately, the ways that spring to mind immediately are not ones that are consistent with how things are typically done, unfortunately, with respect to the sentencing guidelines. For example, I'm thinking about the analogy in immigration court where there was a vast disparity between asylum grant rates between judges sitting in courtrooms next to each other with identical client populations. And one of the things that was done to address that disparity was publishing statistics. What's your grant rate? What's the grant rate of the person next door to you? If they're really far apart, maybe y'all need to have a discussion about, getting closer to the same page. I think that information provided to judges about how often they are applying this versus how often other people are applying this. I think that if there's a general sense that an exceptional case is something that is in the top 5% or whatever number is reasonable, that if someone is applying this at a far greater rate than that, then maybe it's time to reassess the definition of exceptional. Now, the guidelines aren't set up to do that kind of data measurement. That's not, so I'm talking in the abstract. I realize that would be something very difficult to do within the current framework of how we work. But I did find that the data that was presented earlier about differences in jurisdiction very compelling. And I think that, we don't have, or I don't think data has been provided to us about judge by judge variance, but I suspect just based on my own personal practice that if you took Phoenix, I have practiced in Phoenix. Phoenix is a big city. I also practiced in San Diego. San Diego is a big city. That there was a lot of within district variance as well, with all due respect to the Department of Justice representative. I don't think that the difference can solely be explained by the fact that, while in rural areas you see things that are less sophisticated. So I think that data would be very helpful and may help judges as well, because I don't think that judges are trying to over-apply sophisticated means. I think that everybody's doing their best, but I think that people may not have a realistic, among all the other things they're trying to do in the world, trying to get a comprehensive view of what kidnapping offenses look like nationwide is really a Herculean task that's probably unfair to give to district court judges. I'm sorry, I hope it's the best I can do.
Well, and then follow up, Mr. Lurie, I was sitting here thinking about, the persons who grapple with whether or not how this PSR and stuff might look like, where this issue of sophisticated means may first sort of come out. How are probation officers, if trained on this? Because I can imagine that there may be some officers or some people who might think the use of encrypted communications devices, the Snapchats and the WhatsApp of the world, and see that as a little bit different from just regular phones or a long time ago, the beepers. I guess if you sort of transacted your drug transactions by using a beeper, maybe that was sophisticated means back then. But when they shifted from that to cell phones, and cell phones were not widely in use, then that might have been. Now that we have all that, and you have people, the technology, the Apples, and I don't want to call anybody out, but basically the companies pushing encrypted devices. What does probation officers train? Are you training on that to sort of suggest what might be sophisticated and what might not be sophisticated?
So certainly we look at a lot of the examples that you guys have put in there, and that's not it to say that it's simply, oh, this matches that. It's does it have the same objective? Does it have the same effort being put into it? Is it successful in terms of delaying things? Is it successful in terms of hiding information? Certainly there's a limit to the success. They are before the court. So somewhere along the way it didn't work, but it may have worked in terms of, as Ms. Rydell pointed out, extending the length of the offense, concealing the identity of the people for a short time, giving them greater access to a greater number of victims, or a greater amount of the assets of those victims. So I think that we're constantly wrestling with this within the current structure. This newer structure, it has a very similar component to it, but we do look at case law. Would we go back and say email? It might be a binding case. Would email be sophisticated? I don't think that. I don't think that we would, because it's become so commonplace. It doesn't have that component to it. There are ways to engage in sophisticated conduct, even with old technology. So there's still ways. Phishing attempts. I don't know how to do a phishing attack or a hacker or whatnot. I have no hacker skill in that way, but that certainly is email being weaponized in some fashion to achieve an illegal purpose. You know what I mean? Would I apply a phishing attack as possibly sophisticated? Maybe. I'd look at it at least. But even that was my example earlier. Email, it's commonplace, it's everywhere. That doesn't necessarily mean that it's outside of the realm of being used in a sophisticated way. I think that's kind of why the smuggler's hold concept is such an interesting one, because that's been around for hundreds of years, and you still see it being used. Why? Because it works. And so, the degree of technology, how cutting edge it is only as interesting as the things that are being done, what it's actually attempting to achieve. That's the part that I think is really the animus behind the sophisticated activity. Is certainly the technology is a delivery mechanism for it. And we try to deal with that, but we're really trying to get to kind of what Commissioner Wong was talking about, which is, what's the underlying core of this? Well, we're always trying to find that, I think.
The efficient example, would that reach the definition of Ms. Johnson and the defender's exceptional sort of case, the use of regular technology to do exceptional things?
It's possible. It depends on the phishing attack, honestly. And I imagine that even within that, you're probably going to see that in certain jurisdictions more often than you would others. So, we had that discussion earlier about one of the jurisdictions where they just deal with violent crime. And so if somebody were to be doing a phishing attack from that jurisdiction, that might, even a simple one, might come across as very sophisticated. Whereas somebody doing it in another jurisdiction that's a little bit more commonplace, you might have to elevate that. So there's always a bit of a, with that wrestling, there's always a bit of a sliding scale with it, I think.
Chair Reeves, if I could just jump in for one, following up on what Mr. Luria just said, the means of using sophisticated means in a place like South Florida or New York City might be entirely different than in a more rural area. And as far as victims are concerned, victims could be more susceptible because they have access to that technology. They have email or they have phones. So it's easier for the offender to get in touch with people these days because of the technology. And so there might be different standards, district to district, on what is a sophisticated means is. I think that's what Mr. Luria was just addressing, that somebody in a rural area of your state could be more susceptible than someone in New York City. And the complexity that sophisticated means might be entirely different.
I'm just trying to find out what's the rural area versus the rural area in Mississippi to be 30 times as high. That's all. This is just amazing to me, learning that statistic through this here today. Anything else from this esteemed panel? Thank you all so much. I think now we'll take a 10 or 15 minute break and we'll start back up with our last panels. Thank you so much. the tunnel. Not quite there yet, but we'll start this next panel. It's our 9th panel for today, and they will present the stakeholders' perspective on our proposed amendment on post-offense rehabilitation. First, we have William Voigt speaking on behalf of the Department of Justice. Mr. Voigt is an assistant United States attorney and the appellate chief for the District of Arizona. Next, we will have Celeste Keeney. She'll provide the federal defender's perspective. Ms. Keeney is an assistant federal defender with the Federal Community Defender Office of the Eastern District of Michigan. Mr. Voigt, start us off, sir.
Thank you, Chair Reeves, and good afternoon, members of the Commission. Thank you for the opportunity to speak with you here today. My name is William Voigt. I am the appellate chief in the District of Arizona. I also previously served as criminal chief there for a number of years. And I'm grateful for the chance to share the department's view of the post-offense rehabilitation proposal before you. The department agrees that sentencing judges should consider and recognize when a defendant's post-offense behavior indicates genuine rehabilitation. But that is a highly individualized inquiry. So too is the extent of any downward adjustment that may be appropriate. We foresee workability problems, disparities, and collateral consequences in the creation of a rigid offense level adjustment. Genuine post-offense rehabilitation is best addressed through the tool sentencing judges are already using effectively when cases call for it, Section 3553A. We therefore respectfully oppose the proposal to create a new guideline Section 3E 1.2 and the related proposal to create a new 2B 1.1 B23. Our concerns fall in 3 categories. First, it is unnecessary. The proposed 3E 1.2 overlaps with other guidelines, most notably 3E 1.1's acceptance of responsibility reduction. It would generate double counting concerns without need, and as POAG has explained, this reduction is operating as intended and without issue. In those cases where a defendant has demonstrated the kind of post-offense rehabilitation that merits a further downward adjustment, sentencing judges are already using the right tool to address it. Judges know how to use variances, they have historically done so, and they are doing so effectively today. As the Criminal Law Committee has advised, courts generally have already been rewarding extensive rehabilitation through variances under Section 3553A, where 3E 1.1 doesn't fully capture them. This affords discretion and flexibility. By contrast, a mathematically rigid guidelines adjustment would add an additional fact-finding burden on judges, probation officers, and litigants, and it would create an unhelpful anchoring effect on this highly individualized issue. Second, the department is concerned about the proposal's inherent disparate impact. Virtually everyone commenting on the proposal has noted its serious risk of widening disparities. That means the Commission should pause, study data, and refine carefully before proceeding. Everyone seems to agree that the poorest defendants, non-citizen defendants, and defendants in under-resourced districts and localities will lack the same opportunities as wealthy citizen defendants from urban and suburban areas. Coming from the District of Arizona, I can attest that the proposed amendment risks treating a significant number of the people that we prosecute differently, given the nature of our border crime and tribal crime dockets. Many defendants will lack access to the kind of programming, resources, and opportunities that the proposed amendment may assume are abundant. By contrast, again as noted by POAG, such an amendment may become a box-checking exercise for affluent citizen defendants in well-resourced areas. But treatment resources are scarce. The unfortunate effect of the amendment may be that those most in need of resources may be less likely to get them. Third, the amendment is not workable. One cannot mathematically define what genuine, sustained, meaningful post-offense rehabilitation looks like in a typical case. But failing to define it or listing vague criteria would leave judges with little guidance. And as noted by the Victim Rights Advisory Group, the proposed amendment would credit post-offense rehabilitation even to those defendants committing the most violent crimes with the highest probability of recidivism, yet there is proposed no workable way to exclude them. Given these concerns, we urge the Commission to undertake a rigorous analysis of reliable data before implementing an amendment. We're not aware of data showing, for instance, that federal offenders who may take an anger management class or do charity work or pay required restitution are less likely to recidivate. Finally, if the Commission is resolved to implement such a guideline, we would suggest it involve only a limited reduction, avoid double counting, require behavior that is extraordinary,
rest on sustained, demonstrated rehabilitation, not mere aspirations or participation, and focus on behavior occurring prior to the relevant investigation and prosecution. In conclusion, and to be clear, post-defense rehabilitation is a good thing. It's something department attorneys rely on every day in making their charging, sentencing, and plea decisions. We're required to under the Justice Manual, and it's something that sentencing judges should consider in reaching a sentence. They're required to by 3553A. But creating a set guidelines adjustment is not the right tool. The department respectfully urges the Commission to reject the proposals. Thank you again for the opportunity to speak with you here today, and I'm welcoming the Commission's questions.
Thank you so much, Ms. Kenny.
Good afternoon. Thank you for having me. When I explain the sentencing guidelines to a client, I emphasize two things, especially when their guideline range is high. Number one, the guidelines are advisory, and number two, the guidelines cannot numerically capture the full context of the offense or all that is you. This proposal makes sense. The guidelines are a starting point, and a person's genuine efforts at rehabilitation should be included in that calculation. Most of my clients are from the same community as me. Some of our experiences living in Detroit overlap. The only difference between myself and most of them is early and consistent access to education, family support, and encouragement. When defenders look at our clients' social histories, we see devastating similarities. Most have experienced trauma in the form of violence, neglect, or early exposure to harmful influences. Research shows that behavior change often begins after a significant event, and defenders can usually pinpoint the exact moment our clients diverged and should have been in some sort of supportive social service. When a former client of mine was just 10 years old, his older brother was viciously murdered. Following this tragedy, his mother became emotionally withdrawn, and my client was not placed in any sort of counseling to process such a profound loss. Unsurprisingly, he started acting out in school. He started misusing and later abusing substances to quiet his grief. With no meaningful therapeutic intervention, he adopted habits and routines that resulted in frequent interactions with law enforcement and a staggeringly high guideline range. While that client was ordered detained in our case, he did not sit idly. Even though his detention facility did not offer any programming for him, he read books, he maintained communication with his children, he started having difficult conversations with his mother about his brother's murder and the impact it had on their family. And at 36 years old, he started mentoring younger people at his detention facility to give them the reality check he did not have at their age. He identified the static moments in his life and how they shaped his perspective and behavior, his brother's murder, how young he was when it happened, and the emotional neglect that followed. But he also identified the dynamic factors in his life that he could control and seek help for: his substance abuse, his peer associations, his employment goals, and his emotional regulation. Participation in rehabilitative efforts advances public safety and aligns the goals of sentencing with empirical evidence. We routinely see in cases across the country that sustained efforts result in desistance from crime. A former client who was charged with money laundering, an offense that resulted from her own financial struggles and her effort to provide for her children as a single mother, was accepted into my district's Restart program, a diversionary program that routinely sees long-term success. She participated in financial wellness classes, she took advantage of cognitive behavioral therapy, she made timely monthly payments towards her restitution, and by the end of the program, she was able to purchase her own home. Both of these clients made real, genuine efforts towards rehabilitation, and they are not alone. Why wouldn't the guidelines include this information? The guidelines are not lacking tools to address bad post-offense behavior. What they currently lack is a clear and defined way to recognize real positive change. This amendment, particularly option 1 with our suggested modifications, pushes the guidelines in the right direction. It acknowledges what social science has shown to be true. People are dynamic, and they can and they do change. When you set people up for success and give them the necessary support, those changes stick around. Habits change, routines change, Peer associations change, and that's all for the better. It should be indisputable that a person who finally overcomes years of substance abuse, or the crushing weight of financial insecurity, or attends therapy for the first time after years of devastating life circumstances, or takes advantage of educational programming is not deserving of the same starting point as a person who sits idly. To conclude, defenders are excited about this proposed amendment, as should every member of our judicial system, and we wholeheartedly support its adoption with our suggestions. Thank you.
Thank you, Ms. Kenny. Any questions? VC Restrepo.
Thanks for being here. Ms. Kenny, do you have any concerns, or do the defenders have any concerns that by adopting this sort of an amendment, it would kind of create an anchoring position for judges, and the judges that may factor in this post-offense rehabilitation under 3553A would kind of see it as a cap? And have you thought about that at all?
We have thought about that, and one of our suggestions is to add language that emphasizes that judges can still consider a further reduction under 3553A, and that is why we still have a two-step sentencing process. And so you bring up a good point. The guidelines do have an anchoring effect, and that is why this amendment is so important, because it includes information that should give judges the correct starting point to begin, to determine how much time in prison is actually justified and how much time is appropriate to consider to take a person away from their community, particularly when it may interrupt the forward momentum that they are on, given their sustained rehabilitative efforts. And so by including it into the guidelines and also reminding judges that they can vary further if they find it appropriate under 3553A, we think that addresses any concern that the commission may have.
Mr. Voigt makes a good point, suggesting that some folks in underserviced areas or some folks that don't have means to facilitate the rehabilitation would be disadvantaged. What's your perspective on that?
That's a very real concern, but that's why flexibility in drafting is important, to give judges the ability to consider it holistically and to meet a person where they are. A person like my client that I mentioned in my opening, he took every effort that he could to rehabilitate himself. And I was very proud of him. I thought the sentencing judge was very proud of him, and it should have been included in his guideline range. And so that is a concern that we have, but our suggested modifications, we think, addresses it appropriately.
Thank you.
VC May.
Good afternoon. Thank you both for being here and for your testimony today. I have a very kind of weedy question for you, Ms. Kinney, about the proposed amendment and then your comments and the comments of some others about it. Our proposed amendment accounts for or recognizes financial support to family members. And I think defenders and at least one other commenter raised that there may be other types of family support beyond financial that we should be accounting for if we were to put something, if this were to go forward. Are there specific kind of additional forms of family support that should be accounted for in anything we published?
I think so. I think our suggestion that moving the considerations to an application note and emphasizing that they're non-exhaustive would allow for judges to consider the various ways that a person is making rehabilitative efforts. So my client that I mentioned in my opening, when I said that he was maintaining communication with his children, he wasn't just calling and saying hello. He was helping them with their homework over the phone. He was helping them navigate through things that they were going through in school. And so he was still trying very hard to be an active parent, and that is something that would be borne out in our allocution and in letters that would be submitted, and that is certainly something that should be considered as family support.
Mr. Meisler.
Hi, thanks for being here. Just for Ms. Kinney, I don't mean to nitpick your word choice, but I think that defenders expressed a preference for option one if the commission is going to go forward with either of these with amendments. But I noticed that when you were speaking before, you talked about the importance of sustained rehabilitation, and that stuck out to me because option two, of course, leads with the criterion that the defendant must demonstrate a sustained commitment to positive behavioral change. Do you have specific concerns about requiring that level of commitment if the commission is going to go forward with a adjustment here?
Not necessarily, because sustained just means that it can't be something that you started to do 3 days before sentencing. And so I do think that you still have to look at it holistically and look at the options that are available to a particular person and the efforts that they took. And it should be sustained. It should not be something that is a fly-by-night attempt at trying to lower your guideline range. It should be something that you can show documented efforts at. And so that's not a concern that we have, but we do prefer option 1 because of the flexibility that it offers.
Mr. Boyd, I have a question for you. I think your testimony and the writing talks about extraordinary efforts that a person may take. And I guess some people have access to more things than others to do things that might be common, might be extraordinary. I'm just trying to figure out, on the grand scheme of things, what is that DOJ is saying might be extraordinary, those types of things that might be extraordinary.
Thank you, Chair Reeves. And I think that the first point we would make is the difficulty in defining that is one of the main reasons that we are recommending against the proposal. It is, I think that many district judges will have different views of what would be extraordinary, but it's hard to see an amendment that would apply to what defendants typically do. And I think that Judge Chang spoke about this a little bit this morning when he talked about when you're creating a guidelines adjustment, you want something that's concrete that will differentiate a discrete subgroup of defendants from the whole. And so if you were to write something that would apply to everybody, it wouldn't really be an effective guidelines adjustment unless it was just sort of an across-the-board reduction. Another concern we have is related to the anchoring effect, to the extent that this is something that does apply to the typical defendant and not to people who make extraordinary efforts, then you're applying that anchoring effect to the typical defendants and you're just exacerbating it more. So I think if you were going to put forward an adjustment, you should probably look at the types of cases in which judges have granted variances based on rehabilitation, to look at things that may have come up in those cases, if you can identify them, to look at the extent and the distribution of variances. So I think those are things I would look at to try to answer the question. You have, in some cases, looked at, for instance, is violating pretrial release typical or extraordinary? It is unusual. So just complying with terms of pretrial release wouldn't really be something that I think would categorize a defendant for unusual, extraordinary circumstances that merit a downward adjustment.
I think Judge Chang mentioned earlier, he gave the example of somebody who had been morbidly addicted to drugs for a long time, and post-offense has now sought treatment, and by the time of sentencing, months have gone by, and that person has done really well. Would that be extraordinary for that individual?
I think recognizing that will have to be a very individualized question for that defendant. He may have had opportunities before and fallen off the bandwagon, or he may not. He may have a lot of other things in his background. But sort of taking the question as a whole, I think it very well could be. And there absolutely have been cases in which judges have granted and I have agreed with downward variances for defendants who have really turned their life around. And often we do see, often maybe too strong of a term, but there are cases where we see that even before the government gets involved and we have detected a crime. And those are the cases where we have the strongest confidence that a defendant has committed himself to rehabilitation, has a reduced risk of recidivism, and would fall in the heartland of when you would vary down from the guidelines.
And I heard you mention at the outset, according to your U.S. Attorney's Manual or DOJ policy, some of those factors you might take into consideration, even in your charging decisions or your plea negotiations, because I'm hearing that's pretty new to me. So
Yeah, the principles of federal prosecution, it's a very long part of the Justice Manual, and it tells us to take a holistic look at the crime, at the individual, to be sure that we are picking the right individual decisions for a case. Obviously, we are just making recommendations. You know, the judge is the one who ultimately picks the sentence, but it is something that we look at when we decide what cases should be prosecuted and how we should dispose of those cases. I have had cases where I have stipulated to a cap. The judge would have to reject the plea agreement where the cap is below the guidelines range, precisely because the individual circumstances of the defendant are such that that wouldn't be a fair range for him to have. And those are some of my favorite sentencings because everyone's on the same page. So yes, it is absolutely something that we consider.
Even in your charging decisions, because that's the question that I have, because sometimes we have very vulnerable people who might get caught up in a conspiracy to sell drugs, and their only role might be to sell one dime bag of whatever or one small portion to something to feed that person's addiction, and that person is before me having been charged with being in a whole conspiracy. So, so your justice manual tells you to consider that individual who's addicted to drugs possibly, and thinking about whether or not she, because that's what I've had before, ought to be charged in an overall conspiracy.
And this might be an area where, being from Arizona, I'm sort of at a disadvantage because the drugs we see are usually, you know, gigantic loads of kilos and things like that. So I don't think that we have many cases like that where I come from. But yeah, we are supposed to take a holistic look at the defendant, at the crime, at our prosecution priorities as they're provided from the Justice Department, and try to make a smart decision about where we should spend those resources. And there have certainly been cases, particularly violent crime cases, where you might be talking about, you know, an assault that happened a long time ago. The victim has made, you know, peace with it and is not seeking anything. And the smart thing for society as a whole is not to try to bring some high-level charge or even a charge at all.
Thank you, Mr. Boyd. I think Commissioner Wong has something.
I would go back to what Vice Chair Restrepo had asked earlier about whether there would be a cap based on, I think you were talking about, well, I guess any option, but I wanted to start with option one. So with option one, we provide these various, as published, various considerations. And I certainly understand the response, but I'm curious, Ms. Kinney, you had said, you know, perhaps there was language that says the options here are 1, 2, or 3 based on these considerations. And I assume you all would agree any of those considerations could also be considered at 3553 later on, right? I understand the point that if you did 3 levels, that maybe there's some clarification that at 3553 you could say, in fact, I think it's worth even more. So we'd go beyond that. But what if you had a judge, I just want to unpack this a little bit and test that interaction between this guidelines consideration and the 3553. What if you had a judge that said, based on factors 1, 2, and 4, I'm going to give a 1-level adjustment. And then in 3553, listed the exact same characteristics again, 1, 2, and 4, and gave an additional reduction. Is that appropriate? Or would that actually, is that appropriate? Is there any difference between someone who gave a 2 here, or if, you know, if you haven't gone the full maximum level reduction in your guideline, can you, based on identical criteria, go further in the 3553?
I hesitate to tell a judge he couldn't go further if he wanted to. 3553 is very broad, and as the Supreme Court has said many times, the things you can consider are virtually unlimited in a sentencing. I think there is, you know, getting to the conceptual, there is a conceptual problem with saying we want you to look at these things for a guideline reduction and then look at the exact same thing for a further variance. And here I might add to what Judge Chang said this morning about the anchoring problem, because anchoring is not a bug, it's a feature of the guidelines. We want judges to eliminate disparities, to be saying the heartland of this factor is this type of reduction. And given how individualized post-defense rehabilitation is, or how any one of these facts might end up being, I think it's just hard to do. You can't mathematically to quantify that. So I think the judges should be looking at it under 3553A, and I think that is the safest place for them to be looking at it.
And do you think, and what would the difference be sort of implication-wise on appeal for a situation where the exact analysis occurred at the guidelines level versus at 3553? Would there be any distinction if the analysis was precisely the same?
I mean, I think there might be, and I guess here I will confess my ignorance for not having researched that particular point. I mean, I know that, under the Kimbrough line of analysis, that judges can disagree with guidelines and say, I think it may not go too far or it may go far enough. So I hesitate to say that that there would be an appellate problem from my perspective. But again, I haven't thought it through, so I won't take a firm position on it.
I was looking to see if there was a follow-up. I see Miss Kenny wants to jump in, and she was looking at you to make sure, I think.
Yes.
Okay.
Well, so it's an interesting question. The defenders are asking for a flat 4-level reduction to avoid disparity in the application of the reduction. We think a 4-level reduction is appropriate because acceptance of responsibility, you can get up to 3 levels, and you cannot have exhibited any rehabilitative effort to get the acceptance of responsibility. As we see, it's applied in 95% of cases, and usually that's just because you've pled guilty. And so by getting a 4-level reduction based on a judge's judgment about whether that reduction is appropriate, that judge could then go further if they feel that a person has exhibited more effort or has accomplished more than someone else who just got the 4-level reduction. They can go further under 3553A, and we think that that would be appropriate.
Any additional question from this panel? All right. Well, thank you all so much. I appreciate your testimony. The 10th and final panel will present our advisory group's views on our proposed amendment on post-offense rehabilitation. First, we will hear from David Patton, chair of our Practitioners Advisory Group. Second, we'll hear from Josh Luria, chair of our Probation Officers Advisory Group. Then Adam Clausen. He'll speak to us on behalf of the Sentence Impact Advisory Group. Jamie Johnson has returned once again. She will share the perspective of our Tribal Issues Advisory Group. And finally, we'll hear from Ms. Colleen Clace on behalf of the Victims' Rights Advisory Group. Mr. Pat.
Thank you, Chair Reeves. I think the only thing worse than standing between everyone and lunch is standing between everyone and the end of the day. So
we saved the best for last.
Yes. We at PAG are grateful to the Commission for proposing the post-offense rehabilitation amendment. I think we all agree that rehabilitation is a core traditional component of sentencing. It's part of 3553A, and yet, as central as it is to sentencing considerations, is not reflected at all in the guidelines, and it seems overdue to think about it, especially in the way that you have. To go back to Judge Chang earlier, talking about the guidelines' role in being able to point to some more concrete things, most considerations of rehabilitation are sort of forward-looking and aspirational in some sense. What sentence will promote rehabilitative goals, whereas post-offense rehabilitation, concrete things that have been accomplished or attempted or efforts made pre-sentencing can be a lot more informative, both about what may lie ahead in terms of further rehabilitation and what's just. And so we certainly favor the proposal. There are 4 general things that we would ask you to keep in mind as you think about fashioning the actual language. One is that, and you've already heard about this, that you consider the fact that there are a variety of opportunities for differently situated people to demonstrate rehabilitation. People who are detained are differently situated from people who are not. Within the detained population, there are widely disparate opportunities. Where I practice primarily in the Southern District of New York, there are no fewer than 5 places that our clients are held, 1 federal detention center and at least 4 local jails in 2 different states. And so I think some language in the commentary that judges should view post-offense rehabilitation through the lens of what opportunities were available to the person and what efforts did they make, with an emphasis on efforts. Second, to tie into that efforts piece, we do think that any sort of language along the lines of sustained or completed or successful are problematic. Many efforts, genuine efforts at rehabilitation, involve failure. Most people who eventually kick drug habits have a long history of failed efforts at rehabilitation, but that doesn't mean it shouldn't be encouraged in the sort of concrete ways that you're proposing here. And there are other examples. Third, we'd suggest that voluntariness not be a part of any of the language. We often will ask for court-ordered intervention, precisely so that probation can get somebody into a particular program. There may be financial aspects to it. There may be even just space constraints or programs willing or unwilling to take somebody, and to have the court order and probation behind those efforts can make a big difference. And finally, and this what we have proposed in our written comments, we'd suggest sort of a blended version of options 1 and 2 that have sort of broader standard in place, but with specific illustrative examples in the application notes, and making it clear that those are not exclusive, that they are in fact illustrative. And I look forward to answering your questions.
Thank you. Mr. Luria.
Thank you again for the opportunity to share POAG's views. We appreciate the proposal's goals of incentivizing and rewarding positive conduct and rehabilitation efforts taken by defendants prior to sentencing. However, POAG is unanimously opposed to this amendment as written. We're concerned that both amendment options would increase disparity in sentencing, negatively impact victims, and have unintended consequences resulting in litigation and delays in sentencing. We believe there would be considerable disparities between how this amendment would impact those who are detained and those granted pretrial release. Detained defendants do not have access to the same treatment, occupational opportunities, or educational resources as those who are on pretrial release. The disparity of opportunity is further widened when considering regional differences. Resource availability between rural and urban areas vary. Even if resources are available, obtaining records from local detention facilities can be extremely challenging with varied outcomes. While those who are on pretrial release have more opportunities to demonstrate their post-offense rehabilitation, there is also the potential for disparity amongst them. For instance, financially stable defendants are in a position to pay restitution prior to sentencing or pay for private substance abuse or mental health treatment. We are concerned about voluntariness as a metric because those who are indigent do not have money to make restitution payments or to spend on treatment. When treatment is made part of their conditions of release, those defendants have access to the federal resources for their treatment. Once it is a condition placed upon them by the court, it is arguably no longer voluntary, even if they initially requested it as a condition. Successful post-offense rehabilitation can be difficult to measure. For example, a lifelong drug user who is able to stay sober for 4 months but relapses may look like failure, but could also be the longest that defendant has been sober in their adult life, which is success. There are many circumstances wherein a defendant may make substantial progress in one area and demonstrate substantial regression in another. We are uncertain how to balance that under this structure. We believe this amendment may lead to unintended consequences. We have repeatedly seen circumstances wherein defendants who want to participate in the BOP's residential drug abuse program have bolstered or embellished their substance abuse history in order to qualify for the program and the custodial reductions benefits that result. It would not be surprising for a similar outcome to occur with this reduction. The amendment could lead to defendants requesting conditions that they do not need, wasting resources and setting them up for failure. POAG is concerned that if we establish a system based on checking boxes to get a reduction, defendants will find a way to check as many boxes as they can to get the reduction. We do not want defendants to just check boxes. We want them to take sincere steps towards meaningful change. Option 2 seems like less a box checking list, even though POAG, again, does not think either option is ready as written. We are also concerned about the interplay this reduction will have with acceptance of responsibility and obstruction. Acceptance and obstruction have a complicated interplay, with courts having to balance those two dynamics across a variety of fact patterns. Post-offense rehabilitation does not have any guidance on how to operate within those dynamics, which it will almost certainly brush up against. For example, if a defendant has engaged in treatment and engaged in community service, but at the time of sentencing recants their admission of guilt, do they still get the post-offense rehabilitation reduction? It seems like if they are not accepting responsibility, they are likely not rehabilitated. If the defendant absconds from pretrial supervision, missing a hearing, but is later found to have checked themselves into a substance abuse treatment program where they made progress, does the post-offense rehabilitation reduction apply? Certainly the defendant made progress in their sobriety, but engaged in obstructive conduct, violating the instructions of the court. A description of the interplay between acceptance, obstruction, and post-offense rehabilitation is pivotal to clear implementation. And a change like this, POAG also recommends that the stakeholders be given an opportunity in another amendment cycle to provide feedback on how that interplay looks due to its complexity. Lastly, we have observed that individuals who make substantial post-conviction effort often get substantial recognition from the courts through variances. There is a concern that if the Commission anchors this reduction to a set level, it may reduce the court's interest in granting a greater reduction for those worthy defendants. POAG appreciates the Commission's commitment to incentivizing post-offense rehabilitation. Thank you for the opportunity to share our views on this.
Thank you, Mr. Luria. Mr. Claus.
Thank you, Chair Reeves, Commissioners. Again, I appreciate the opportunity to share SAIG's unique perspective on this. What SAIG brings to this conversation is not theory, it's our lived experience. Many of us have served federal time. Many of us have been family members carrying the weight of these sentences right alongside someone we love. We know what it looks like when a person is truly changing, and we also know what it looks like when the system unintentionally makes it more difficult for individuals to change. especially when people have fewer resources. SIAG strongly supports recognizing post-offense rehabilitation, and we support it for a simple reason, because ultimately it serves public safety. Most people who are sentenced in federal court are going to return home. The question is not whether they will, it's how they will. And a system is better for everyone when it rewards a level of accountability, treatment, education, and real behavioral change beginning before sentencing, not just after. SIAG prefers option 1 because it's clearer and more objective. If this adjustment is going to work, it has to be applied consistently, not unevenly. Option 2 asks the court to decide what's sustained and typical. Those words may sound reasonable, but in practice, they can mean very different things in different courtrooms. And that kind of subjectivity can turn good policy into an inconsistent one. Now, here's the part that SIAG wants to say as plainly as possible. Access is not equal. And I think we've heard much of that statement from a number of people already. And if you don't put a system and a structure in place and create incentives, then there never will be that reason to change. I believe this is a strong first step towards creating that structure. These incentives need to be there to let people know that there is a reason for them to begin investing in themselves. The alternative is what we currently have. There's very little incentive on the front end. People end up biding their time simply waiting to get through the system. The investment in themselves is more or less an afterthought. And it would be a tragedy because there are some people who are working the hardest towards change, but they have the least amount of options, the longest wait list, the most limitations, and the least amount of support. So SIAG's asking for some guardrails here, not to complicate the guideline, but to make it fair. First, courts should evaluate rehabilitation in light of just what's realistically available. Second, they should recognize that there's multiple pathways to rehabilitation. It's not one program or one court-mandated form of treatment. Third, there should be simple, standardized way to document that rehabilitation, say a rehabilitative record that the court can look at. And finally, when it's needed, courts should request institutional verification of program availability so that a lack of access is never confused with a lack of commitment. Because currently that's the issue, as was previously stated. Programs that are in place are very limited. And individuals who are looking to invest in themselves will basically say whatever is needed to gain access to that program. Not necessarily as they are trying to game the system, they're just trying to get to the front of the line because the resources are so limited. And if there were additional means for them to achieve the same result, to be recognized for the investments that they're making in themselves, then they would not need to take those steps. In closing, I'll speak from my lived experience. People can change. I've seen it, I've lived it, but it's not automatic. It takes work, it takes structure, accountability, and a reason to keep going. When the system communicates that rehabilitation, even before sentencing, matters, it creates a sense of urgency and gives people a sense of direction. It gives people a clear incentive to do the hardest part of transformation when it matters most. And it sends a message that strengthens legitimacy, that the system can be firm and still recognize what redemption looks like when it's real. And this is how we get better, safer outcomes. Thank you.
Thank you, Mr. Clausen. Ms. Johnson.
Thank you. Thank you again for the opportunity to address the commission on behalf of TIAG. TIAG strongly supports the proposal to add an adjustment for post-offense rehabilitation. And to explain why, I want to talk about a documentary that I recently watched. It's on HBO. If you have HBO, you can watch it. It's called Class 57. And it tracks the 57th class of police cadets, police recruits for the Navajo Nation. The Navajo Nation, it was about 3 years ago, needs 500 police officers to perform basic policing services. And at the time, they had 180. So their goal was to get to 500 within 5 years. And in order to accomplish this goal, they needed to, they had classes of about 30 recruits, and they were looking for an 80% retention rate, an 80% success rate. And their success rate was averaging about 50%. So this documentary tracks this 57th class of recruits. It starts off with 28 members. And on their first day, they're put through a sort of military style boot camp. There's yelling, there's, throwing things, the kind of stuff we're familiar with from the movies. The head trainer, all the cadets are Navajo. The head trainer is not Navajo. He's not native. He's not from the community. He formerly was a police officer in the state of Arizona who moved to the Navajo Nation to work for their police department. By the end of the documentary, there are only 10 cadets out of 28. And this sergeant, who is not from the community, decides that he's going to talk to one of the recruits about what their attrition rate is so bad. And he's talking to one of the cadets that made it, one of the 10 who succeeded. The cadet is very uncomfortable with the conversation, and he said, well, to tell you the truth, the majority of the people who left, they left because of how they were being beat down every day. And the sergeant says to him, well, do you think that the people who left, do you think that they met the standard? And again, very uncomfortable recruit says, I think so. I think that the majority of the people who left could have been outstanding police officers. And he said, well, you have to understand, the majority of these recruits, they've grown up only hearing that they're pieces of trash and that they're nothing. And then they come here, and it's more of the same. And they feel like they're working hard, and they feel like there's nothing to show for it. And so they leave. And this is life on a reservation. And these are police cadets. These are not people who have drug and alcohol problems. They're not people who've been involved in the criminal system. But this is still the message that they have received. And this is a very common message sent throughout Indian country. And the feeling that you're working really hard and that you have nothing to show for it and that your hard work doesn't matter presents real obstacles to success. This amendment is not just about rewarding and incentivizing good behavior. It's not for TIAG. It is not just about being nice to defendants or giving people adjustments under the 3553A factors. It is about showing people in a concrete way that their hard work will matter, which is something that for many people who grew up on reservations is something that they have never experienced in their entire lives. And I sit down with Native clients all the time, and I go over the guidelines. I'm like, here are your guidelines. And if you're on pretrial release, or even if you're in custody, if you do everything right, these are still your guidelines. Now, if you mess up, things will get worse. And they could get a lot worse if you mess up a lot. That's all stick and no carrot. All they're hearing is that if you just, do your best, nothing is going to change for you. And I'll say, well, we'll try to make arguments, we'll do our best, but I can't really promise anything. TIAG feels really strongly that the guidelines need to incorporate a carrot, that particularly Native defendants need to be sent a message that if they work hard, if they work on themselves, that there is something that they will have to show for it. Not just on behalf of the defendants themselves, but because it promotes community safety by promoting rehabilitation and promoting success. So we think it's the right answer for everybody, and we strongly support the amendment. Thank you.
Thank you, Ms. Clace.
Thank you.
Thank you, Chairman Reeves, members of the commission.
The Victims' Rights Advisory Group strongly opposes a post-offense rehabilitation adjustment. The amendment doesn't consider the impact of criminal offenses on victims. The traumatic effects of crime are long-lasting. Criminal conduct, particularly in the case of violent offenses, inflicts significant emotional, physical, and financial harm that extends not just beyond the initial victimization, but well beyond the victim's involvement in the criminal justice process. Victims often endure persistent anxiety, loss of personal safety, and disruption to their daily lives. The harm caused by a criminal defendant does not dissipate because the offender later engages in rehabilitative efforts. Granting a sentence reduction for post-offense rehabilitation creates a fundamental imbalance where victims may not have felt heard, have not been made whole, and continue to experience trauma. Courts may already consider acceptance of responsibility and substantial assistance to authorities. Further reduction is unnecessary. Congress did not intend to reward an offender's personal improvement. Rather, sentencing should reflect the purposes set forth in 18 USC 3553. The proposed amendment undermines the goals of punishment and does not recognize that rehabilitation is already a component of incarceration. And in cases of incarceration or pretrial release, good behavior is already expected. Another reason our group opposes this amendment is that it invites strategic offender behavior. It raises serious questions about whether purported post-offense rehabilitation is genuine or undertaken solely to influence the outcome at sentencing. This is particularly concerning in cases where an offender is facing a lengthy prison sentence. Option 1, subsection C, is especially concerning to the Victims' Rights Advisory Group. In addition to rewarding strategic behavior, it risks penalizing late reports or delayed disclosures, which would harm victims of sexual offenses. The last reason is that the Victims' Rights Advisory Group is concerned that it creates a substantial risk of unwarranted sentencing disparities. Not all defendants have equal access to therapy or treatment programs. Wealthier defendants may be better positioned to appear rehabilitated, more so than an indigent defendant would. And this, again, would directly conflict with the mandate to avoid unwarranted disparities. If this commission adopts the amendment despite VRAG's objections, VRAG does have some input and would ask that sentencing courts be required to consider victims' rights, victim input, and victim objections, that violent offenses such as homicide and sexual offenses are categorically excluded from eligibility, that any offender-initiated contact with a victim is expressly prohibited. We would ask the commission to also adopt clear and narrowly tailored definitions of what constitutes a benefit to a victim, and victim consent should be required in all circumstances. We would also ask that victims not be compelled to participate in rehabilitative efforts that serve an offender's pursuit of a sentence reduction. No victim should be required to receive an apology that they don't want to receive or to engage in a dialogue with an offender. We would ask that if this commission moves forward with this amendment, that it is consistent with the victim's rights under subsection A1 and subsection A8 of the CVRA, which is to, the victims are to be reasonably protected from the accused and to be treated with fairness and with respect for a victim's dignity and privacy. Thank you.
Thank you, Ms. Clace. Questions? Yes, VC Merck.
I have a question for Mr. Clausen. You yourself are someone who demonstrated remarkable rehabilitation, and you've worked with thousands of defendants. I guess I'm interested in hearing your thoughts on the point Ms. Johnson made. Like, to me, there are just cards on the table. I worry about the anchoring effect, and I think that this is a very hard thing to put on paper in a way that is quantifiable. And I think those considerations really give me pause. But this idea of a carrot, of something that could be something people could hold on to and that could be transformative for them, is very appealing to me. And I wonder whether it's something you've seen in practice or what you think based on your experiences.
Thank you for the question. Two parts to this. Ms. Johnson did a masterful job describing the need, the reason why this is so important. And it's not just tribal communities. These are the majority of individuals who come through our criminal justice system. Many of them come from underserved communities where there is limited access. I can say from someone who was granted relief due to extraordinary and compelling reasons. So I heard that term mentioned a couple times previously. My concern, even while I was going through my own legal process, knowing the record that I had spent 20 years to accumulate, was not just extraordinary, it was rare, just incredibly hard to be able to do that because the system is not set up currently to track those achievements, those personal investments. So that shouldn't stop us from creating the opportunity. And that's why my suggestion was that we focus on putting a framework in place and trust judges to have the wisdom to see whether individuals are making true investments in themselves, even at that early stage. And why would we not create an incentive for people to begin that work? And I'm going to be perfectly frank with you that I actively recruited people, as you would into a gang, to be a part of programming, right? And because I wanted to see people transform their lives, and I used whatever incentive I could. I'd tell guys, hey, if you get in this program, you might get a transfer to a better facility. And although they came into those programs for whatever means initially, whatever incentive there was, that was the key to them beginning that path, that journey of personal transformation. Why would we not make that opportunity available, right? Just because it's difficult. So yes, there's some challenges in creating a uniform way to make this easily accessible, but I trust that our judges are in a good position to be able to assess, what an individual is engaged in and whether or not it's genuine.
VC Mate.
Thank you all very much for sticking around to the bitter end. We appreciate it. This is a much more kind of technical question, but several commenters have encouraged us to provide a bunch of examples of what this kind of conduct might look like, that we're talking this post-offense rehabilitative conduct, and also make clear that whatever list we provide isn't exclusive, that it's a list of examples. And then I know at least PAG and the defenders have suggested we put that in commentary as opposed to the guideline, which we almost never hear anymore, put it in commentary. I was curious about TIAG's position on how, if we were doing this list of examples, and SIAG, thoughts on this too. Is that something that's better in a guideline, better in commentary, whether you have any thoughts on that very weedy aspect of it?
I think that we were very against commentary for a while because of concerns about it was Kaiser in the Ninth Circuit. I'm not sure in every circuit. I think that there have been developments in case law that have made it less concerning. I think that TIAG is, we didn't discuss this, right? But I think that knowing what we did talk about, less concerned about would be less concerned with putting this language in the commentary, because it's really just guidance about what post-offense rehabilitation might look like, and not an exhaustive list that is fixed in stone. And we are very concerned about an exhaustive list that is fixed in stone, because, for example, and we provided this example in our letter, Navajo peacemaking, very, very powerful for people from that cultural tradition who engage in it. That's not going to be on the list. And we don't want people who are from different cultural backgrounds, who have different cultural traditions, excluded from these benefits because the guidelines don't account for their own particular cultural tradition. And I imagine there are a lot of other cultures, subcultures in the United States where there could be similar issues. So I don't think that we would object to putting it in the commentary language, because I think it's really just to illustrate for courts the kinds of things that might take that they might need to take into account. And I think at the end of the day, it becomes up to the litigants themselves to explain the relevance in cases where it's not obvious. Some of them are always going to be obvious: drug and alcohol rehabilitation, where there's some sort of niche niche rehabilitation that's particular to their culture, to explain and make that clear to the judges.
I have a couple of questions, I guess for the lawyers first. Some say, the 3553A factors do all the work for anyone, for the judge, for the person who's being sentenced, even from, I guess, probation. If that's the case, why do this? And that's my question. Why do this if 3553A really does do all the work for you?
I'm happy to chime in. I think in part this goes back to Commissioner Wong's point earlier about, could a judge sort of do both? How would the interplay work between 3553A and a new adjustment here? I don't think that it's all that uncommon for judges to do both, to consider things in 3553A that are also in some way taken into account by the guidelines. I think so many of the possible adjustments, whether it's role-based adjustments or obstructive conduct or acceptance, there are all sorts of colors of those things. And I think when it comes to 3553A, judges do holistically consider all of those things. And so you could have some good and bad. You could have some obstructive behavior, and you could have some rehabilitative behavior. And I think it's okay for the guidelines to account for those things, and then for judges ultimately to put it together in a 3553A analysis while still considering some of the same factors of rehabilitation. I'll also say, just to this concern about sort of strategic behavior, that it might incentivize people to do things just sort of solely for the points. That possibility already exists, right? I mean, when I sit down with clients right now to talk to them about what's going to help them at sentencing, one of the things we talk about is what's going to happen between today and sentencing. And I think every lawyer has that discussion right now. And so to the extent that there's some concern about strategic behavior, that's already there. And I just loved what Mr. Clausen said, which is, who cares why they do it, right? If you can get somebody to walk into a program that's going to improve their lives, improve the lives of their families, improve public safety, improve recidivism outcomes generally, who cares why? Whether it's initially maybe a strategic thought or not, we ought to be encouraging it, and to do it in a very concrete way, I think makes a lot of sense.
Yes, I appreciate the 3553A comment. There is a degree to which that argument could be made with respect to almost any adjustment, positive or negative in the entire book. We could make the entire book 20 pages long and just say, 3553A covers it all, including many of the things we're talking about today. Sophisticated means, meth distinctions, 3553A. In terms of why Tig in particular thinks that this is a poor candidate for 3553A, we have that discussion with Native defendants. The guidelines are only advisory. The judge can always give you a downward departure. I think that for people who grow up in tribal communities, you do all the work on the front end and trust me, we'll take care of you on the back end, said by the federal government, is not a persuasive argument for historical reasons. So showing people that there's something written down, that like, here are your guidelines now. And if you do all of these things and you succeed at them, which is hard, it's really hard, even for people who are trying, not everybody's going to succeed. But here's where they could be, is much more effective and much more promoting of success, particularly, I think, for our Native communities.
And Mr. Lurie, it seems like I always wound back to you, and primarily because the judges, at least in my district, rely heavily on the probation office and officers' advice and the pre-sentence report, the pre-sentence investigation. And I'm wondering, through POAG, what do you know about whether or not in preparing the pre-sentence investigation report, probation officers are looking for post-offense efforts and people doing better? We get the information for sure when they've done something wrong, when they've, did something in pretrial, or they got, or I think about the other offenses that might come up, or the other people that they might have been associated with, the things that might be in their home, that these things that ought to count against them. And Judge, you ought to consider this as you're sentencing this person, maybe even varying upward, or maybe going a little bit above what the recommendation might be from the based on the plea agreement or whatever. So how much effort does the probation office take in finding stuff that might plug this area of post-offense rehabilitation, that the judge, you ought to consider this at sentencing, when they come in here?
So great question. And I'll say that probation officers, if you were probably to poll them to get a sense of why they do the work they do, you'd probably get a response that looks like, I love justice and I love rehabilitation. That is such a substantial part of who we are, that when you see rehabilitation occurring in advance of sentencing, we want to foster that. We want that to be a part of what the judge sees. We want to put that on display because it's an important component of what that defendant is experiencing. So often people who are looking at sentencing, they're in that frame of mind ready to change, because they're looking at the result of their conduct, and this is the moment to change. But we're not the only ones who are looking for that. So often, we talked at length about this when looking at this this amendment, and everybody was sharing stories of the times that they've seen individuals receive substantial variances for that post-rehabilitative conduct. And in those, one of the things that struck me about it is how often it's not just us. It's the U.S. Attorney's Office. It's the AFPDs, the judge themselves. The pretrial officer is also getting involved. And you're seeing this trajectory from a variety of sources moving towards that same end, which is this person has done a lot substantially to change their circumstances and to prepare themselves for a life, regardless of the sentence, for a life that's different. And let's do what we can to recognize that. Let's do what we can to help keep that change going. Part of the reason why we talk about the anchoring issue is because when that happens, those variances, and this is from a variety of officers all over the country, those variances are substantial to facilitate that continued growth. That's something that makes a big difference in terms of that person's success, is trying to prevent them from taking steps backwards. It's always something in the forefront of our thought process, and certainly one of the big components about our investigation is looking at how you're doing in substance abuse treatment, how are you doing in mental health treatment, what does your family life look like, what has it been like since, how have you changed, how have you adjusted to meet different obligations that you previously might not have been considering. Those are all things that we try to make sure are incorporated in. And, I think it's one of those things that gives the judge a complete picture of that person. If you were to not include it, it would be a disservice. And I don't think that any of us have gotten into this to ignore rehabilitation. It's what we want, and that's not just the PSI side, that's the post-conviction as well.
Mr. Meisler.
Just to follow up with Mr. Lurie, though, I think this, at least as I understood Judge Reese's question, is kind of an empirical bit of a question too. Are you are PSR drafters including the kind of information you just talked about in the PSR? Is it before judges? And I guess baked into that, to my mind, is are the parties making these arguments in a way that judges are able to give meaningful consideration to post-defense rehabilitation when it's genuine and proven?
I would say absolutely. We work very hard to include that information. We're not the only ones who are presenting it to the court. So often we're also working with the defenders, we're working with the U.S. attorneys to get a sense of what that information looks like and make sure that it's accurately portrayed.
Anything additional? Well, ladies and gentlemen, with that, I would like to bring our hearing on the December 2025 proposed amendments to an end. On behalf of my fellow commissioners, my good friends here, I want to again thank our panelists. I know you all sacrificed in a number of ways to get here, to prepare. You all have done an extraordinary job for us, I believe. Thank you for your service. I also want to thank our staff and of course, all who have decided to listen to us today. And for your testimony, I thank you. We will consider that testimony. Our work continues along with our staff, again, who will do the real work. We'll use this testimony to make our sentencing policy, to make that policy what we believe is right, what is fair, and what is just. One final note about the continuing work that we'll do. We are currently seeking comments on the proposed amendments we published last month, addressing sentencing options, career offender, circuit conflicts, and human smuggling. There's still time left for you to comment if you wish to do so. Please let us hear from you, though, by March 18th, 2026. Our work continues, and I guess your work does too. But with respect to this hearing, Kathleen, it is now adjourned. On time. Thank you all.